The date was given on 25th August, but it is not called on 25th August. On inquiry, it is submitted that it will be called today, but even
Check ಮಾಡ್ರಿ ಯಾಕೆ ಅದು?
Its date is
maybe
allotted today.
posted tomorrow.
Huh?
Its date is allotted today, my lords, covered by
Dates
lords. Date is given today, my lords, and it is not listed.
ಚೆಕ್
my lords.
ಮಾಡಿ ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ. ಅವೆಲ್ಲ.
Connected matter is also listing, my lords.
It was given on Tuesday.
Huh?
It was given on Tuesday, my lord. But the respondent, without informing us, has taken an adjournment, and now it's been posted on 17th of September.
17th September is not too far.
My lord, sir, petitioner happens to be a cancer patient, my lord. We all are seeking is for compensation in this petition.
Yeah, ನೋಡ್ರಿ ತಗೊಳ್ರಿ.
Sir, kindly have it on Monday, my lord.
ಹಾ.
Consent award is not arrived at, pass the fresh award instead of reviving the.
ಅದೇನ್ ನೋಡಿ ತಗೊಳ್ಳಿ. KDB ಮ್ಯಾಟರ್ ಅಲ್ಲ? Correct. Adjournments.
Yes, sir. Adjournments phase wise. Page number 8, serial number 22 and 23. Page number 9, serial number 24 to 30. Page number 10, serial number 31 to 33. Page number 11, serial number 34 to 39.
Serial number
Page number-
36, my lords. And for the petitioners, my lords,
ಹಾ.
short accommodation may be given, my lords. Previously, I
Edita.
sought the time, my lords.
How many times?
Since there is some difficulty, my lords, the senior counsel has been engaged, that there is some.
You've been seeking time before me, mister. How many times? 1, 2,
Previously, on the medical
3,
grounds, I
4.
have sought the time, my lords.
5.
Previously,
5 times it is listed before me.
please, my lords.
I will not adjourn. Yes,
Please
please
kindly-
bring your. 5 times, mister, it is
A
listed
short
before
accommodation.
me.
Short accommodation.
no,
my lords. Once,
sorry.
one last chance, my
No,
lords.
no. 5 sati adjournment ಇನ್ನೆಷ್ಟು ಸತಿ ಕೊಡ್ತಾರೆ?
Since some
No,
difficulty, my lords,
sorry,
senior
sorry,
counsel.
mister, sorry. Yes, next.
Serial number 30 Milos. Serial number 30 Milos, least one.
You remember?
30 Milo, 30.
Ah,
Milos, it's a parted matter, Milos. May I request for next week any date, Milos?
whom do you represent?
Petitioner, my lord.
There are 3 cases. Oh, further hearing ಅಲ್ಲಿ ಎಂತದು? ಯಾವ್ದಲ್ಲಿ? ಇದರಲ್ಲ.
What has happened, my lord?
What is this regarding?
40%, 50%.
Okay.
Otherly,
Police.
the memo is filed because what's happened is the Honorable Supreme Court, my lord, which the division bench which is pending now, and they said that we'll await the decision of the Honorable Supreme Court. So the Supreme Court, my lord, they had directed the VDA to file an affidavit there, and that they have listed it on 8th of September, so it could be taken up.
Learn
Similar
cause.
point, my lord, what your lordships have said in the division bench, my lord, headed by Justice Oak, my lord, had said that similar order saying that you will have to pay under the 2013 Act. Very, I mean, on same set of facts. That, my lord, is pending for the Honorable Supreme Court. So that probably.
But this was something else,
Something
isn't
else,
it?
Milos. Please, my lord.
You know, utilization of land.
Without
Without
acquisition.
acquisition, utilization for the formation of road. So there are number of all these judgments. So this, the division bench where, my lord, it was similar case, there they said that you'll have to.
So I'll take it up later.
Yes, sir. After that, and he
Learn
was,
concept
he was seeking for time for a week today.
So you also want time or?
Yes, sir. After 8.
Learn counsel for the petitioner and the learn senior counsel for the respondent submits that similar issues are pending before.
Similar issues are not pending, my lord. It was argued several times. My lord has already
So
gone.
what he is saying that
Okay.
the learn counsel for the petitioner, Varda Kama, learn counsel for the petitioner seeks time. The learn senior counsel for the respondent submits that issues which are similar to the one raised in this writ petition are pending before the Honorable Supreme Court. And that the Bangalore Development Authority is directed to file an affidavit. And that the case is listed on 8th September. Full stop. We therefore prays that this petition be taken up after 8 September. In that view of the matter, list on the author on date. Could.
That should not be,
Then can I release it? Let it go before.
it was heard at length, my lords.
List on yath on date could. Navat no. Yes, next.
15th September.
My lords, this observation should not be that.
Mr. What observation have I made? Don't become, don't make a,
Recording of the statement, it should not affect into observation.
In fact, Lord, the division bench in a
when you are
similar
making
manner
a
has said
submission,
after
when you are
order.
making a submission, you should be conscious about what you are making. What submission you are making. You should be conscious. You cannot simply make a submission just because you have to utter something. What does anything turn on whatever submission that he made? The lawyer should be very ಯೋಚನೆ ಮಾಡ್ಬೇಕಪ್ಪ. ತಲೆ ಕೊಟ್ಟರೆ ಬರೀ ಬ್ಯಾಲೆನ್ಸ್ ಸಿಗಲ್ಲ. You should also use it. Just don't make a submission for the heck of doing it. Yes.
Good.
Page number 10, serial number 31 to 33, page number 11, serial number 34 to 39, page number 12, serial number 40 to 47, page number 13, serial number 48 to 54, page number 14, serial number 55 to 57.
ಹೇಳಿ. Serial number 30.
13.
That is in the orders list. Please wait. Correct.
List number 1 for non-compliance first time, serial number 1, Uday KS.
Case Uday.
But the office objection is that,
Huh?
office objection is that issuing authority signature is.
Office exam season is not. Yes, particularly office objection still number 1 is overruled. ಏನಿದು ವಸಂತ? What is this?
Passing of general award and seeking direction to allot alternate developed land.
Huh? Can allow this? ಮಾಡ್ಬೋದಲ್ಲ? AG ಏನಾ HCGP ನಾ? Who will take notice? Seal number 1. AG is directed to accept notice for R1. Mr. Vasanta for respond number 2 and 3. A general award, quashing the general award and passing a consent award. Yes, next, allowed. Yes, next.
Serial number 2,
SP
Lakshmama.
This case for the petition, the office objection, item number, office objection 2 is, my lord, in the cause list, the designation.
Respondent made party by name to be clarified. Who is respondent?
Their names have been shown, my lord. Why, my lord? In page number 154 to 160, there was a committee board meeting, my lord. In the said board meeting, the petitioner as well as all the respondents were personally present, my lord. Because of that reason, I have shown them, my lord.
No, but
That is
why
all
do-
the reason, my lord.
Why can you show them as parties, madam?
I'll delete
By
it.
their name. Don't, please delete it.
Please. I'll
Unless
delete
you
it.
make allegation against them, you
No,
can't
no,
array them.
no allegation, my
Then
lord.
why do you make?
Because they are very much present in the board meeting, my lord. I'll delete it, my lord. My lord, the matter is urgent, my lord.
ನೀವು
So
delete ಮಾಡಿ first.
I'll do it today itself, my lord.
Pass over ಮಾಡ್ಬೇಕಾ?
Ah.
Pass over. ಶಿವಶಂಕರ
Orders
YD.
matter, serial number 3, Shiv Shankar YD.
YD ಶಿವಶಂಕರ್.
Serial number 3, YD Shiv Shankar.
ಹೇಳಿ ಬಸವ ಏನಿದು? What is this? What does this relate to? ಏನು? Dismiss for non-prosecution. Ready na? You're ready? There's no representation for the petitioner. The cost of rupees 2,000 is not paid. Hence the petition is again dismissed for non-prosecution.
Serial number 4, Serates Gowda. Serial number 4.
A memo for retirement is filed by the counsel for respondent number 3.
Sadhu,
They are Nitin R.
that respondent number 3, my lord, he was the whistleblower. Your lordship called upon to be present today or ಯಾರು ಅಂತ ನೋಡೋಣ ಅಂತ. ಅದಕ್ಕೆ ಅದು.
ಅದೇನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಕೊಟ್ರ?
ಅಲ್ಲಿ ಫೈಲ್ ಇಲ್ಲ ಅಂತಾರೆ. ಹೋಗಿ ಸಾಕಾಯ್ತು ಸುಮಾರು ಸಾರಿ.
ಆಯ್ತು ಮೇಡಮ್, ಇನ್ನೊಂದು ಫೈಲ್ ರೆಡಿ ಮಾಡಿ ಫೈಲ್ ಮಾಡಿ. They are willing to reconvey. the memo for retirement filed by the council for respondent number 3 is rejected, would be considered later, yes.
Lords, ಇದು ತಾವು
On ಯಾವ್ದು ಬೇಕು?
substantially your lordship has already ಅದೊಂದ್ಸತಿ parted ಅಂತಾನು ಹೇಳಿದ್ರೆ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿಲ್ಲ. ಪಾರ್ಟ್ಲಿ ಹೆರ್ಡ್ ಅಂತ ಬರ್ತಿದೆ 10/7/2026.
ಯಾವತ್ತು?
10/7/2026.
10/7. That is where list is petition, ಎಲ್ಲಿದೆ ಪಾರ್ಟ್ ಅಂತ?
ನಮ್ಗೆ ನೆಟ್ ಸ್ಟೇಟಸ್ ನಲ್ಲಿ ಪಾರ್ಟ್ಲಿ ಹೆರ್ಡ್ ಅಂತ ಬರ್ತಿದೆ.
ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
10/7/2026 ಆನ್ಲೈನ್ ಇದರಲ್ಲಿ ಪಾರ್ಟ್ಲಿ ಹೆರ್ಡ್ ಹೇಳಿದ್ರಿ, ಅದು ಆನ್ಲೈನ್
ಈ ತರ ಬರ್ದಿಲ್ಲ ಇದು.
ಬಟ್ ತಾವು ಹೇಳಿದ್ರಿ ಅವತ್ತು.
ಬರ್ಕೊಳ್ಳಿ. This court in terms of the order dated 10/7/2026 directed felt that the petitioners should give up one of the sites allotted to them by the BDA. The learned counsel for the petitioner submits that the petitioner has already indicated her willingness to give up a site allotted to her by the BDA, and that the BDA is yet to respond. Full stop. In view of the aforesaid, list this petition for further hearing on so and so date. Yes. Date for that.
3rd September. Serial number 5. Rakshit KN.
Court notice issued to petitioner is answered with Rakshit KN. The notice issued by the court to the petitioner is returned unserved, as no such person was found to be in the address. Full stop. In view of the above, the petition is dismissed for non-prosecution.
Serial number 6. Muralidhar HM.
I'm for the petition.
Yeah, affidavit filed by advocate. What is this affidavit?
Previous date ali there was a direction by this honorable court
Available to revenue officer.
that revenue officer has to be present.
This court. Who is this officer?
ಅದು 6/1
Revenue officer BDA.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ. 6/1 ಬಂದಿದ್ರು ಲಾಸ್ಟ್ ಡೇಟ್ ಅಂದ್ರೆ
It
ಅವತ್ತು ಲಿಸ್ಟ್
appears
ಆಗಿರ್ಲಿಲ್ಲ.
that available warrant issued available. It appears that pursuant to the order dated 23/7/2026, the bailable warrant is not issued. Hence, issue bailable warrant to the revenue officer BDA, North Division, Bengaluru, for a sum of ₹25,000, requiring his appearance before the court on 3rd September. ಆಗುತ್ತಾ? ಅಲ್ಲ, 3rd September 2026 ಆಗುತ್ತಾ ಅಷ್ಟೊಳಗೆ? To comply the order dated 22/1/2025. Yes. List on 3rd September.
3rd September.
Please.
Serial number 7. VR Vishwanath.
ಏನು affidavit ಇದು?
International.
This matter is relating to the stray sites. My lords are directed to prepare a list of stray sites. The BDA, my lords. List is ready, my lords. Please.
The learned counsel for the respondent in WP number 5524 of 2026 has filed a memo and has enclosed therewith a list of stray sites. This is for that wrestler, bodybuilder.
In this case, what had happened in my case, the second case, 7.1, my lords, there was a resolution, 2018, there was a resolution passed to give site in the Nada Prabhu Kempegoda layout, my lords. That has not been implemented, my lords. And also, I have division bench of this honorable court. I request my lords to look at annexure M is the resolution passed, my lords.
Annexure M.
Annexure M only.
Next quarter 7.1 could. Annexure M.
Annexure M, ink page number 29, my lords. In the second para, my lord, ಹೀಗಾಗಿ ನಾನು ತಮ್ಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ರಾಷ್ಟ್ರೀಯ ಮತ್ತು ಅಂತಾರಾಷ್ಟ್ರೀಯ ಕ್ರೀಡಾ ಪ್ರಶಸ್ತಿಗೆ ಭಾಜನರಾಗಿದ್ದರಿಂದ ಬಿ ವರ್ಗದಲ್ಲಿ 12 12 ವಿಸ್ತೀರ್ಣದ
Why
ಬಿಡಿ
this
ನಿವೇಶ-
site cannot be given to him?
That's
The
because there are-
resolution was passed, my lords. Subsequently, the matter has been to give consent by the commissioner. It was forwarded, my lord. Subsequently, my site was not allotted, my lords.
Why it is not allowed?
Let's see, the application is not applied through the regular course, my lords, because my lord, we will announce the applications, my lords, to give the stray sites. During that course, it was not applied. And in the same manner, my lord, there are other 200 persons who have applied for the seeking for the stray sites in the different quotas, my lords.
Yeah,
So,
stray sites, but you have allotted some site in Nadaprabhu Kempegowda.
so we did not allot, my lords. There was a recommendation, allotment, the suggestion was put up before the
Resolution
commissioner.
was passed.
Resolution was passed. And upon that, we came to the conclusion that, my lords, he has not applied in this regular course. So there was an endorsement, my lords may see annexure, page number 28, my lords.
28.
28, page 28.
Taking quashing of the.
Please wait, let him. Madhya matadbadi.
I'm sorry.
Don't irritate the court.
Let's ಬಿಡಿ ನಿವೇಶನಗಳ ಹಂಚಿಕೆಯ ವಿಷಯ ಸಂಬಂಧ ದಿನಾಂಕ ರಂದು ಜರುಗಿದ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 24-23ರಲ್ಲಿ ಕೈಗೊಂಡ ನಿರ್ಣಯದ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆಯಲ್ಲಿ
ಎಲ್ಲೋತ page 28 annexure M.
annexure page 28 annexure L, my lords.
L.
Annexure L. Let's got it, my lords. ಬಿಡಿ ನಿವೇಶನಗಳ ಹಂಚಿಕೆಯ ವಿಷಯ ಸಂಬಂಧ ದಿನಾಂಕ 27/2/2023ರಂದು ಜರುಗಿದ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 24-23ರಲ್ಲಿ ಕೈಗೊಂಡ ನಿರ್ಣಯವಾದ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆಯಲ್ಲಿ ನಿವೇಶನಗಳು ಗುರುತಿಸಿ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನಿವೇಶನ ಹಂಚಿಕೆ ನಿಯಮಗಳ 1984ರ ನಿಯಮ 5ರ ಅನ್ವಯ ಕ್ರಮ ವಹಿಸಬೇಕಿತ್ತು. ಆದ್ದರಿಂದ ಬಿಡಿ ನಿವೇಶನ ಹಂಚಿಕೆಗಾಗಿ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ನೀವು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಬಹುದಾಗಿ ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
ಆಯ್ತು, ಯಾವಾಗ ನೀವು ಇದು ಸ್ಟೇ ಸೈಟ್ಸ್ ಯಾವಾಗ ಮಾಡಿದಿರಿ? ಯಾವಾಗ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದಿರಾ?
We'll issue the notifications, my lords.
ಯಾವಾಗ?
It's that I should seek instructions, my lords. Periodically, my lords, we used to issue the notifications, my lord, and we used to allot the sites whenever we receive the applications for that, my lords.
So please tell us.
Please, my lords.
Tell the court, when was the last time BDA issued a notification proposing to allot stray sites? When was the last notification?
ಏನಾಗ್ತಿತ್ತು ಅಂದ್ರೆ usually stray sites ಯಾವಾಗ ಇರ್ತಿತ್ತು, we used to auction, my lords.
No, how can you?
Please, my lords, that was what the
Stray sites also have to be allotted.
Please, as per the rules, my lords, we should have
allotment of stray sites.
Please, my lords, as per the rules, we should have.
When was the last notification that you issued calling for applications for allotment of stray sites? Have you ever issued a notification?
Secure instructions with regard to that, my lords.
If you have ever issued a notification, it looks like stray sites are something that you are trying to exploit. Maybe your officers are trying to exploit.
Now the list is ready, my lords. My lords may see there are about 1,000 sites which are available in the hands of the BDA. We should follow the rules now, my lords.
Fair enough, you follow the rules, prepare a list of seniority, allot the sites to those people who are entitled to.
Please, my lords.
Here is an international what you call
bodybuilding. Please, my lords.
Athlete of international repute who has to be given a stray site or some allotment.
Because they should apply in the regular course, my lords, because there are other 200 to 250 applications which are received in the same manner.
G category site has to be allotted to a person of this stature. Intavaru kodbeku G category site.
Alla ide category alle sports, music, culture.
Sports alli kodbekalla ivrige. Nadaprabhu Kempegowda alli itara enu
based on the seniority list, based on the basis of attempt also, my lords, we will allot the sites.
Correct. You please, why don't you keep it transparent? ಯಾರು ಎಷ್ಟು ಜನ ಇವರು ಎಷ್ಟು ವರ್ಷ ಕಾಯಬೇಕು ಅಂತ ಒಂದು ಹೇಳಿ ಅವ್ರಿಗೆ. ನಿಮ್ಮ ಮೇಲೆ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? These people, so many people are above you. Why don't you intimate him?
Please.
You're just giving him some theories, illide, that is there, this is their seniority. You give him a what you call timeline within which he will allot a site, or you tell him that this is the process. ಏನೋ ಒಂದು ಹೇಳ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. You don't tell him, just keep him in the dark. It doesn't make any sense.
Let's grant me a time, my lords. I'll secure instructions and I'll place it before the court that how we are going to auction.
No, if there are so many stray sites, if you are not issued any notification, then we'll ask you to allot one site. ಯಾವ್ದಾರ one site ನೀವೇ ಹೇಳಿ ಯಾವ್ದು ಕೊಡ್ತೀರಾ ಅಂತ.
Just because there may be other senior persons who have applied before him.
Please point out
2017.
That I should see.
Whether this man appears in that seniority list.
Please, my lords. I should secure that instruction with regards to my lords. Where he appears. Tomorrow, my lords. next week, Monday, my lords.
Next week ಇಲ್ಲ Saturday ಹೇಳಿ. Saturday.
ಸ್ವಲ್ಪ time, next week, next week, my lord, I will check with the instructions.
And
Seniority list
council
and
for the
sort out.
Learned Council for the PDA has filed a memo and enclosed therewith a list of stray sites. The same is taken on record. Copy ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ?
ಕೊಟ್ಟಿದ್ದಾರೆ. Annexure N, your lordship kindly look at.
Copy of this
Division bench
memo,
of this honorable
copy
court.
of this memo and documents are furnished to the Learned Council for the petitioner. We'll stop till the next date of hearing. The respondent authority is directed not to allot or auction any stray site shown in the memo along with the documents. Don't auction or sell,
please,
or allot. List on date code.
Let's place it on Monday, my lords.
The Learned Council for the respondent authority shall place on record as to when the last notification was issued calling for applications for allotment of stray sites.
Can I request for this, my
And
lords? My lords
the
may
list
have it on
of
Saturday.
seniority, the list of seniority, if any, prepared by the authority concerning allotment of sites to persons who excelled in sports and
Other categories. Specified in the rules, my lords.
List on yavat?
Let's may have it on Saturday, my lords.
Saturday, yes.
My lords, can I request for this, my lords? There be not then stay of auction.
Don't sell anything. Now that you have told the court, please don't sell, don't auction.
If some sites which are already published, which are going to be.
In 2 days, you are not going to do anything.
I don't know, my lords, whether there is any auction that is going on or not.
Within 2 days, don't do anything.
My lords may have it on Saturday.
Yes, Saturday.
Please,
Division bench of this honorable court has considered the case of the similarly situated case, my lord, allotted the site, my lord.
It is right. You might get a better site than the site in Nadaprabhu Kempegowda layout. Who knows? You might get a better site. You will see the kind of sites which are treated as stray sites. Yes, Sarvana, yes.
Please, please.
Number 8, Sarvana, yes.
This case also suggested a site number 101 as an alternative land. But what we have learnt is that site is already registered in favor of some third person. So that site will not go.
But my instruction, Nadaprabhu Kempegowda layout. We will provide in Nadaprabhu Kempegowda.
ಇದೆಲ್ಲಿ 101 is
ನಾಗರಬಾವಿಯಲ್ಲಿ 2007 ನಲ್ಲಿ we have paid 40 lakhs 2007 ನಲ್ಲಿ ಈಗ
auction ಇದು
auction ಅಲ್ಲಿ ನಾವು ತಗೊಂಡಿರೋದು.
Then you cancel that site and give it. He has purchased it in an auction.
The alternate sites in Nagarbavi not available, my lord.
ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಯಾರು ಕೊಟ್ಟಿದ್ರು ಅವರು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇವ್ರು ಕೊಡಿ ಅದನ್ನ.
ಅವು ಮನೆ ಕಟ್ಟಿಬಿಟ್ಟಿದ್ದಾರೆ 90A. Otherwise ಮನೆ ಕಟ್ಟದೇ ಇದ್ದಿದ್ರೆ
What do you want?
I will take instructions 20 ವರ್ಷ
ಆಯ್ತು, if there are any sites available in this layout, you
ಅವರೇ ಏನಾದರೂ ಅಕಸ್ಮಾತ್ if there is any possibility we will see that.
Sir, ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲದ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ?
Yes, sometimes I am not saying that ರಿಜಿಸ್ಟರ್ ಎಲ್ಲ ಚೆಕ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ
ಅಲ್ಲ, ಯಾರನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ಅವ್ರು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ತಾರೆ.
DS ಒಂದು ಮಾಡಿದ್ದಾರೆ. His party met with the deputy secretary along with nodal officer. They have discussed with reference to it. ಅವ್ರು ನಾಡಪ್ರಭು ರೆಫರ್ ಮಾಡಿದ್ರೆ ನಾಡಪ್ರಭು ಬೇಡ ಅಂತ ಅಂದ್ರು, ಅಷ್ಟೇ ಅಲ್ಲಿಗೆ ನಿಂತಿದೆ.
ಕರೆಕ್ಟ್. ಡೆಪ್ಟಿ ಸೆಕ್ರೆಟರಿಗೆ ಏನ್ ಗೊತ್ತಿರುತ್ತೆ?
He is the one, he is in charge of this allotment section head ಅವರು ಡೆಪ್ಯೂಟಿ ಸೆಕ್ರೆಟರಿ.
ಕರೆಕ್ಟ್. ಇವಾಗ ಎಷ್ಟು ಸೈಟ್ ಮಾಡಿದ್ರ ಅಂತ ಹೇಳಿ, ಲೇಔಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಸೈಟ್ ಮಾಡಿದ್ರ, ಎಷ್ಟು ಸೈಟ್ ಅಲಾಟ್ ಮಾಡಿದಿರಾ?
2006 ಲೇಔಟ್ ಅದು ಹಳೇದು.
2006 ಆಗ್ಲಿ, you will have a record how many sites you have formed, you will have a record how many sites you allotted.
ಅದೇ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ನೋಡಿ 3 ಸೈಟ್ಸ್ ತೋರಿಸಿದ್ವಿ ಸ್ವಾಮಿ. 36 90 ಇದು 36 76 ಅಂತ ಕಾಣಿದೆ, ಇನ್ನೊಂದು 101. ಅದು ಎರಡರಲ್ಲಿ ಡೈಮೆನ್ಷನ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇತ್ತು, ಅದಕ್ಕೆ 101 ಮಾಡಿ 101 ನೋಡಿದ್ರೆ ರಿಜಿಸ್ಟರ್ ಆಗೋಗಿದೆ.
ಆಯ್ತು, ಇನ್ನು 31 36 ಏನು ಅಂದ್ರಲ್ಲ,
ಅದನ್ನ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಡೈಮೆನ್ಷನ್
ಸತಿ ಕೇಳಿ ನೋಡ್ತೀನಿ. Just put a word, but they should compensate means whatever.
Similar area, similar size plots you have to give, whether it is one site or two sites.
ಈ 11A ದಲ್ಲಿ ಸಪೋಸ್ ಇಲ್ಲಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ subsequently formed layout ಅಂತ.
I think it's an auction, sir. It is not a allotment, it's an auction. It is an auction, so therefore you have to ಆ ಲೇಔಟ್ ಅಲ್ಲಿ ಇರುವಂತ ಏನು ನೀವು ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರೆ ಇವತ್ತಿನ ಮಾರ್ಕೆಟ್ ರೇಟ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ. ಬಿಕಾಸ್ ಯು ರಿಸೀವ್ಡ್ ದ ಎಂಟೈರ್ ಕನ್ಸಿಡರೇಷನ್, ಸೊ ಟುಡೇಸ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಪೇ.
ಅಲ್ಲ, ತತ್ಸಮಾನವಾಗಿ ಬೇರೆ ಯಾವ ಲೇಔಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ ಅಷ್ಟೇ.
ಸಮಾನ ಹೆಂಗಾಗುತ್ತೆ?
ಆಗುತ್ತೆ. ಇವಾಗ ಸಪೋಸ್ ಫಾರ್ ಸರ್ ಎಂ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಲೇಔಟ್ ಅಲ್ಲೋ ಅಕಸ್ಮಾತ್ ಇದೆ, ಅವರು ಅಂಜನಾಪುರ ಅಂದ್ರು, ಅಂಜನಾಪುರದಲ್ಲಿ ಸಪೋಸ್ ಇಫ್ ದೇ ಆರ್ ಅವೈಲಬಲ್ ಮಿಲರ್ಸ್ If he agrees, ನಮಗೂ ಡಿಫಿಕಲ್ಟಿ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
ಕೊಡಿ ಯಾವ್ದಾದ್ರು, ಇಲ್ಲ ಕಮರ್ಷಿಯಲ್ ಸೈಟ್ ಕೊಡಿ ಯಾವ್ದಾದ್ರು ಲೇಔಟ್.
ಕಮರ್ಷಿಯಲ್
ಮತ್ತೆ ಎಷ್ಟು ಸೈಟ್, ವಾಟ್ ಇಸ್ ಡೈಮೆನ್ಷನ್ ದಟ್
30-40.
30-40
ಎರಡು ತಗೊಂಡಿದ್ವಿ, ಒಂದು ಈಗ ಏನೋ ಸರಿ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ, ಒಂದು ಅವೈಲಬಲ್ ಇದೆ, ಬೇರೆ 2, 3, 4 ಸೈಟ್ಸ್ ಅವೈಲಬಲ್ ಇದೆ. ಒಂದು ಮಾತ್ರ ಸಮಸ್ಯೆ.
4 ಸೈಟ್ಗೂ ತೊಂದರೆ ಆಗಿತ್ತು. ಈಗ ಬೌಂಡ್ರಿ ಸರಿ ಮಾಡಿ ಒಂದು ಸೈಟ್ ನಮಗೆ ತೊಂದರೆ ಆಗಿದೆ.
ಆಯ್ತು, ವೈ ಡೋಂಟ್ ಯು ಎಕ್ಸ್ಪ್ಲೋರ್ ಟೇಕಿಂಗ್ ದಟ್ 30, 33 ಅಂದ್ರಲ್ಲ.
ಅದು ಕೇಳಿ ನೋಡ್ತೀನಿ.
ಇನ್ನೊಂದು ಯಾವ್ದು ಇದೆ ಅಂತ ಹೇಳಿದೆ, 2 ಸೈಟ್.
31 ಯಾವ್ದು?
13. ನಾನು ಅದನ್ನ ಐ ವಿಲ್ ನೋಡಲ್ ಆಫೀಸರ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿಸ್ತೀನಿ ಅವ್ರಿಗೆ. ಅವರೇ ತೋರಿಸಿರೋದು ಫಸ್ಟ್ ಅದನ್ನ ಎರಡನ್ನೂ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ರು. ಡೈಮೆನ್ಷನ್ಸ್ ಕಡಿಮೆ ಇತ್ತು, ಆಗಿಲ್ಲ.
ಡೈಮೆನ್ಷನ್ ಕಡಿಮೆ ಇದೆ, ಯಾವ್ದು ದೊಡ್ಡದಿದೆ ಅದು
if they are agreeing ಅದನ್ನೇ.
Let's may have this matter next week, sir. We just will try to explore. ಆ ಸೈಟ್ ನಂಬರ್ ಹೇಳ್ಬಿಡ್ಲಿ ಅವರು, ಅದನ್ನ ನೋಡ್ತೀವಿ.
Memo regarding submission report is filed.
20 ಗೊತ್ತಿದೆ.
The memo submitted by the learned counsel for the respondent is noted.
The haleetso.
Is 90/A, 90/B.
ಹೌದು.
2 memos were filed in the earlier writ petition.
2 ಸೈಟ್ ತಗೊಂಡಿದ್ವಿ, ಸೇಮ್ ಪಿಟಿಷನರ್.
2 ಸೈಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಇಲ್ಲ, ಒಂದಕ್ಕೆ ಸಮಸ್ಯೆ ಆಗಿರೋದು. ನನಗೆ ಇಲ್ಲ,
90A ಸಮಸ್ಯೆ ಆಗಿದೆ.
90A ಸಮಸ್ಯೆ ಆಗಿದೆ. 90B, 90C ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಅವ್ರಿಗೆಲ್ಲ
ಉಳಿದವರಿಗೆಲ್ಲ ಕರೆಕ್ಟ್.
ಮತ್ತೆ ಈ ಮೆಮೊ ಕೊಟ್ಟರೆ ಏನು ಈ ತರ ಇದು ಕ್ಲಿಯರ್ಲಿ ಫೌಂಡಬಲ್
ಅಂತ ಸೈಟ್ಸ್ ಅವೈಲಬಲ್ ಇದೆ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ರು ಆಗ. ಇವಾಗ ಲ್ಯಾಟರ್ ಸ್ಟೇಷನ್ ಸರ್ವೆ ಎಲ್ಲ ಮಾಡಿ ನೋಡುವಾಗ 90 ಸೈಟ್ ನ 90A ಮಾಡಿ ಅಂತ ಕೊಟ್ಟಿರೋದು. 90 ಅವ್ರು ಮನೆ ಕಟ್ಟಿಬಿಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ. ಸೊ ದೇರ್ ಇಸ್ ಡಿಫಿಕಲ್ಟ್.
The same is perused. The learned counsel for the petitioner seeks time to consider the offer made by the learned counsel for the respondent regarding allotment of site number 30.
31.
Not 13 minutes.
ಏನು ಅಂದ್ರಲ್ಲ ಇವಾಗ.
The last time.
ಇದು 90/C ಅಂತ ಬೇರೆ
ಅದು ಇನ್ನೊಂದು
ಅದ್ರ ಸಮಸ್ಯೆ ಇಲ್ಲ.
So totally about 3 sites.
No, the other petition. ನಾನು 2 ಸೈಟ್ 90A, 90B in the first
37 and 60 minutes.
37 and 60.
Second stage, second block, Nagarbavi.
Second stage, second block, Nagarbavi layout. List on date.
Monday 2 sims. Monday
date you want. Whatever date.
Monday malot sir. ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬಿಟ್ಟು ಅಷ್ಟೇ.
Yes, next Monday ಆಗಲ್ಲ.
Tuesday Wednesday.
Third.
Serial number 9, Cyril Prasad Payas.
I'll take steps, my lord, so far as R3 is concerned. I've secured a new address, my lord. During the course of the day, I'll take steps.
Revalidation of DD check for 5,000.
My lord, this petition was dismissed for non-prosecution. They restored, my lord, the payment of 5,000 rupees demand draft. I have paid, my lord, on 28/2/2024. It's already been paid.
So please, they are not encashed.
They are not encashed, I believe.
The demand draft for rupees 5,000 deposited by the learned counsel for the petitioner is not encashed. Hence, the learned counsel for the petitioner is directed to receive back the demand draft and submit a fresh demand draft. Full stop. Learned counsel for the petitioner undertakes to take steps for
R3, my lord.
R3. Fresh steps for R3. Yes, list on zones.
10 September. Serial number 10, Raj Gopal Naidu.
Pray for time, sir. Verify ಮಾಡಿ. Complaints ಇದೆ, 3 complaints.
First file this IA for amendment.
ಅದು ಪ್ರೀವಿಯಸ್ ನಮ್ಮ ಕೊಲೀಗ್ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರು ಏನು ಇಂಟಿಮೇಷನ್ ಮಾಡಿಲ್ಲ.
ಸ್ವಲ್ಪ ಏನು
ವೆರಿಫೈ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಇದರಲ್ಲಿ ಇದು ಮಾಡಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನೇ ಇದ್ರೆ ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಸರ್.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಸ್ವಲ್ಪ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾರು ಹಾಕಿರೋದು?
ನಾವೇ ಹಾಕಿರೋದು.
ನೀವೇ ಹಾಕಿದ್ಮೇಲೆ ನಿಮ್ಗೆ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ವಾ?
ಇದ್ರಲ್ಲ ಫೈಲ್ ಸರಿಯಾಗಿ ಇದ್ದಾಗಿಲ್ಲ ಸರ್. ಫೈಲಲ್ಲಿ ಇದ್ದಾಗಿಲ್ಲ, ಕೊಲೀಗ್ ಅವರು ಸರಿಯಾಗಿ ಇದು ಮಾಡಿಲ್ಲ ಫೈಲ್.
So how can you seek for such an amendment?
File ಅಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ ಅದು ಕಾಪಿ ಲಾಸ್ಟ್
So it looks like you are indulging in making money from your members. ಯಾರು ದುಡ್ಡು ಕೊಟ್ಟರು ಅವ್ರದ್ದು ಮಾತ್ರ ಹೆಸರು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ.
ಹೌದು.
Then we'll dismiss the petition, let all those people come. We'll consider their case when they come to the court.
Kindly pass out.
If you are representing a section of people, you should pursue the petition for all benefit, the benefit of all the members. You cannot say you please allot the sites only to those members whose names are found in the list. Who are you to say that?
Kindly pass out, senior.
Pass over here.
My lord, kind permission, serial number 6. Honorable court imposed the cost of the rupees 25,000. They're already paid, my lord.
Yadu?
I did not have the information. Serial number
Please,
6, serial number 6, my lord.
Ah,
They already paid the cost, my lord.
who has to pay?
5-8, Anil Kumar has paid the cost, my lord.
Which
Officer
respondent?
of the PDA, respondent. I'm sorry, my lord. I'm apologized, my lord.
ಕೇಸ್ ಕರೆದಾಗ ಬರೋದಿಲ್ಲ, ಮಧ್ಯದಲ್ಲಿ ತೂರ್ಕೊಂಡು ಹೇಳ್ತೀರಾ ನೀವು.
No,
You
my
can't
lord.
wait.
I was present, but I did not have the information.
ಕೊಡಿ ಅದೇನೋ. No, we have not asked you to deposit 25,000 rupees.
Deposited, my lord. They sent the receipt just now.
Who has to deposit?
Anil Kumar, who is the officer,
Madam, we
imposed
have
the
not
cost
asked
to
you
him.
to deposit. Why did you deposit? We issued a bailable warrant. And there should be a condition in case if you don't appear, then you will be bound to pay 25,000. ಆ ಥರ ಇರೋದು. Who asked you to deposit? Next career.
Serial number 11, Nagaraj D. Serial number 11. Armed furnishing of original.
There is no representation for the petitioner. No representation, there is no representation for the petitioner. The order dated 8/1/2024 is not complied. Hence list on date code.
11 September.
Shivani Shetty.
Serial number 12, Shivani Shetty.
For the petitioner, Your Lordship. Your Lordship, this is a matter where an unauthorized layout has been formed, Your Lordship, and divided into further individual sites without obtaining plan sanction under section 17 of KTCP Act. Your Lordship, in this regard, Your Lordship may kindly refer to page 52 of my petition, Annexure A. Demolition order, Your Lordship, has already been issued by the R2, which is the BDA. Even after issuance of the demolition order, Your Lordship, rampant construction activities are ongoing. I am, Your Lordship, the neighboring residents. And Your Lordship may see that the demolition order is issued on 2/7/2025. Even after issuance of demolition order, Your Lordship, somehow they have been able to procure khata and building licenses in violation of the regulations dated 17/3/2023, Your Lordship, which I have attached as Annexure C. And also, Your Lordship, in violation of building bylaws, or BBMP building bylaws, Rule 7.1, Note 2. Now, Your Lordship, even after the demolition order, they have obtained khata, they have obtained building construction permissions, and they are ongoing with the activities.
Order of demolition.
Order of demolition is Annexure A, Your Lordship. Page 52. More than a year back, Your Lordship, this order was passed. Now, Your Lordship.
Khata made out.
Your Lordship.
When was the khata made out?
Your Lordship, even prior to the order of demolition and even subsequent, they have been regularly obtaining the multiple site owners now.
So what all has happened after this demolition orders?
Your Lordship, multiple new sanctions have been given.
Where are they?
Your Lordship will see there are sale deeds, Your Lordship, at page 53 to 84, and khata certificates at Annexure D Collie from 88 to 96.
Mr. They are all prior to the demolition order. I hope you understand.
Your Lordship.
What all favorable orders are passed by the BDA after the demolition order is passed?
Your Lordship, even now, as far as the khatas given prior to the demolition order is concerned, Your Lordship, my apprehension.
You said after the demolition, they have done A, B, C, D, E. What are those A, B, C, D, E is the question put to you.
Your Lordship, some khata sanctions have been issued, khata certificates. Even after the demolition order, Your Lordship, I will produce that.
Where do you get it?
Your Lordship, I'll produce the subsequent, or the Khata certificate issued subsequently.
Where are they?
Your Lordship, my concern, my limited prayer today, Your Lordship, is that as far as those Khata certificates issued prior to the demolition order is concerned, they are going ahead with the construction activities and they are creating third-party interest. My only relief, Your Lordship, today is that as far as those sites are concerned, there may be a stay order with respect to the construction activities that are going on, since the demolition order is already passed.
Sir, BDA gets-
My lord.
What
My lord,
action you have taken to stop the construction?
My lord, the notice was issued on 2/7/25, my lord. By virtue of the government order dated 10/10/2025, the area vested with the GBA, my lord.
Yeah, GBA garu. What action have you taken? What action have you taken? What action will you take? Whether this demolition order is challenged anywhere? Yes, Mr. Shivani.
Your Lordship, they have, if I'm not wrong, they have, the respondent number 10, they have filed a suit before the KR Puram court and obtained an ad interim order of injunction from dispossessing them. Your Lordship, but my submission would be a disposition, an ad interim order of injunction by KR Puram court with respect to not dispossessing them will not come in the way, Your Lordship, of granting a stay on the construction activities that are going on. Because, Your Lordship, our apprehension is,
What did I ask?
Your Lordship, they've approached only seeking stay with regard to disposition, that's all.
Have they challenged the order of demolition?
No, they have not challenged the order of demolition.
Okay.
My lord, there is no specific prayer against me.
Hmm?
There is no specific prayer against me, my lord, in this petition.
I too, now that you are coming to the scene later, you please take action.
I'll see to sir, I'll take.
Yavaga. When do you want me to list it?
For a week, my lord.
Stop the construction.
Yes, my lord.
So long as the demolition order remains, the construction has to be stopped.
I'll write a value.
You're a party in this writ petition?
Yes, my lord.
Yes, Your Lordship.
Number 3.
R3.
Purple. The learned counsel for the petitioner submits that despite the order of demolition passed by the respondent number 2, the respondent number 10 is permitted to carry on the construction activities and also to encumber the developed portion. The learned counsel for the respondent number 3 submits that though the area is now handed over to the respondent number 3, the respondent number 3 has not taken any steps. Full stop. In that view of the matter, the respondent number 3 is directed to take steps to ensure that no construction activity is undertaken in survey number 142 of Pattandur Agrahara village, K.R.Puram Hobli, Bengaluru East Taluk, till the next date of hearing. List on Yaut. Thursday, next Thursday. In that you should file the concerned officer of the respondent number 3 shall file an affidavit that construction activities is stopped.
Serial for hearing and I, serial number 13.
I appear for petitioners.
Serial number
13.
13.
I appear for the petitioners below. Serial number 13. This matter is pertains to acquisition for the NICE project. The preliminary notification issued on 19/12/1998.
In all these cases?
In all these cases.
19/12/1998.
At Annexure A, my lord. Annexure B, my lord, the final notification issued in the month of March, that is on 21st March 2009, after 11 years.
May I make one submission, your lord?
After 11 years, my lord. Thereafter, my lord, till as on the day after even spending of almost 16 years, including from the acquisition, from the date of notification. 27 years, there is nothing had happened regarding about award.
No award is passed.
No award is being passed.
Yes.
And these things have been considered by the Honorable Supreme Court as well as the division bench in the various cases.
Yes.
It was held that there is no award, acquisition abandoned, it should be lapsed.
In regard to the subject matter, the lands which are subjected in all these writ petitions, your lordship, final notification has been made. No award has been passed. Now the question is.
Some cases.
So we need some time so that we have to bifurcate where the award has been passed, where the award has not been passed.
But in these cases, please make a submission whether award is passed
Yes,
or not.
that will come now. Noted active. That is one part, your lordship. Another in regard to the 28/4. SLP ಸುಜಾತ ವಿಜಯ್ ಕೇಸಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದು ಈಗ ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇದೆ, ವೆದರ್ ಟು ಇನ್ ರಿಗಾರ್ಡ್ ಟು ದ 28/4 ಎಫೆಕ್ಟ್ ಆಫ್ 28/4. ಅದಕ್ಕೆ ಇದನ್ನು ಫ್ಯಾಕ್ಚುಲಿ ಕೂಡ ನಾವು ನೋಡ್ಕೊಂಡು ಬಂದ್ಬಿಡ್ತೀವಿ.
But 98 acquisition still it is not
Yes,
concluded.
ಅದು ಈಗ ಕೆಲವೊಂದು ಅವಾರ್ಡ್ ಆಗಿದೆ, ಅದು ವಿ ವಿಲ್ ಕಮ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವಿತ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಪ್ರಿಸೈಸ್ಲಿ.
ಇಷ್ಟು ಕೇಸಲ್ಲಿ ಯಾವ್ದು ಅವಾರ್ಡ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ
ಅದನ್ನ ಅವ್ರು ಬಹಳ ಸರ್ವೆ ನಂಬರ್ಸ್ ಇದೆ, ಒಟ್ಟು ಎಲ್ಲದರಲ್ಲೂ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ. ನಾವೊಂದು ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್
ಶನಿವಾರ
ಏನಾಗಿ ನಾವು ಈಗ ಬಂದಿದ್ದು, ಅರ್ಲಿಯರ್ ಬ್ರದರ್ ವಾಸ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ರವೀಂದ್ರ ರೆಡ್ಡಿ ಇದ್ರು, ಈಗ ಫೈಲ್ ಸಿಕ್ತು, ಅದಕ್ಕೆ ಒಂದು 2 weeks.
My lord, this is the delay tactic which is been adopted by the respondent from the day one, just to avoid the orders of this.
Not that.
And this is the category. Please.
Approach this court in 2025.
25.
What were you doing? Sleeping?
My lord, the award was not passed till as.
So what were you doing?
Please,
for so many years, you were also sleeping.
Please. My lord, we are only the.
And moreover, some
don't make accusations against the other side when there's so many fingers pointing against you.
Absolutely, my lord. The heart burning is, my lord, no award is as such as in the day. On Monday, there are some 2 connected matters is listing, my lord.
That matter may be also posted with.
It may be taken on the Monday.
Supreme Court. Second akla
2 weeks.
Award agide
ಅಲ್ಲ, ಏನಾಗಿದೆ ಕೆಲವೊಂದರಲ್ಲಿ.
Wait, mister. What is this? ಅವರೇನ ಹೇಳ್ತಿದಾರಲ್ವಾ? Please wait.
ಕೆಲವೊಂದರಲ್ಲಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸರ್ ಇದ್ದಾರೆ, ಕೆಲವೊಂದರಲ್ಲಿ ಅದು ಮ್ಯೂಟೇಶನ್ ಯಾರ್ದು ಹೆಸರಿನಲ್ಲಿದೆ, ಈಗ ಸೇಲ್ ಡೀಡ್ ಹಾಕಿದ್ದಾರೆ. ಸೊ ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ 2 weeks ಕೊಟ್ರೆ ನನ್ಗೆ ಎಲ್ಲ ತಗೊಂಡ್ರೆ
ಇರೋದು 5 ಪಿಟಿಷನ್
ಇಲ್ಲ, 17 ಒಟ್ಟು 12 ಪಿಟಿಷನ್ ಇದೆ. ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ಗೊತ್ತಾಯ್ತು, ಒಂದ್ ನಿಮಿಷ ಇರಿ ಸರ್. 13, 13.1, 13.2, 13.3, 4, 5, then 14, then 15, 15.1, 16, 16.1, 16.2, and 17. All these matters are one and this.
I list it on third.
ನಮ್ಮ ಹಂಬಲ್
ಹೇಳಿ
ಅಲ್ಲ, ಅವ್ರ ಹತ್ರ ನಾನು ಫ್ಯಾಕ್ಸ್ ತಗೋ ಮೊದ್ಲು ಒಂದ್ಸಲ ಇದೇ ತರ ಸಮಸ್ಯೆ
2025 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
No, it was not cut. ನಾನು ಯಾವಾಗ್ಲೂ ನೇರ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ವಿ. My humble submission is at least to be on 10th, your lordship.
No.
ಮಾಡಿದ್ರೆ ನಾನು we will come with that.
Take a date before third.
ಅಲ್ಲ, ಥರ್ಡ್ ಗೆ ಈಗ
ಒಳಗೆ ಯಾವ ತರ ಡೇಟ್ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ,
not beyond third.
No, my 10th ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಬರ್ತಾ ಇದೆ.
Third list on.
ಅಲ್ಲ, my humble submission, short accommodation ಆಗ್ಬಿಟ್ಟು, because I has to get the things 10th ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ. ಇದೊಂದು ಯಾಕಂತ ಎಲ್ಲದರಲ್ಲೂ ಮಾಡಿದ್ವಿ.
Third, please find out what you can do.
May I make one submission? Now all these matters are being moved after 29/7 judgment of the division bench. My lord, SLPs are already filed. It may come up on next Wednesday or Thursday.
See, the division bench has nothing to do with this matter. Division bench is on a different finding.
On the same fact.
ಇಲ್ಲ, same different fact.
There are many other things which the division bench has taken note of.
That is true.
Correct.
The fact that an award is not passed is a formidable point that they are pressing.
Yes.
So therefore you have to answer only that point, whether the award is passed or not. Mugitu.
Some part consent to agide, but we are not able to. My only submission was,
wherever they have consented, they cannot go back now. Please make a submission, take an order. Wherever you have not been able to pass an award, acquisition has lapsed because after so many years you have not taken any steps for concluding. Only on that short ground.
My lord, my only one submission, if I may make. My lord, the learned single judge, my lord, in a batch of 50 cases on 4th July last year, my lord, quashed the acquisition only on that ground that award is not passed. My lord, there, of course, my lord, some consent were there, res judicata, all that, nothing was taken note of, and a common order was passed. Appeals were filed, my lord, both by us and by KADB in all the 50 cases. The division bench, my lord, directed us to file a chart saying where all consent and whatever factual intricacies were there, we filed. Again, a common order is passed without taking note of that. That may not apply to these petitioners. We have filed, my lord. Now we have filed.
Filed an SLP.
4 SLPs we have filed, categorizing them into different issues. That is coming up on Wednesday or Thursday, mostly.
Fair enough. This is only case has to be decided on a question of fact.
That also, my lord,
there is no law involved here.
My lord, law involved is under 28(5), the land vests. once the 28-4 is issued, it vests by operation of 28-5. There is no provision for divesting. There is also a division bench judgment of Justice Oaks earlier in Srinivas Murthy, which says that there is no time limit under the KD Act.
Yes.
There is no question of lapsing. That question also is raised, in the SLP. That has not been taken note of.
But there is also a division bench judgment authored by Justice Alok Harade
Harade.
and Justice Vishwajit
Shakuntalama's
Shetty.
judgment.
Correct.
Where it is held that if the acquisition, even if it be under the KDB Act, if the acquisition is not concluded within a reasonable time, the acquisition goes.
But there
As
is a
per
ಇನ್ನೊಂದ್ರಲ್ಲಿ Justice Alok Harade ಅವ್ರದೇ
Himself has
judgment.
said.
It is a contra judgment where it says now that is before Supreme Court in 2219, where 28-4.
Please place on record all those facts.
Yes,
Let us
Your
see. Yes, list on third.
It be had after the week.
Third it is there.
Let us see what you can do before third. Yes, next.
Lord, we make one.
That,
My name may be shown, Lord.
Along-
Instead of Lord.
Wherever
three
office is directed to show the name of Mr. H.L. Pradeep Kumar as a counsel representing respondent number 1 after deleting the name of Mr. Ravindra V. Reddy in all these petitions.
special counsels.
Yes, next.
Sir. Lord, along with Lord S.A. Ahmed and
Mallar.
Mallar.
Huh?
Along with Lord S.A. Ahmed and Mallar, Mr. Mallar.
He is a additional advocate general.
ಅದರಲ್ಲಿ ಅವರಿಗೆ
Special counsel
ಮಾಡಿ
Nimana,
How's ಮಾಡಿ.
along with Mr. S.A. Ahmed, the additional advocate general. Yes.
and Mallar.
Mallar.
And
Mallar Rao.
oh, ನೀವು ಇದ್ದೀರಾ? And Mr. Mallar Rao, additional advocate general. Yes. Hmm.
18.
Manjunath Reddy.
Same.
21.
21 is same.
Huh?
21 is also
For
same.
18.
21 also, na?
21.
Okay, for the petition.
But 21 we have not
also
got
not
copies.
21 also. Manjunath Reddy.
18 Manjunath Reddy.
Manjunath Reddy. Oh, ಇದು judicial employees. ಏನ್ ಸಾರ್ಟ್ ಔಟ್ ಆಗ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಅದು matter itself can be heard ಅಂತ.
I think it is understood that the party shall address arguments on the main matter ಅಂತ last time ಆಗಿದೆ.
ಅದೇ ಅದನ್ನೇ
If you are ready, I'll take it.
Yes, sir.
Ready na? All of you
Ready,
ready? Pass over.
ಅವ್ರಿಗೇನು ಮಧ್ಯಾಹ್ನ ಏನೋ ತೊಂದ್ರೆ ಇದೆಯಂತೆ.
ಯಾರಿಗೆ?
ಆಗ್ಲಿ ಪಾಸ್ ಓವರ್ ಆಗ್ಲಿ. ಲೆಟ್ ದಿ ಸೀನಿಯರ್ ಕಮೆಂಟ್ಸ್. ತೊಂದ್ರೆ ಇದೆ ಬಟ್ ಸೀನಿಯರ್ ಕಮೆಂಟ್ಸ್ ಮಾಡಿ. ಅಲ್ಲ ಕಮೆಂಟ್ಸ್ ಮಾಡಿ ರಿಪ್ಲೈ ಮಾಡೋ
ನಾವೊಂದ್ಸರಿ ನೀವೊಂದ್ಸರಿ ಇಬ್ರು ಒಟ್ಟಿಗೆ
maybe 10 minutes late ಅಷ್ಟೇ. ಲೆಟ್ ಸೀನಿಯರ್.
ಆಯ್ತು. Yes, next.
Serial number 19.
H.C. Sundaresh,
Sundaresh HC.
N.R. Girish.
Yeah, IA has been filed for correction of cost title of the petitioner. First petitioner, B.R. Narendra Babu, another Nagendra Babu. And then this is only a mandamus to consider my reputation.
Yeah, the IA 1 of 26 ಏನಿದೆ?
ಅದು cost title ಅಲ್ಲಿ first petitioner name wrongly shown
IA
as
1 of
Narendra
26
Babu.
is filed by the petitioner to
Nagendra
correct the
Babu.
name of the petition number 1 in the cost title as B.R. Nagendra Babu instead of
Narendra Babu.
P.R. Narendra Babu. Since the application is for innocuous relief, IA 1 of 26 is allowed and the petitioner is permitted to correct the name of the petitioner number 1 as B.R. Nagendra Babu instead of B.R. Narendra Babu. Yes.
This is only a mandamus to consider my reputation for allotment of alternative site. But the site was allotted in favor of the petitioner's vendor.
But could the
Annexure
petitioners have sought for it in the nature of mandamus to direct the respondents to consider the representation dated 7/3/2026 for allotment of
alternate
site bearing number 2485 at Banshankari 6 stage 3rd block as an alternate site or allot any other site in the same layout of a equal dimension in lieu of site number 89 measuring 30 by 40 situated Granaparathi layout. Full stop. Petitioners contend that the respondent number 1 had allotted site number 89 at Granabharati layout, Nagadevanahalli block 2 in favor of Mr. Jairaj in terms of a letter of allotment dated 21/2/2000. A sale deed was also executed in favor of Mr. Jairaj. The petitioners jointly purchased the said site from Mr. Jairaj in terms of a sale deed dated 24/8/2005 and are in possession of the said site. Also, petitioners contend that site number
89 was formed in.
89 was formed in survey number 124 of Nagadevanahalli, and the owner of the said survey number filed WP number 11063/2014 challenging the acquisition proceedings. The said writ petition was allowed and the acquisition proceedings was quashed as per the order dated 19/7/2017. The respondent filed writ appeal, respondent number 1 filed writ appeal 738 of 2018, which was dismissed in terms of the order dated 3/12/2019, which was unsuccessfully challenged before the Honorable Supreme Court in SLP 3909/2021. It is claimed that the owners of the land in survey number 124 took possession of the land pursuant to the acquisition proceedings being set at naught. Full stop. Petitioners then filed a representation before the respondent for allotment of an alternate site. Full stop. The Deputy Secretary of the respondent number 2, in his note dated 9/3/2026, directed the executive engineer to conduct a spot inspection and submit a report. Full stop. The executive engineer visited the spot and submitted a report that the owners of survey number 124 had taken over the entire land, including site number 89 that was allotted to the vendor of the petitioners. Full stop. On the basis of the report, the case was referred to the law officer of the respondent number 1, who furnished a report recommending for allotment of an alternate site. Full stop. Petitioners contend that a proposal was placed before the committee for allotment of alternate site, which took a decision to allot a site in the same layout. And authorized the commissioner of the respondent number 1 to take necessary steps to allot the site. Petitioners contend that they submitted another representation dated 7/3/2026 requesting them to allot site number 2485 situated at Banshankari 6 stage, 3rd block, as the same was vacant and was not allotted to any third party. Petitioners contend that their representation is not considered and therefore seeks for a direction to the respondents to consider the representation and allot site number 2485 at Banshankari 6 stage, 3rd block, or any other site in the nearby layout. The learned counsel for the petitioners reiterated the above submissions. The learned counsel for the respondent, on the other hand, contended that the respondents would consider the request of the petitioners in accordance with law and pass appropriate orders. In view of the aforesaid submission of the learned counsel for the respondents, this petition is disallowed and the respondents are directed to consider the request of the petitioners dated 7/3/2026 and if possible to allot site number and if feasible to allot site number 2485 at Banshankari 6 stage, 3rd block, or any other site of the same dimension in any nearby layout. This shall be complied within a period of this shall be complied within a period of 3 months from the date of receipt of a copy of this order. A correction ಮಾಡಿ
Please.
Serial number 20.
Mr. Doreraj
BH.
Murugesh Charati. ಏನು?
My lord, subsequent to
You
order.
ready? I'll take it up. Pass hold.
21 G1 Hajan for preliminary hearing matter, serial number 22, Nishit Kumar Shetty.
serial number 21 ಏನಾಯ್ತು? 21, okay. Yes,
Yeah.
Nishit Kumar.
Lord, my colleagues, madam, my lord, I signed the wakalat. Lord, the subject matter of this land, my lord, was initially to be notified, my lord, by under section 28(1). But there is an endorsement issued, my lord, saying that it is not acquired, the final notification, because the total extent of land is 41 acres, my lord, in that survey number. But only 33 acres was handed over to the KADB, thereafterwards the beneficiary. Now there is an endorsement which says that, my lord, this land is not handed over. Now notice is issued for passing the award, my lord, to me, saying that produce the documents. My lord, my prayer before my lords is that, my lord, I am entitled for denotification of that entire land. And also,
If you say it is not
no,
notified,
but still, my lord, RTC is not entered in my name, despite the KADB writing to the
so
Tahsildar.
how did you get this land?
My lord, by purchase.
You purchased it?
Yes, yes.
Where's the preliminary notification?
Preliminary notification is at page number F, my lord, page number 49.
What is the survey number?
40, by 40. Survey number 40, my lord, which my lords would get it at.
Page 51.
51 and 52, my lord. 51.
M.R. Lakshmanappa.
ಲಕ್ಷ್ಮಣಪ್ಪ ಅದೇ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಅದ್ರಲ್ಲಿ 40 ಎಕರೆ ಅಂತ ಬರೀತಾರೆ ಸ್ವಾಮಿ ಅವರು.
ನಿಮ್ಮ ಹೆಸರೇನು?
ನನ್ನ ವೆಂಡರ್ ಇದ ಹೆಸರು ರಾಜಪ್ಪ.
ರಾಜಪ್ಪ.
ದಟ್ ಈಸ್ ಅಟ್ ಪೇಜ್ 52.
ಅವ್ರ ಹೆಸರು ಇದೆ, ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಅವ್ರ ಹೆಸರು ಇದೆ.
ಇದೆ. ಆಮೇಲೆ the extent of land is only 33 acres.
Final notification.
Final notification.
ನಿಮ್ಮ ಹೆಸರು ಇದೆಯಾ?
Page 60.
Page 60.
Yes, 60, my lord. Serial number 11.
ನಿಮ್ಮ ಹೆಸರು ಇದೆ, ರಾಜಪ್ಪ ಅಂತ ಇದೆಯಲ್ಲ?
ರಾಜಪ್ಪ ಅಂತ ಇದೆ. ರಾಜಪ್ಪ ಅಂತ ಇದೆ. 33 acres is the total extent, my lord.
ಆಯ್ತು, ಬಟ್ ಇವ್ರು ಯಾರ ಹೆಸರು ಬಿಟ್ಟೋಗಿದೆ ಇದರಲ್ಲಿ? From the preliminary notification to the final notification.
No, I'm only total extent is, my lord, 41 acres.
41 acres ಅಲ್ಲಿ it is reduced to 33 acres.
33 acres.
Are the names of any occupants deleted in the final notification?
My lord,
preliminary notification ಯಾರ ಹೆಸರು ಇದೆ ಹೇಳಿ?
My lord, may I persuade my lords to turn to page number 138, my lord. The endorsement issued by the KADB saying
M.R.
that
ಲಕ್ಷ್ಮಣ ಮುನಿಪೇತಾಳಿ, M.R. ಲಕ್ಷ್ಮಣಪ್ಪ, ಪಾರ್ವತಮ್ಮ, ಪುಟ್ಟ ಗಿ ಹನುಮಂತಪ್ಪ, ಎಚ್ ಚಿನ್ನಪ್ಪ, ಉದಯಶಂಕರ್, ಇಷ್ಟು ಜನರ ಹೆಸರಲ್ಲಿ ಯಾರ ಹೆಸರು ಬಿಟ್ಟೋಗಿದೆ ಅಂತ ಕೇಳ್ತಿರೋದು.
ನನ್ನ ಜಾಗವನ್ನು ಅಕ್ವೈರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಯಾರ ಹೆಸರು ಬಿಟ್ಟೋಗಿದೆ ಅಂತ, ಯಾರ ಹೆಸರು ಬಿಟ್ಟೋಗಿದೆ?
ನನ್ನ ವೆಂಡರ್ ಇದ ಹೆಸರು ಬಿಟ್ಟೋಗಿದೆ
ತೋರಿಸಿ.
The reason is this, my lord. Kindly turn to page number 130.
Let us understand the facts first. Preliminary notification, there are 11 names.
Yes, my lord.
In the final notification, whether all the 11 names is shown. Final notification ಎಲ್ಲರ 11 ಹೆಸರು ಇದೆಯಾ?
ಬರೀ 7 ಹೆಸರು ಇದೆ.
ಸೊ 4 ಜನದ ಹೆಸರು ಯಾರ್ದು ಬಿಟ್ಟೋಗಿರೋದು? ಎಂ.ಆರ್. ಕೃಷ್ಣಮೂರ್ತಿ, ಬಿನ್ ರಂಗಪ್ಪ,
ಪಾರ್ವತಮ್ಮ,
ಎಂ.ಆರ್. ಕೃಷ್ಣಮೂರ್ತಿ, ಬಿನ್ ರಂಗಪ್ಪ, ಚಿನ್ನಪ್ಪ,
ನನ್ನ ವೆಂಡರ್
ತಾಳಿ ಪ್ಲೀಸ್ ವೆಯ್ಟ್, ರಾಜಪ್ಪ, ರುದ್ರಾಚಾರ್, ಎಲ್ ರಾಜು, ಎಲ್ ರಾಜು ಬಿನ್ ಅಮರ್ನಾಥ್, ಕಿರಣ್ ಚಂದ್ ನೆಹರ್, ಮಹೇಂದ್ರ ಕೊಠಾರಿ. ಯಾರ್ಯಾರ್ದು ಬೇರೆ ಹೆಸರೆಲ್ಲ ಸೇರಿಸಿದ್ದಾರೆ.
ಹೌದು. Extent has been reduced, my lord, from 41 acres to 33
But
acres.
your name is found in the
Yes,
final notification.
but my lord, may kindly turn to page number 138, where they very specifically say that, my lord, my land is not acquired or not handed over, my lord.
On what basis?
My lord, because the total extent was reduced from 41 acres to 33 acres.
But your name is found in the final notification.
That is the dispute which is still pending, my lord, with regard to the RTC entries. But when I filed an appeal before the authority, my lord, assistant commissioner, he says that, my lord, to restore my name in the RTCs, my lord, may persuade my lords to turn to page number 138, my lord. My lord, penultimate paragraph. ಭೂಮಾಪಕರು ನಕ್ಷೆಯಲ್ಲಿ ನೀಲಿ ಬಣ್ಣದಿಂದ ಗುರುತಿಸಿರುವ ಪ್ರದೇಶವು ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಂಧಪಟ್ಟ 4 ಎಕರೆ ಪ್ರದೇಶವಾಗಿದ್ದು, ವರದಿಯಂತೆ ನೈಸ್ ಕಂಪನಿಗೆ ಹಸ್ತಾಂತರಿಸಿರುವುದು ಕಂಡುಬರುತ್ತಿಲ್ಲ. ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 40 ರಲ್ಲಿ 41 ಎಕರೆ 12 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಕಾಲಂ 3(1) ಕೈಗಾರಿಕಾ ಪ್ರದೇಶವನ್ನು ಘೋಷಿಸಿದ್ದರೂ ಸಹ ಸದರಿ ಸರ್ವೆ ನಂಬರಿನಲ್ಲಿ ಕೇವಲ 33 ಎಕರೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನಿಗೆ ಮಾತ್ರ ಕಾಲಂ 1(3)28(1) ಪ್ರಾಥಮಿಕ ಅಧಿಸೂಚನೆ ಮತ್ತು ಕಾಲಂ 28(4) ಅಂತಿಮ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನು ಈಗಾಗಲೇ ನಿರ್ಮಾಣಗೊಂಡಿರುವ ಪೆರಿಫೆರಲ್ ರಸ್ತೆಯ ಸುಮಾರು 60 ಮೀಟರ್ ದೂರವಿರುತ್ತದೆ. ಈಗಾಗಲೇ ಪೆರಿಫೆರಲ್ ರಸ್ತೆ ನಿರ್ಮಾಣವಾಗಿದ್ದು, ಸದರಿ ಜಮೀನಿಗಾಗಿ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದಿಲ್ಲ ಮತ್ತು ಸರ್ಕಾರವು ದಿನಾಂಕ 14/2/22 ನೈಸ್ ಯೋಜನೆಯಡಿ ಇರುವ ವ್ಯಾಜ್ಯಗಳ ಕುರಿತು ಪರಿಶೀಲಿಸಿ ಶಿಫಾರಸುಗಳನ್ನು ಮಾಡಲು ಈ ಯೋಜನೆಗೆ ಹೆಚ್ಚುವರಿಯಾಗಿ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡಿರುವ ಜಮೀನು ಮತ್ತು ರಸ್ತೆಯಿಂದ ದೂರವಿರುವ ಜಮೀನುಗಳನ್ನು ಕೈಬಿಡುವ ಬಗ್ಗೆ ಸಚಿವ ಸಂಪುಟ ಸಮಿತಿ ಸಭೆ ನಡೆಸಲಾಗಿರುತ್ತದೆ. My lord, thereafterwards, my lord, ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವ 4 ಎಕರೆ ಪ್ರದೇಶವನ್ನು ನೀಲಿ ಬಣ್ಣದಲ್ಲಿ ನಕ್ಷೆಯಲ್ಲಿ ಗುರುತಿಸಿದ್ದು, ಕೆಡಿಬಿ ಭೂಸ್ವಾಧೀನ ಎಂದು ನಂಬಿಸಿರುವ ವಿಸ್ತೀರ್ಣದಿಂದ ಕೈ ಬಿಡುವ ಬಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಿಸಿ. This is what is given to me, my lord. I mean, the order is passed. Thereafter, now they have issued a notification, I mean, letter, my lord, to produce the documents. Your lordship may kindly turn to page number 150. This is the letter received by me, my lord, saying that you have to produce documents for passing of the award.
Yes. Where is that map which had sketch, survey or sketch that they had drawn up?
Where sketch, I don't have a copy, my lord. I'll produce it because I'll have to obtain it. Maybe I'll have to obtain it from the authority.
ನೈಸ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದ H.L. Pradeep Kumar is directed to accept notice for respond number 1 and 2. Mr. Yaru A.L. Gopal Billalmane is directed to accept notice for respond number 3 and 4. HCGP is directed to accept.
Lord, NICE is not made a part in this case.
HCGP is directed to accept notice for R5. Learned counsel for the petitioners is directed to implead NICE as respondent number 6 in this expedition. Mr. Nitin Prasad is directed to accept notice for respond number 6.
Please. Lord.
In view of letter of the Special Deputy Commissioner dated 5/10/2023. 5/10/2023. Addressed to the respondent number 5. Bracket annexure yes, comma, the further proceedings pursuant to the notice dated
29/8/2025.
29/8/2025.
Page 150.
29/8/2025. 2025. Bracket annexure.
Annexure X.
Annexure X is stayed. List on yavat ಬೇಕು.
I may
implead
yes,
response.
right now, my lord, I may be permitted.
So copies list on date could yavat 2 weeks. Could yavat on date. Yes, next. Copies.
15 September. 23. Adi Narayan.
Adi Narayan.
Yeah, good.
Speak for short, pass over, my lord. Senior is engaged in other court, my lord.
Nice.
Senior is engaged in other court, my lord. Short
What is the
pass over,
case
my lord.
about? You have the file with you or not?
My lord, I have the file, my lord.
What have you read? You not read the file?
Lord?
Have you read the file?
Yes, my lord, I read the
What
file,
is the
my
case
lord.
about?
My lord, it's a conversion land, my lord, from agriculture to non-agriculture purpose. As a site was purchased by the petitioner, my lords. I've given the representation regarding that representation. I've
It's
given the
only a
objection, my
preliminary
lords.
notification.
Yes, my lord. For that, I have filed an objection, my lords. That has not been considered, my
Consider.
lords.
Come to the court after final notification is issued.
My lords, I take a short pass of seniors comment argument matter, my lords.
Paso.
Oblige, my lords.
Number 24, M. Sudhakar.
Okay, for the petition.
Sudhakar.
24 and 26, my lord, are identical, my lord. In both the matters, my lord, your lordship may take, my lord, serial number 24, my lord. As per the annexure F, my lord, that too, my lord, after the High Court order, in page 28, my lord, it was, first respondent has referred the matter to the special DC 2 KADB, my lord, for approval of the award. Petitioner's land refer, my lord. In page 28. That is the dated, my lord, 14 to 16 to February 2026, my lord. Lands are acquired, my lord, long back. Thereafter, the representation was made, my lord, on 1/4/2026, my lord. So only a mandamus is sought, my lord, to do the needful in both the matters. ಅನುಮೋದನೆಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ approval ಗೆ.
Again, you ask for passing an award.
Please, my lord.
Serial number 24.
Yes.
Prayer ಅಲ್ಲಿ ನೀವು award pass ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀರಾ. Please see the relief that you sought for.
Yes, ma'am.
Pass an award pertaining to the petitioner forthwith pursuant to an order dated so and so.
Yes.
In the general award ಇದು. So pass individual awards.
Yes, right. They have to approve only, they have to approve now.
Huh?
It has to approve by the land acquisition. Special act. Last step may dispose of the direction to the deputy commissioner, take a decision of pass on.
Very good. The petitioner has sought for a writ in the nature of mandamus to direct the respondent number 2 to pass an award in the name of the petitioner concerning the land bearing survey number
95/3.
95/3 of
Chelur village, Bandwal Taluk, Ullal Taluk.
Chelura. Chelur village.
Ullal Taluk.
Ullal Taluk, Bandwal district.
Allala, Dakshina Kannada district.
Dakshina Kannada district.
Yes.
Dakshina Kannada district.
2 survey numbers.
ಯಾವ್ದು?
95/3 measuring 1 acre 44 cents and 98/1 18 cents, in all measuring 162, 1 acre 62.
Pursuant to an order dated 16/2/2026 passed by the respondent number 1. And also by considering the representation of the petitioners dated 1/4/2026. The petitioner contends that
There they filed a writ petition.
the respondent number 1 had issued a notice dated, submits that the aforesaid land was acquired for the purposes of the Industrial Area Development Board. Full stop. The respondent number 1 issued a notice dated 14/10/2025 determining compensation at a sum of rupees 10 lakhs per acre. The petitioner filed his objections to the said notice.
Yes.
Thereafter, the respondent number 1 issued a notice dated 31/12/2025. And the petitioner submitted a request to dated 16/1/2026 to redo the determination of the compensation. Therefore, by an order dated 16/2/2026, the respondent number 1 referred the issue to the respondent number
And refer to the deputy commissioner.
passed an award and referred the matter to the respondent number 2
For approval, that's all.
for approval. Petitioner contends that the respondent number 2 has failed to approve the award.
Yes.
And therefore, the petitioner was constrained to submit a representation dated 1/4/2026. However, the respondent has not taken any action till date, and therefore the petitioner seeks for a direction. The learned counsel for the petitioner reiterated the above submissions and submitted that the respondent number 2 is bound to approve the award passed by the respondent number 1 and pay the compensation as determined. Full stop. The learned counsel for the respondents submitted that the request of the petitioners would be considered in the light of the award passed by the respondent number 1 and appropriate steps would be taken to approve the award so passed and take a decision in accordance with law. In that view of the matter, this writ petition is disposed of, directing the respondent number 2 to consider the award passed by the respondent number 1 and take appropriate decision in accordance with law. This shall be completed within a period of 1 month from the date of receipt of a copy of this order. See, number 28 is also similar.
26 ಮೇಲ್
26,
Yeah.
same order.
ಅದರಲ್ಲಿ annexures ಸ್ವಲ್ಪ ಚೇಂಜ್ ಅಷ್ಟೇ.
Yes, we'll consider. Same ಅಲ್ಲ?
ಸೇಮ್ ಅದೇ
Yes,
ಒಂದೇ ಟೇಬಲ್ ಅಲ್ಲಿ ಎರಡು ಗ್ರೇಟ್ ಸರ್.
Mr. PV
ಚಂದ್ರಶೇಖರ್
ಇದಾಗಿಲ್ವಾ ಅದು? ನೋಟಿಸ್
ಅಲ್ಲ, ಅದು ಅವರಿಗೆ ನಾವು ಸರ್ವ್ ಮಾಡಿದ್ವಿ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ಹತ್ರ.
Mr. PV Chandrasekhar is permitted to file memo of appearance within 10 days. ಎರಡರಲ್ಲೂ. Yes.
Great, sir.
Nandakishore.
Petitioner.
PRR 1.
1 month.
Same order, madam. ಇದರಲ್ಲಿ AGA is directed to accept notice for respondent number 1. Could you? Mr. BS Karthikeyan is directed to accept notice for respondent number
2 and 3.
AGA for 1, 2, BS Karthikeyan for 3 and 4. PRR same in status quo. Yes, next.
Serial number 26, dispose of. Serial number 27, Chandrasekhar L.
L. Chandrasekhar.
Type of a petitioner, my lord. In this, the petitioner is seeking mandamus has obtained the said land by partition and to develop the layout has filed an application before the respondent number 225.
Parkol. AGA is directed to accept notice for R1. Mr. BS Karthikeyan is directed to accept notice for respondent 2, 3, 4, 5. Yes.
For admission
List
matters.
on date code.
Yes, sir. 11th September. For admission matters, serial number 28, Ravi
Yes,
MM.
my lord. For the owner of the 14-wheeler vehicle, my lord, I am the owner of the 14-wheeler milk tanker.
You are the owner of?
Milk tanker, my lord, 14-wheeler milk tanker. Then first respondent filed a FIR under the Annexure C, my lord, Annexure A, my lord. Under the excise of, my lord, on the ground that the accused number 2 driver was carrying the liquor in the driver's seat. I filed a criminal petition before this honorable court. The same has been allowed, my lord, by I am the owner. Page number, my lord, 45, my lord.
Who are you?
I am the owner of the vehicle, my lord.
Why you come again?
They are not releasing my vehicle, my lord. Even though, my lord, the earlier proceedings has been quashed. Against the accused number 2 also it has been quashed, my lord, on page number 50. But I am made a representation. Page number, my lord. Annexure J, my lord, they have issued an endorsement. They already passed an order, impugned order, that to deposit the.
No, what is the order passed by this court?
This court, my lord, already passed the entire proceedings.
Where is that order? Page number 45, huh?
45.
What does it say? In that way of the matter, petition is allowed, prosecution petitions is also on file of so against is quashed. However, the prosecution shall continue against the accused number 1 in accordance with law.
Oh, my lord, I made a representation on that, my lord, to release the vehicle, but they said they give the endorsement that they already passed an order to deposit the bank guarantee of 10,20,000, my lord. So thereafter, my lord, accused number 2 also preferred a criminal petition in page number 50, my lord. That is also, my lord, allowed, and the entire proceedings has been quashed. Thereafter, my lord, I given representation. They issued an endorsement, Annexure J, my lord. Kindly see, my lord, page number 64. ಎರಡನೇ ಪೇರದಲ್ಲಿ ವಾಹನವನ್ನು ಮುಟ್ಟು ಪ್ರಕ್ರಿಯೆ ಅಂತಿಮವಾಗಿದ್ದೇವೆ
ಓದಪ್ಪ ಎರಡನೇ ಪ್ಯಾರ ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್
64 ಮೇಲೆ
ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರು
ವಲಯ ಸೋನ್ಸೋ ದಿನಾಂಕ ದಾಖಲಿಸಿರುವ ಪ್ರಕರಣದಲ್ಲಿ ವಶಪಡಿಸಿಕೊಂಡಿರುವ ವಾಹನವನ್ನು ಮುಟ್ಟುಗೋಲು ಹಾಕಿರಲು ಅಂತಿಮ ಪ್ರಕರಣ ಇತ್ಯರ್ಥವರೆಗೂ 10,20,000 ಬ್ಯಾಂಕ್ ಭದ್ರತೆ ಹಾಜರುಗೊಳಪಡಿಸುವ ವಾಹನವನ್ನು ತಾತ್ಕಾಲಿಕವಾಗಿ ಮಾಲೀಕರ ಹೊರಗಡೆಗೆ ಪ್ರಾಧಿಕಾರದಿಂದ ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಆದೇಶದಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ಬಿಡುಗಡೆಗೆ ಮಾರ್ಪಡಿಸಿ ವಾಹನ ತಾತ್ಕಾಲಿಕ ವಶಕ್ಕೆ ಆದೇಶಿಸುತ್ತದೆ. ಅದ್ರ ಮೇಲೆ ದೇ ವಾಂಟೆಡ್ ಟು ರಿವ್ಯೂ ಮಾನ್ಯ ಉಚ್ಚ ಆದೇಶದ WP ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಸರ್ಕಾರಿ ವಕೀಲರು ನೀಡುವ ಅಭಿಪ್ರಾಯದ ಮೇರೆಗೆ ಮಾನ್ಯ ಕೊನೆಯದಾಗಿ ಲಾಸ್ಟ್ ಈ ಮಧ್ಯೆ ಮಾನ್ಯ ಉಚ್ಚ ಆದೇಶ ಸಂಖ್ಯೆ ಆರೋಪಿ ವಿರುದ್ಧ ನ್ಯಾಯಾಲಯದ ಸಲ್ಲಿಸುವ ಕ್ರಿಮಿನಲ್ ನಡವಳಿಕೆಯನ್ನು ರದ್ದುಗೊಳಿಸಿ ಆದೇಶಿದ್ದು ಆದೇಶವನ್ನು ಪಾಲಿಸುವ ಕುರಿತು ಕಾನೂನು ಅಭಿಪ್ರಾಯ ಕಚೇರಿ ಪತ್ರದ ವಕೀಲರನ್ನು ಕೋರಲಾಗಿರುತ್ತದೆ. ಸರ್ಕಾರಿ ವಕೀಲರನ್ನು ಸ್ವೀಕರಿಸಿದ ನಂತರ ನೀವು ಅರ್ಜಿಯನ್ನು ಪರಿಮೋಹಿಸಲಾಗುವುದು. He has been inducement. Till date, my lord, he has not released the vehicle, my lord. The entire proceedings has been quashed. And I'm seeking to
Now, why have you filed a criminal petition for this?
Lord, on the guise of, my lord, the order, impugned order, they are not releasing the vehicle. That I'm seeking to pass that order and direction to release the vehicle.
No, but how are you filing a criminal petition, mister?
And that, my lord, pass the interim order passed by the respondent number 2.
Mister, how can you file a criminal petition for that relief?
My lord, they are not releasing the vehicle, my lords. The entire proceedings has been passed.
See, if you lost your way,
And
if you're
liberty-
going to Tamil Nadu, if you've gone to Andhra Pradesh, and if you're searching for Chennai in Andhra Pradesh, what can I do? You're supposed to go to Tamil Nadu if you want to reach to Chennai. ನೀವು ಆಂಧ್ರ ಪ್ರದೇಶ್ ಬಸ್ ಇಟ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಚೆನ್ನೈ ಹುಡುಕ್ತಾ ಇದ್ರೆ ನಾವ್ ಏನ್ ಹೇಳೋದು ನಿಮ್ಗೆ?
My lord, I already filed.
How can you file a 482 petition for this?
Passing of the interim order, my lord, passed by in the same FIR.
Mister, the proceedings is quashed.
I will withdraw.
Full stop.
Liberty.
ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ, ಜನರಲ್ ಮಿಸ್ಟೇನ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ಅದ್ ತಕೋಬೇಕು. ಇದ್ಬಿಟ್ಟು ಏನೋ ಬೇರೆ ಮಾಡ್ತೀರಾ ನೀವು? You want to withdraw it? Barkol learned counsel for the petition after arguing for some time sought permission to withdraw this petition. Accordingly, the petition is dismissed as withdrawn. If the petitioner desires to approach this court in a writ petition, he is permitted to do so. Petition, writ petition ಹಾಕ್ಬೇಕು. 29 ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ. Yes, next.
Serial number 30 urgent, serial number 31 final hearing matter Nayak NR.
NR Naik. Mr. NR Naik. Ajay Kumar Patil. Yes. Yes, Murugesh. Copy ಕೊಟ್ಟಿಲ್ಲ?
Last time directed them to.
Mr. NR Naik, pass over.
Preliminary B group matter serial number 32 Vivek Holla.
ವಿವೇಕ್ ಹೊಳ್ಳ. ಏನಾಯ್ತಿದು? ಆಯ್ತಾ? ಎಲ್ಲಿ ಸೋಮಶೇಖರ್? ಹಾ.
ಅದರಲ್ಲಿ 40 ಫೀಟ್ ರೋಡ್ ಇದೆ, ಅದು ಬೇಡ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. 40 ಫೀಟ್ ರೋಡ್ ಇದೆ 2 ಸೈಟು, ಬೇಡ, ಅದು ಕಮರ್ಷಿಯಲ್ ಅಲ್ಲ, ರೆಸಿಡೆನ್ಷಿಯಲ್. ದೇ ನಾಟ್ ಅಗ್ರಿ.
ಅವರು 80 ಫೀಟ್ ರೋಡ್ ಅಲ್ಲಿ ಇದೆ, ಕಮರ್ಷಿಯಲ್ ಆಗುತ್ತೆ ಅಂದಿದ್ರು. ಬಟ್ ಅದು 80 ಫೀಟ್ ರೋಡ್ ಅಲ್ಲ ಅಂತೆ, 40 ಫೀಟ್ ರೋಡ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸೈಟ್ಸ್ ಅವೈಲೇಬಲ್ ಇದೆ ಅಂತ ಹೇಳಿ ಅಂತ ಇದ್ದಾರೆ. That much my client may not be agreeable.
Argue the matter, I'll decide the matter. ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ ಪ್ರಪೋಸಲ್?
ನಾನು ಒಂದು ಪ್ರಪೋಸಲ್ ನಮ್ಮ ಕ್ಲೈಂಟ್ ಹೇಳಿದ್ದೀನಿ. ದೇ ಹ್ಯಾವ್ ಸರ್ಚ್ಡ್ 2 sites in ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್.
ಯಾವುದು? ನಮ್ಮ
ಕ್ಲೈಂಟ್ಸೇ ಸರಂ ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲಿ 2 ಸೈಟ್ ಹುಡ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ.
ಯಾರು?
ಅವರ್ ಕ್ಲೈಂಟ್. ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
PDA will allot.
PDA ಅದಕ್ಕೆ ನಾವೇ ತಗೊಂಡ್ಬಿಡ್ತೀವಿ 2 ಸೈಟ್ ಇಂದ, ಸುಮ್ಮನೆ ಯಾಕೆ?
ಅಂದ್ರೆ ಇದ್ರ ಬದಲು ನೀವ್ ಹೇಳ್ತಿರೋದು HSR ಲೇಔಟ್ ಬದಲು ಅದನ್ನ ತಗೋತೀರಾ ಅಂತ?
ಸುಮ್ಮನೆ ಲಿಟಿಗೇಷನ್.
So this can be given back to them.
ನಾನು ಇವತ್ತು ಈಗ ಹೇಳಿದ್ದು ನಾವೇ ಹುಡ್ಕೊಂಡ್ ಬಂದಿದ್ದು ನೋಡಿ. ಏನು
ಆಲ್ಮೋಸ್ಟ್ ಡಬಲ್ ರೋಡ್ 120 ಫೀಟ್ ರೋಡ್ 100 ಫೀಟ್ ರೋಡ್ ಇದೆಯಾ?
ಅದು ಅಲ್ಲೊಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಪಾಪ. ದಟ್ ನಾಟ್
ಯಾವತ್ತು ಹೇಳು?
ಅಲ್ಲ, ತಂದಿದ್ದೀನಿ, ಸೈಟ್ ನಂಬರ್ ತಂದ್ಬಿಟ್ಟಿದ್ದೀರಿ.
ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. The learned counsel for the respondent number
4.
Learned counsel for the respondent number 4 submits that the respondent number 4 has identified two sites.
Site number 1000,
Identified site numbers
1010,
1010,
ಅಲ್ಲ 11,010
11,010 and
in survey number 32/2
in survey number 32/2 and
of Ramchandra village.
of Ramachandra village.
ಆಮೇಲೆ 1116/1
And
1116/1
1116
for 1
bar
for 1
bar 1 in
same survey number
same survey number
80 Ramchandra village.
of Ramachandra village in
Sarvam
Saram Vishweshwara layout. And he is willing to take these two sites in lieu of the sites that are denotified and which are questioned in this writ petition. Full stop. The learned counsel for the respondent number 1 seeks time to secure instructions whether the aforesaid two sites could be allotted to the respondent number 4.
ಆಮೇಲೆ it has to be allotted. Then subsequently, my lord, I have sold this 17 guttas of land. One Janardhan. They also produced the sale deeds. ನಾನು ಮಾರ್ಬಿಟ್ಟಿದ್ದೀನಿ ಆಲ್ರೆಡಿ ಜನಾರ್ದನ್ ಅವ್ರಿಗೆ. ಅವ್ರ ಹೆಸರು ಖಾತೆ ಹೋಗಿದೆ, ಅವರು ಬೆಟ್ಮೆಂಟ್ ಚಾರ್ಜ್ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈ 2 ಸೈಟ್ ಅವ್ರ ಹೆಸರಿಗೆ ಹೋಗ್ಬೇಕು. ಯಾರು ಪರ್ಚೇಸ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಫ್ರಮ್
ಜನಾರ್ದನ್ ಹೆಸರಿಗೆ.
ಜನಾರ್ದನ್.
He also fairly submits that the respondent number 4 has already alienated the sites that were
Entire land of
denotified. They already alienated site survey number
3/3
3/3
measuring 17 guttas
3/3 of
HSR layout.
HSR layout ಅಲ್ಲ, ಯಾವ ಊರು? ಸರ್ಜಾ ಎಲ್ಲ ಎಂತದ್ದು ಹೆಣ್ಣೂರ?
ಬೆಂಗಳೂರು
ಅಲ್ಲ, ಹೆಣ್ಣೂರು ಅಂತೀನಿ ಎಂತದ್ದು.
3/3 of HSR sector.
Schedule.
Survey number 3/3
of HSR
3/3 become 3/5 ಆಗಿದೆ.
to one Mr. Janardhan. And therefore, if the respondent number 1 decides to allot the sites, alternate sites at Saram Vishweshwaraya layout, the same has to be conveyed to Mr. Janardhan.
Agara village, Begur Hobli, Bangalore.
Agara village anta 3/3 of Agara village.
Begur
Hobli. The same has to be conveyed to Mr. Janardhan. The learned counsel for the respondent number 1 seeks time to secure instructions. List on yavat.
Next week
Parted ಎಲ್ಲ ಇಲ್ಲ.
ಈ ಸ್ಟೇಜ್ ಬಂದಿದೆ.
ಅವ್ರಿಗೆ ಒಪ್ಕೊಳ್ತಿದಾರಲ್ಲ, what if he is willing to take those sites, better you give it to close. There is no reason. ನೀವು ಒಪ್ಕೊಂಡ್ರೆ ಮುಗೀತಲ್ಲ. Yes, list on ಯಾವತ್ತು ಬೇಕು?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ಆಗ್ಬಿಡ್ಲಿ.
Yes, ಅವ್ರು ಹೇಳ್ಬೇಕು ಯಾವ ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು to
second, third.
2-3 days ನಾನು ಹೇಳ್ತೀನಿ.
List on third. Yes, Mr. H.C. Shivram.
That's I think new survey number 3/5 ಅಂತ ಹೇಳಿದ್ರು. ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ 3/5 ಅಂತ ಹಾಕಿದ್ದಾರೆ.
3/3 bracket ಅಲ್ಲಿ new survey number 3/5 ಅಂತ ಹಾಕಿ. Yes, Mr. H.C. Shivram. What is this issue? What is the issue in this?
ಅದರಲ್ಲಿ I want to implement my lord ಜನಾರ್ದನ್ ಈ ಕೇಸಲ್ಲಿ.
ನೀವಿದ್ದೀರಾ ಇದರಲ್ಲಿ?
ಇದರಲ್ಲಿ ಇನ್ನು ಅರ್ಲಿಯರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಯಾರನ್ನ ಇಂಪ್ಲೀಟ್ ಮಾಡಬೇಕು?
ಜನಾರ್ದನ್.
ಫಸ್ಟ್ ಇದು ನೋಡ್ಲಿ, ಇದು
ಇದೆ ಸೈಟ್ಸ್ ಇದೆ ನೋಡ್ಕೊಬಹುದು.
ಫಸ್ಟ್ ಇವ್ರು ಒಪ್ಕೊಳ್ಳಿ, ಅವ್ರು ಬಿಡಿ ಅವ್ರು ಒಪ್ಕೊಳ್ಳಿ, ಒಪ್ಕೊಂಡ್ಮೇಲೆ ತಾನೆ. ಎಸ್
33 ಶಿವರಾಮ್
ಮಿಸ್ಟರ್ H.C. Shivram.
Saturday last year. Saturday, we called Saturday. 29.
Learned counsel for the petition seeks time. List on Saturday.
Much.
Tejas SR.
Number 34.
Directions was issued to BDA to rectify certain same.
This is the case where we had inserted one new site numbers, G1 number. 6 properties ಗೆ notice issue ಮಾಡಬೇಕಾಯ್ತು.
ಮಾಡಿದಿರಾ?
ಮಾಡ್ತಾ ಇದೀವಿ. Today or tomorrow it will be issued.
The learned counsel for the respondent number 1 to 3 seeks time. To comply the order dated 13/8/2026. List on yavat?
2 weeks.
Code yes. Next.
Great.
Vasant Kumar HT.
Page number 35. Person.
Can you pass over, my lord?
Pass over. Yes, pass over.
Serial number 36, Abhishek Gowda, age.
I
Abhishek.
appear for the petitioner.
Ah.
The show cause notice issued by the task force cell of BDA is challenged. Well, it's just two, I'll give only two dates.
Yeah.
Well, it's 13/1/2016.
13/1.
2016.
Ah.
BDA allots 11 alternative sites in favor of my vendor.
Ah.
About 3 months to 6 months later, minutes between March to June, I purchased those sites in 2016. In 2021, the show cause notice is issued by the task force cell of BDA summoning me for an inquiry. But my submissions are only twofold. One, the task force cell does not have any jurisdiction to summon and look into allotments. Even if they were to do so, minutes, that to summon their officials, not me.
Where is the notice?
Minutes, Annexure A, page 11.
Please read that.
Please, minutes. ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಸುವುದೇನೆಂದರೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಬೇಗೂರು ಹೋಬಳಿ ಅರಕೆರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 80/1 ರಲ್ಲಿ 3 ಎಕರೆ 26 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಭೂ ಮಾಲೀಕರಾದ ಶ್ರೀ ಕೃಷ್ಣಾರೆಡ್ಡಿರವರಿಗೆ ಪ್ರಾಧಿಕಾರದಿಂದ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಜಮೀನಿನ ಭೂ ಪರಿಹಾರ 2 ಎಕರೆ ಜಾಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶೇಕಡ 50% ಅಂದ್ರೆ 1 ಎಕರೆ ಜಾಗ ಅಥವಾ 43,000 ಚದರ ಅಡಿ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಕೊತ್ನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ 15x24 ಮೀಟರ್ ನಿವೇಶನಗಳ ನಂಬರ್ 24 to 28, 31 to 36 ಒಟ್ಟು 11 ನಿವೇಶನಗಳು ಜಮೀನ್ದಾರರಿಂದ ಪರಿತ್ಯಾಜನ ಪತ್ರ ಪಡೆದುಕೊಂಡು ಶ್ರೀ ಕೃಷ್ಣ ರೆಡ್ಡಿರವರ ಜಿಪಿಎ ಪ್ರತಿನಿಯದ ಶ್ರೀ ಕೆ ನಾಗರಾಜ್ ರವರಿಗೆ ಹೆಸರಿಗೆ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರ ನೋಂದಾಯಿಸಲಾಗಿದ್ದು ಸದರಿ ನಿವೇಶನಗಳು ಪೈಕಿ ನಿವೇಶನ 31, 32 ಸೋ ಅಂಡ್ ಸೋ ಅಂಡ್ 36ನೇ ನಂಬರಿನ ನಿವೇಶನಗಳು ತಾವುಗಳು ಖರೀದಿಸಿರುವ ಸಂಬಂಧ ವಿಚಾರಣೆಗಾಗಿ ಈ ಸೂಚನಾ ಪತ್ರ ತಲುಪಿದ 7 ದಿನ ಒಳಗೆ ತಮ್ಮ ಗುರುತಿನ ಚೀಟಿ ಹಾಗೂ ವಿಸ್ತೀರ್ಣದ ಇತ್ತೀಚಿನ 2 ಪಾಸ್ಪೋರ್ಟ್ ಸೈಜ್ ಭಾವಚಿತ್ರಗಳೊಂದಿಗೆ ಕಚೇರಿ ಸಮಯದಲ್ಲಿ ವಿಚಾರಣೆಗಾಗಿ ಹಾಜರುಪಡಿಸಿಕೊಂಡು
What is your authority to do so? How can you summon him?
This is only for an inquiry.
For what? Krishna Reddy has not made any allegation.
No.
Who are you?
Lord, special task force, Lord, is empowered to the government notification. Whenever there is a land grabbing or violation or unauthorized encroachments or unauthorized constructions, they have got every power to issue notice to the concerned persons.
But really the allegation, unauthorized.
There are two aspects, Lord. One
Ah.
is they are saying that I have no power at all. The
That is
second
fine.
even if I have a power, suppose if you lodge to the opinion that it does not bristle with details, I may be permitted to give a fresh notice to them. That's it.
Barkul. The petitioner has called in question a notice bearing number so and so dated so and so issued by the respondent number 4. Should have properly described respondent number 4. He is
police inspector.
Arakshaka Upadikshakaru is not police
Special task
inspector.
force.
He is a superintendent, deputy superintendent of police. DYSP alva.
Please.
You called him, you call the DYSP as a
police inspector. My apologies.
You're reducing him in rank.
Please. My apologies.
Notice bearing number so and so dated so and so issued by the deputy superintendent of police, special task force, Bangalore Development Authority, by which she was called upon to furnish documents in respect of the acquisition of site number 31, 32, 33, 34, 35 and 36 formed in survey number 80/1 of Arakere village. Next paragraph. Petitioner contends that Petitioner contends that the respondent number 2 had allotted 1 acre of land, allotted 43,000 square feet of land in survey number 77/2, 78, 80/2A, which is this layout?
JP
of
Nagar 8th phase.
2A, JP Nagar's 8th phase, 3rd block, to the land loser in survey number 80/1 of Arkere village, Begur Hobli, Mangalore South Taluk, as compensation for the acquisition of his land. Full stop. Petitioner claims that she purchased 6 sites out of the aforesaid 43,000 square feet in terms of various sale deeds for valuable consideration. She also entered into a joint development agreement for development of the aforesaid sites. Full stop. After the construction was commenced in the aforesaid sites, the respondent number 3 issued a show cause notice calling upon the petitioner to appear before him for an inquiry. Full stop. Inquiry regarding the 6 sites purchased by the petitioner. The petitioner, being agreed with the said notice, is before this court. Next, the learned counsel for the petitioner contends that the respondent number 3 and 4 have no authority in law to call upon the petitioner to appear before it for an inquiry in respect of sites lawfully purchased by the petitioner. He contends that the notice issued by the Deputy Superintendent of Police Special Task Force is as bald as it could be, as it is not mentioned in the notice that the petitioner has encroached into any other portion of the layout formed in JP Nagar 8th phase. And there is no allegation of whatsoever nature regarding the purchase by the petitioner. He therefore contends that the impugn notice is issued at the behest of the respondent number 3 to meet personal scores rather than conducting a genuine inquiry. Stop. The learned counsel for the respondents 2, 3 and 4 on the other hand submitted that the respondent number 3 is entitled to conduct an inquiry to ascertain whether there is any encroachment into any property belonging to the respondent number 2 and take necessary steps. He contends that the petitioner cannot assail the competence of the respondent number 3 to conduct such an inquiry. However, when the court questioned as to what was the allegation against the petitioners which warranted an inquiry, the learned counsel for the respondent number 2 and 3 was unable to point out to the real reason for an inquiry into the sites purchased by the petitioner. In that view of the matter, as the notice issued by the Deputy Superintendent of Police Special Task Force BDA, he is bald and does not set out the reasons for doubting the sale deeds executed in favor of the petitioner by the owner of land in survey number 80. Then madam,
8/12/21.
Owner of the land in survey number 80/1 who was granted the developed land as compensation in survey number 77/2, 78, 80/2A of JP Nagar 8th phase, the impugned notice is liable to be set at naught. In that way of the matter, this petition is allowed. The impugned notice issued by the Deputy Superintendent of Police, Special Task Force, BDA, bearing number is quashed. It is however open for the respondent number 3 to issue a fresh notice setting out the particulars as to why an inquiry is necessary insofar as the sites purchased by the petitioner. Full stop. It is needless to mention that the respondents 3 and 4 shall not take any action against the petitioner until fresh notice is issued and proceedings are concluded in accordance with law.
But the issue of jurisdiction may be left open.
All other contentions regarding the competence of the respondent number 3 to conduct an inquiry is kept open.
Please. Grateful.
Serial number 37, PB Raju.
PB Raju.
Serial number 32 ಅಲ್ಲಿ ಮತ್ತೆ ಕಾಪಿ ಕೊಟ್ರೆ I will be able to.
ಕೊಡಿ.
Directions.
ಯಾವ್ದು ಇವತ್ತಿನ ಆರ್ಡರಾ? I will upload it. By evening we'll upload it. Yes, PB Raju.
I have challenged the police notice issued by the BMTF.
Pardon?
The annexure K is the police notice issued by the Metropolitan Task Force. My lord, there are some fresh other developments, my lord. Thereafter, my lord, the BMTF has issued a notice in 2023.
PDA park ಜಾಗದಲ್ಲಿ ಕೆಲವು ಭೂ ಕಬಳಿಕೆದಾರರು.
My case is that it is an odd site and it is not a park. And my lord, I have already filed a suit. My lord, this matter was a subject matter of a joint development agreement where one Celestial Parks firm, the 7th respondent, would enter into a consolidated with myself and several others. Insofar as I am concerned, 93/1, there is only an agreement of sale. The others sale deed ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. Because he did not pay the money in respect of my portion of land, I have filed a suit to annul the plan insofar as it's concerned 93/1. Comprehensive suit is pending. BDA also party madi suit is pending. Right now, I have come before this court in view of this police notice which was issued. And my specific contention is the construction is on the odd site and some third party has given a complaint telling that it is a park area. As per the plan which I produced and the interim order also passed by this honorable court, it is noticed that it is an odd site and not a park area or a road area or any civic community position. That is the position.
Police notice ಕೊಟ್ಟಿದ್ರೆ go and participate in the inquiry.
On 10 days time, I'll consult my counterpart and see how best to go about this.
BMTF, Lord, I'm told BMTF has closed the complaint on the ground that writ petition is pending here. Because there is an interim order passed by your lordship that BMTF has not continued any further.
I to go and appear before the BMTF.
ಮುಂದಿನ ವಾರ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
You already
ಸೂಟು ಹಾಕಿದೀನಿ ಕಾನ್ಫರೆನ್ಸ್
ಸೂಟ್ ಹಾಕಿದ್ರೆ ಸರಿ. BMTF ಮುಂದೆ ಹೋಗೈತೆ ಇಷ್ಟು ದೊಡ್ಡ ಬಿಲ್ಡಿಂಗ್ ಬೇರೆ ಕಟ್ಟಿದ್ರ ನೀವು.
ಬಿಲ್ಡಿಂಗ್ ಅಪ್ರೂವ್ಡ್ ಪ್ಲಾನ್ ತಗೊಂಡು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದೀನಿ. ದೊಡ್ಡತೂಗೂರು ಪಂಚಾಯತಿಯಿಂದ ಬಿಲ್ಡಿಂಗ್ ಪ್ಲಾನ್ ತಗೊಂಡು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದೀನಿ.
Abhaya mansion. Abhaya. You named it Abhaya. When the bulldozer comes, what will you name it?
What is it called?
You called it Abhaya.
ಒಂದು ಪೇಯಿಂಗ್ ಗೆಸ್ಟ್ ಏನೋ ಕಟ್ಟಿದ್ದಾರೆ. ಪೇಯಿಂಗ್ ಗೆಸ್ಟ್
ಬಿಲ್ಡಿಂಗ್ ಹೆಸರಿಟ್ಟಿರೋದು ಅಭಯ ಅಂತ. ಅಂದ್ರೆ ಭಯನೇ ಇಲ್ಲ ಅಂತ, ಭಯನೇ ಬೇಡ ಅಂತ. But what happens if a bulldozer comes?
That is true.
ಅವಾಗ ಏನು ಹೆಸರಿಡ್ತೀರಾ?
10 days time.
List on zones. Learned counsel for the petitioner seeks time. List on zones.
11th September.
Yes, Mr. KM Somsekhar.
Okay, Somsekhar KM.
Appear for the petition. Lord, last date of hearing, my lord, the BDA has come up with a statement that, my lord, in respect of site number opposite to the petitioner site number, my lord, 782, 783, 784 are not yet allotted to anybody.
Close ಮಾಡ್ತೀವಿ ಅಂದ್ರು.
Please,
You said you will enclose it.
Please, we have taken steps, my lords. ಒಂದು 2-3 ದಿವಸ ಬೇಕಾಗುತ್ತೆ, ಕಾಂಪೌಂಡ್ ಕಟ್ತಾ ಇದೆ.
Compound ಕಟ್ತೀವಿ. The learned counsel for the respondent Respondents submit that pursuant to the order dated 28/2026, the respondents are taking steps to enclose site numbers 782, 783 and 784 and seeks time to report complaints. List on
Next week minutes.
any date is next.
3rd September.
Take whatever date you want.
3rd September.
Is number 39, Kritika Raghavan.
Kritika Raghavan.
There was a public auction. I was a successful bidder. But that was, of course, 2000. Thereafter, my lord, the BDA said, if you there's some suit, my lord, writ petition which was pending. Therefore, if you are willing to wait, please wait. Please come to my lord the order, letter of the BDA dated at page 24. First paragraph, last 3 lines. Option to seek refund in case the highest builder is not willing to wait till the disposal. We said, my lord, we will wait. Next page only, 25. Then, my lord, the writ petition ultimately came to be dismissed. My lords get that, my lord, at running page 43. A writ appeal was filed. I did not file it, somebody else had filed it. I was a successful bidder in that auction. 52, my lord, is the writ appeal. That also came to be dismissed in 2010. Then they said there's a suit pending. Suit, my lord, came to be disposed of in 2006.
You are also party in that writ appeal. Page 52.
52 only, yes.
You are a party.
Yes, yes.
Yes.
Because I was a successful bidder, they made me as a party. Then, my lord, the suit was filed. Suit also came to be dismissed. Please come, partly allowed. Please come to my lord, running page 57.
Yes.
If my lords come to my lord, the last page at page 72. Defendants are, my lord, are restrained from interfering with the peaceful possession of the plaintiff therein. In that suit, my lord, one Prem Kumar. Till, my lord, he is dispossessed in accordance with due process of law. Now what they do is, they dispossess him. Don't intimate me. I file, my lord, a writ petition. Now in the writ petition, my lord, their contention is, well, there's a delay.
Suit is filed by whom?
By one Prem Kumar, my lord, saying that, my lord, he is in possession and all that.
He was a person who had filed the earlier suit, earlier writ petition.
Earlier writ petition, my lord, was filed by one, my lord, Guru Das.
Not Kannur. It's very uncommon names. Even I was thinking. He name Barodela. One day Gurudas Man and
Now, my lord, their contention is, now then they not bring it for auction.
Hello, who is this Prem Kumar?
Prem Kumar is one person, my lord, claiming that he is in possession.
Erstwhile landowners.
Erstwhile landowner.
They had challenged the acquisition.
Allah, Guru Das challenged it, no?
Guru Das, Narayan Das and Dharma Varta.
Prem Kumar filed a suit.
He is one of the.
He was a tenant, I believe.
Tenant,
Haudu.
Tenant of the erstwhile landowner.
Correct. 58 ali tav bandre. Para 2, my lord. Last 1, 2, 3, 4, 5, 6 lines from the bottom.
Niranjani Srinivasan.
Plaintiff was a tenant of Dr. Niranjani Srinivasan from the year 83 on a monthly rent, so and so. So, my lord, he filed it. At any rate, my lord, thereafter, my lord, they evict him. They don't even intimate me. I file a writ petition. Now their contention is that the delay. My submission is I have waited, my lord, all along. The deposit, my lord, is with them only, 25%. That's all.
Similar circumstances, the lordship sees and learned senior was not there. But I brought your lordship's notice, my lord, the orders up till Supreme Court, which is against us. In fact, if the lordship would recall, your lordship said, my lord, that you return the money with 21% interest and pay a penalty of 10 lakhs. But we were agreeable. Then, my lord, the BDA advocate, my lord, he pointed out, in similar circumstances, my lord, what happened was in the writ was filed. So the learned single judge said, give them the site with that amount, whatever is the balance to be taken. No interest to be levied by BDA. writ appeal was filed by VDA, my lord, the division bench also, my lord, upheld the order of the learned senior. However, my lord, the Honorable Supreme Court said that both are at fault, and since you have also retained that balance amount, you pay 21% interest. But I had produced it on the last occasion.
Yes. Then are you willing to accept that?
The Supreme Court judgment copies.
ಗೊತ್ತಾಯ್ತು. Only thing is,
Same option then. ಇದೇ ಆಪ್ಷನ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಸೇಮ್ ಓನರ್ಸ್ ಹೂ ಹ್ಯಾಡ್ ಚಾಲೆಂಜ್ ಇನ್ನೊಬ್ಬರು ಅಲ್ಲ ದಿಸ್ ಆಕ್ಚುಲಿ ಇಸ್ ಅ ಲಾಸ್ ಫಾರ್ ಅಸ್ ಮಿಲಾಟ್
Loss ಏನಿಲ್ಲ.
what your lordship said milaud that would have been beneficial milaud even 20 lakhs penalty also we would have paid.
Allah, but
we are allowed to pay return
no, but then now the Supreme Court has said 21% interest.
they'll have to give us on the balance amount which they have to pay. 25% they have given. They have to pay the balance amount.
So the same
21% interest.
Is, are you willing?
ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಂಡ್ ಆಲ್ ಆರ್ ಯು ವಿಲ್ಲಿಂಗ್ ಅಂತ ಸೈಬರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Only thing is, my lord, whether because of 142 ತಾವು ರೆಡ್ಯೂಸ್ ಮಾಡಿ
ನೀವು ಡಿಲೇ ಇಸ್ ಅಟ್ರಿಬ್ಯೂಟಬಲ್ ಟು ಯು. ಆ ಕೇಸಲ್ಲಿ ಅದೇ ತರ ಇತ್ತಾ?
Very same, the lordship kindly see the orders passed by the learned senior judge, the honorable division bench and the Supreme Court which have produced. Same, my lord, it's under the same option, same letter, same adjacent property only, same letter, everything same. I can, if the lordship were to take the honorable Supreme Court order, my lord, I'll just point that out on the last occasion which we had given. So that is SLP
16 of 2026.
You have got it. There, my lord, the lordship may come to para 7.
Then are you willing to take this?
Yes, my lord, same site, my lord, we are willing to, my lord.
Same site.
Yes, yes.
We can dispose it of on the
Yes.
similar terms.
Yes.
Very cool. The petitioner,
Letter ಬರ್ದಿದ್ದಕ್ಕೆ ನಮ್ಗೆ ಇವತ್ತು
the petitioner sought for it in the nature of mandamus to direct the respondent to confirm the sale of site number 4120 formed in survey number 58/5 and 60/4 of Yadur.
Banashankari second
was
stage.
Yadur,
Banashankari second stage.
Yadur, Banashankari second stage, which was auctioned on 8/5/2000. Petitioner has also sought for it in the nature of mandamus to direct the respondent to expedite the process of confirming the sale of the aforesaid site. Next part. Petitioner contends that the respondent issued a auction notification dated to auction. The auction date, though, what is the publication date? Issued an auction notification to auction various sites, including site number 4120 formed in survey number 58/5 and 60/4 of Yadur, Banashankari second stage, Bangalore. The petitioner was a successful bidder in respect of site number 4120 at the auction held on 8/5/2000. Full stop. The petitioner was required to deposit 25% of the bid amount at the spot, and the balance was to be payable within 45 days from the date of a letter of intimation from the respondent. Petitioner contends that he deposited 25% of the auction amount
total was 72,50,400.
on 8/5/2000 itself. Full stop. The respondent on 5/6/2000 issued a letter bearing number so and so, informing the petitioner that this court had granted an interim order staying the confirmation of the auction sale in WP number 16141-16143 of 2000. Full stop. The petitioner then addressed a letter to the finance member of the respondent requesting for the status of the proceedings before this court in WP number so and so, and further inquired of whether when the interim order would be vacated. Full stop. Thereafter, he addressed a letter dated 5/11/2011 requesting the respondents to confirm the sale. The respondent, with its letter dated 21/12/2011, informed the petitioner that a suit in OS number 2513 of 2000 was filed against the property in question by one Mr. Prem Kumar. Where and that the said suit was decreed.
Partly decreed, my lord.
Decreed, partly ಅಂತಿಲ್ಲ, partly ಇಲ್ಲ.
ಹೌದು.
ನೋಡಿ, partly ಅಂತಿಲ್ಲ.
ಅಂದ್ರೆ ನಾವು ಹೇಳಿದ್ದು, because if your lordship sees what they have said is, till he disposes, my lord, in accordance with law ಅಂತ ಮಾಡಿದ್ರು ಅಷ್ಟೇ.
Partly ಅಂತಿಲ್ಲ.
I stand corrected by your lordship. I stand corrected by your lordship. Decreed ಅಂತಾನೆ ಇದೆ. Your lordships are absolutely right.
Was decreed, restraining the defendants therein from dispossessing him except without following the due process of law. Full stop. Petitioner contends that in terms of a letter dated
5/6/2000.
5/6/2000,
my lord.
5/6/2000, the respondent had informed the petitioner to either wait until this court vacates the order of stay or seek refund of the amount deposited. The petitioner, in terms of his letter dated 23/12/2002, sentence. Petitioner contends that the respondent issued similar replies on 21/2/2012 and 27/4/2012 to the notice issued by the petitioner on 16/1/12 and 12/3/2012. Full stop. Thereafter, WP number 16141-16143 of 2000 was dismissed by this court with an order dated 18/8/2003, which was challenged in the writ appeal 7199/2003. Full stop. The division bench rejected the appeal with its order dated 28th of August 2010. Thereafter, therefore, the respondent was not in a position to confirm the sale. Though the petitioner issued multiple requests for confirming the auction sale. Full stop. Petitioner contends that he was always ready and willing to pay the balance auction price and accept the site that was sold in his favor. However, it is the respondent who was dilly-dallying over the issue, and therefore the petition is there before this court seeking for a direction to the respondent to confirm the sale. Full stop. Objection ಹಾಕಿದ್ದೀರಾ?
Objections ಹಾಕಿದ್ದಾರೆ.
13/12
ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. 13/12 ನೋಡಿ. ನಾನು ಕೊಟ್ಟಿರೋ ಡೇಟ್
ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಇದೆಯಾ? ಕೊಡಿ.
ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ. The statement of objections is filed by the respondents. ಇದೆಯಾ? ಇದೆ ಅಂತ ಇಲ್ಲಿದೆ ಬಿಡಿ. The statement of objections is filed by the respondents, where it is contended that the petition is liable to be dismissed on the ground of delay in latches. It is claimed that the auction was held on 8/5/2000 and the writ petition is filed after nearly 22 years. And therefore, the petition is liable to be dismissed as it is highly belated.
You know that.
It is contended that at the auction conducted on 8/5/2000 in respect of site number 4120, the petitioner had quoted a sum of rupees 14,900 per square meter, and the total bid value was a sum of rupees 72,50,042. So as per the terms of the auction, the petitioner had deposited 25% of the bid amount.
17.
However, several persons had filed WP number 16141-16143/2000 and 16177/2000 and 16198-202/2000, contending that the land in survey number 60/4 of Yadiur village was deleted from acquisition and that they are the owners of the land and hence questioned the auction notification. Therefore, it is contended that the respondent could not confirm the auction of the site in question in favor of the petitioner. The writ petitions were rejected in terms of an order dated 18/8/2003 and the respondent was directed to maintain status quo for a period of 8 weeks. Full stop. The petitioners, the unsuccessful petitioners in WP number 16141 of 2000 and other petitions filed writ appeal 7199/2003, which was also dismissed in terms of an order dated 20th of August 2010. In the meanwhile, one Mr. Prem Kumar filed OS number 2513 of 2000 for perpetual injunction in respect of the site number 4120, which was decreed in terms of a judgment and decree dated 9/3/2016, whereby the respondents herein were restrained from interfering with his possession except without following the due process of law. It is contended that though the auction was held on 8/5/2000 in view of an interim order granted by this court in the writ petition referred supra, the auction confirmation committee did not confirm the auction of this site bearing number 4120 in favor of the petitioner. And hence it decided to inform the petitioner about the litigation and the interim order and granted an option to the petitioner to seek refund of the deposited 25% amount or wait till the disposal of the writ petition. It is contended that the respondent has already written to the petitioner to collect the 25% of the bid amount deposited. However, the petitioner did not do so. And after nearly 22 years, the petition is before this court. Full stop. The learned senior counsel for the respondent, while elaborating on the submission on the statement of objections filed, submitted that under the very same auction, a site bearing number 4114 of Banshankari second stage was also auctioned, and the successful bidder had deposited 25% of the auction of the bid amount. However, due to the pending litigation, the auction could not be confirmed, and hence an endorsement was issued to the petitioner therein to pay interest.
Yes, Malord.
To pay interest on the balance auction price payable, which was questioned in WP number 11759/2024. He contends that the writ petition was allowed and the respondents were directed to collect the balance consideration and execute necessary deeds of transfer. He contends that this order of the learned single judge was questioned in writ appeal 1865/2024, which was dismissed.
Yes.
which was dismissed with a order dated 17/10/2025. Thereafter, the respondents challenged the same before the Honorable Supreme Court in SLP Civil 16/2026. Full stop.
16/4/2026.
He contends that with a order dated 16/4/2026, the Honorable Supreme Court directed the auction purchaser to remit the balance auction price along with interest at 21% per annum, and the respondent was directed to conclude the auction sale by executing necessary deeds of transfer. He therefore contends that even the present case, the petitioner is bound to pay the balance sale consideration along with 21% interest from the date the same became payable till the date it is paid. Full stop. The learned senior counsel for the petitioner, after securing instructions, submitted that the petitioner is willing to pay balance auction price along with interest at 21% per annum from the date the balance price became payable till the date it would be paid. Full stop. In that view of the matter, the writ petition deserves to be disposed of, directing the petitioner to pay the balance auction price along with interest at 21% per annum from the date the balance amount became payable till the date it is paid. Full stop. The petitioner shall pay the same within a period of 3 months from the date of receipt of a copy of this order. Full stop. Upon payment, the respondent shall ensure that appropriate deeds are executed, transferring the title of the site bearing number 4120. 4120, formed in survey number 58/5 and 60/4 of Yedur, Banshankari, second stage, Bangalore, within a month thereafter.
Please.
Yes. Uh-huh. ಅದೊಂದು sentence Prem Kumar filed in respect to claiming it to be a revenue site bearing number 17 in survey number 60/4. Yes, next.
In fact, litigation had ended in 2016. Now 2016 the interest ಕೊಡಬೇಕು.
They have also retained the money. We also think so. Please, what is this?
You're still a winner, sir.
They're still a winner, my lord. We are ready to even pay even 40% interest on that amount and give it back, please.
Yes.
Number 40, Sundaresh HC.
HC Sundaresh.
It was also shown in the allotment list.
Yeah, other side,
My lords, I appear for PDA in this matter, my lords.
Yes.
ಇದ್ರೊಳಗೆ ನಾವೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಫೈಲ್ ಇಟ್ ವಾಸ್ ಸೆಂಟ್ ಟು SP office for some enquiry. We are unable to place the file on record, my lords. So 1 week
It's
time.
not correct. No, your lords may kindly see. That is not correct, my lord. Your lords may kindly see. At least, my lord, your lord, kindly page 20.
But our file ilvantalla ಏನು ಮಾಡೋದು? What instruction will she get?
After
Last
scrutiny
time
of
I had produced a few documents along with memo.
2 times, my lord, the file was transferred to the STF. STF has submitted a report. On the basis of the report, my lord.
Last time documents ಹಾಕಿದ್ರು ಅಂತಲ್ಲ.
ಇಲ್ಲ, last time ಹಾಕ್ಲಿಲ್ಲ. Document ಕೊಡ್ಲಿಲ್ಲ. Allotment
We filed few documents along with the memo.
When will I keep it? When should I keep it?
1 week, my lords.
Next
3rd,
Thursday.
4th. Yes, my lords.
List on learned counsel for the response 1 to 3 seeks time. List on Thursday. Devendra.
Number 41, Devendra.
Only Krishna.
PDA has to comply this honorable court last occasion.
ಏನಂತ?
Reduce the 10% amount. With
Because my lord, there's another unsuccessful bidder who has paid by who has bidded for a price or amount higher than that 10%.
No, it doesn't matter. See, he is saying.
I understand, my lord, our lawyers are there, they could not identify the.
Corner site ತಾನೆ? Corner site.
Page number 19.
He is willing to take an intermediate site. 10% ಕಡಿಮೆ ಮಾಡ್ಕೊಡಕ್ಕಾಗಲ್ವಾ?
ಇಲ್ಲ. PDA said no answer. 10%
Yes, which is the other intermediate site you are willing to give him?
Yes, he said he wants same site. Same site is an intermediary site only.
So reduce 10%.
It applied thinking that it was a fund site.
I think now he is willing to take that only.
He wants 10% less.
I will direct you to pay 10% less.
Are you certain, sir, Manoj, that they are not willing to pay?
Barcode. The petitioner has sought for a writ in the nature of certiorari, setting aside the letter of confirmation of site. Then reference of annexure A. Has called in a certiorari to quash the letter of confirmation of site, hearing number 708 bar A in survey number 46 bar 3A of further extension of Anjanapura 5th G block. Insofar as it relates to, ಈ ಕನ್ಫರ್ಮೇಶನ್ ಬೇಡ ನಿಮಗೆ?
ನೋ ಮೈ ಲಾರ್ಡ್, ಕಾರ್ನರ್ ಸೈಟ್ ಕೊಡ್ತಿ ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿದ್ದಕ್ಕೆ ಸ್ಟೇ ಕೇಳಿದ್ವಿ. 45 ದಿವಸದಲ್ಲಿ ದುಡ್ಡು ಕಟ್ಟಿ ಅಂತ, ಅದಕ್ಕೆ ಸ್ಟೇ ತಗೊಂಡ್ವಿ ಸರ್. ಫಸ್ಟ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್
Insofar as it ಬೇಡಮ್ಮ. Next pair. He has also sought for a direction to the respondent to allot a corner site to the petitioner in lieu of site number 708 bar A. Next para. Petitioner contends that the respondent published an advertisement on its website and also in the daily newspapers inviting e-bids for corner sites, specifically corner and intermediate sites. Full stop. The petitioner desired to purchase a corner site and hence he applied on 18/3/2023. Full stop. The respondent had geotagged the corner site so that the bidders could have a glimpse of the corner site. Full stop. Petitioner contends that he participated in the e-auction held on 18/3/2023 and the bid of the petitioner was confirmed with a e-auction advice letter hearing number BDA/FEANJ-AUC/FEANJ-5G/708/A/2022-23 dated 23/2023. He also deposited a sum of rupees 16,47,950 on 23/3/2023 and a sum of rupees 4 lakhs at the time of
17/3/23
on 17/3/23.
Annexure C
Full
and
stop.
D.
He therefore full stop. He contends that he remitted a further sum of rupees 4 lakhs, taking the total amount deposited to a sum of rupees 20,47,950. Full stop. Petitioner claims that after the bid was accepted and he paid the entire consideration. Well, he paid the, he paid 25% of the consideration, comma, a letter of confirmation was issued by the respondent wherein the site bearing number 708 bar A was shown as an intermediate site and not a corner site. Full stop. The petitioner is therefore before this court challenging the letter of confirmation on the ground that what was auctioned and what was confirmed are two different sites. Full stop. When this, the objection hakidira?
But my contentions are.
Full stop. The learned counsel for the respondent orally objected to the writ petition,
Always a intermediate site.
contending that 807 bar A was always an intermediate, 708 bar A was always an intermediate site.
My lord,
No.
clause 9 of the general terms and conditions for e-auction says that geotag location of the auction site is a reference only. No
And,
claim will retain if there are any.
And the petitioner cannot take advantage of the geotagging to contend that what was contend that site 708 bar A was a corner site in view of a specific instruction to the bidders at clause number 9. Illide the page number? At clause number 9, which provided as follows. Provided as follows. ಕನ್ನಡದಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ಹರಾಜು ನಿವೇಶನಗಳ ಜಿಯೋ ಟ್ಯಾಗ್ ಲೊಕೇಶನ್ ಅನ್ನು ಗುರುತಿಸುವಿಕೆಗೆಂದು ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾವುದೇ ವ್ಯತ್ಯಾಸಗಳಿದ್ದಲ್ಲಿ ಯಾವುದೇ ಕ್ಲೈಮ್ ಅನ್ನು ಪರಿಗಣಿಸಲಾಗುವುದಿಲ್ಲ.
ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿದೆ ಪೇಜ್ 20ರಲ್ಲಿ.
ಎಲ್ಲಿದೆ?
ಕಾರ್ನರ್ ಸೈಟ್ ಅಂತಾನೆ ಮಾರಿದ್ದಾರೆ.
ವೇರ್ ಇಟ್ ಇಸ್ ಇದು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳೋಣ.
ಅದೇ ಕೊಟ್ಟಿರೋದು. ಅಲ್ಲ ಅದೇನೆ.
ಬರ್ಕೊಳ್ಳಿ. ಜಿಯೋ ಟ್ಯಾಗ್ ಲೊಕೇಶನ್ ಆಫ್ ದ ಆಕ್ಷನ್ ಸೈಟ್ಸ್ is for reference only. No claim shall be entertained if there are any discrepancies relating to it. He therefore contends that it was incumbent upon the petitioner to visit the site before submitting his bid. Full stop. He submits that if the petitioner is not willing to accept the corner site number 708 bar A, the respondents are willing to refund the amount. Full stop. Next, I consider submissions made by the learned counsel for the petitioner and the learned counsel for the respondent. When this writ petition was listed on (6/8/2026), the learned counsel for the petitioner submitted that the petitioner is willing to take site number 708 bar A, even if it is an intermediate site, provided the respondent considers reducing the auction price by 10%. The learned counsel for the respondent, after seeking instructions from the respondent, submitted that the respondent is not willing for the same. Next para. I have considered submissions also. A perusal of the notification issued by the respondent would show that what was notified was corner sites and intermediate sites. Full stop. Site number 708 bar A was shown to be a corner site and was geotagged. Full stop. The e-notification specifically mentioned ಎಲ್ಲಿದೆ ಅದೇನೋ ಇತ್ತಲ್ಲ ಅದು ಟ್ಯಾಗಿಂಗ್ ಜಿಯೋ ಟ್ಯಾಗಿಂಗ್ ಇತ್ತಲ್ಲ ಎಲ್ಲಿ ಮೆನ್ಷನ್ಡ್
ಇಲ್ಲಿ ನಾನು ಕೈಯಲ್ಲಿ ಕೊಡ್ತೇನೆ. I filed along with memo that.
ಇಲ್ಲಿದೆ ಸೈಟ್ ಅದು ಎಲ್ಲಿದೆ ಸೈಟ್
ಪೇಜ್ ನಂಬರ್ 19 annexure E
mentioned
further extension of Anjanapura 5th.
ಇಲ್ಲ ಫರ್ದರ್ ಏನೋ ಇತ್ತಲ್ಲ ಅದು mentioned that the bidders may click on the geotag to reach the site, to view the site. Full stop. As for the geotag, site number 708/A was a corner site. However, after the bid of the petitioner was accepted, it appears that the geotag was moved from the corner site to an intermediate site. Full stop.
F.
As per annexure F. Full stop. Therefore, it appears that the respondent, after having realized its mistake in geotagging an intermediate site as a corner site and notifying the same for auction, has undone it by moving the geotag to an intermediate site. Full stop. The petitioner who had submitted his bid considering site number 708/A as a corner site must have paid a higher value than an intermediate site. Full stop. Even the state of Karnataka, the state government, while determining the market value of corner sites, considers 10% of the value of the intermediate site, considers 10% more value of the intermediate site. Therefore, it is appropriate that a full stop. In view of the contention of the learned counsel for the petitioner that the petitioner is willing to accept site number 708/A, if the respondent agrees to give up 10% of the value bidded, of the value of the auction value, he is willing to accept the site, this court considers it appropriate to allow the petitioner to retain the site. And I am not saying you conceded. He is willing. He, not you. Allow the petitioner to retain site number 708/A and direct the respondent to refund, direct the respondent to reduce the bid of rupees 81 lakhs. Is the total value?
81
lakhs 91,800.
81,91,800. $81,91,800.
ಗೊತ್ತಾಯ್ತು ನನಗೆ. And direct the respondent to receive a sum of rupees 73,72,620 towards the full value of site number 708/A, including the amounts already paid by the petitioner. This shall be complied within a period of full stop. Upon the petitioner depositing the said sum, within 1 month from today, the respondent shall execute necessary deeds of conveyance, conveying the aforesaid property to the petitioners within 3 months thereafter.
ನಾವು ಏನು ಒಂದು ತಿಂಗಳಲ್ಲಿ ಕಟ್ಬಿಡ್ತೀವಿ ಲೇಟ್ ವಿತ್ ಇನ್
ಒಂದ್ ತಿಂಗಳಲ್ಲೇ ಕಟ್ಟಿ ಅಂತ ಹೇಳಿರೋದು.
ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ 60,61,932 ಆಗುತ್ತೆ.
Yes.
ಅದಾದ್ಮೇಲೆ 10%.
Within 3 months ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಡ್ತಾರೆ ನಿಮಗೆ.
10% reduce.
10% reduce ಮಾಡಿದೆ.
Publish.
Yes, next.
Serial number 42.
Public.
DP Mahesh, serial number 42.
Mr. DP Mahesh.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿದೆ ಬಿಡಿ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಒಂದು ವೀಕ್ ಟೈಮ್ ಕೊಟ್ರೆ ಅದು ಇನ್ಫೆಕ್ಷನ್ಸ್ ಆಗ್ಬೋದು. ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ.
ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ, ಇನ್ನೇನ್ ಮಾಡಿದಿರಲ್ಲ.
ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
Subject to they conveying the sale deed, it is withdrawn ಅಂತ ಬರ್ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ ಬೇಡ ನೆಕ್ಸ್ಟ್ ಡೀಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊತೀನಿ.
ಅರೆ ಬಾಬಾ, you can always seek for restoration.
ಅವ್ರು ಒಪ್ಕೊಡ್ತೀವಿ ಅಂತ ಅದಕ್ಕೇನಿಲ್ಲ ಸ್ವಾಮಿ ಅಂತ ಹೇಳೋರಂತ. ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅಂತ.
ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಾರಂತಲ್ಲ.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು ವೀಕ್ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೇಕಾದ್ರೆ ಇನ್ನೇ ಡೇಟ್ ಫಿಕ್ಸ್ ಡೇಟ್ ಮಾಡಿ.
You take it. Correct, but you take it now or plan sanction ಆಗೋದಿಲ್ವಲ್ಲ. Yes. ಏನ್ ಯಾವ ಬಫರ್ ಇದು?
ಬೇರೆ ಸೈಡ್ ಇಂದ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಬೇರೆದ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತಲ್ಲ ಇದನ್ನೇನ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಪಾರ್ಟಿ ನೀವು ಹೋಗಿದ್ರೆ ಅಲ್ಲೇ ಹೋಗಿದ್ರೆ ಸರ್.
The relevant counsel for the petitioner seeks time list on so and so. Mr. P. N. Rajeshwar.
Number 43, Rajeshwar P.
Jungle.
Case of double allotment, my lords had directed on the last date of hearing.
Fairly so, after respond for allotted and alternate sale, there also exists serious effort. Yes, cancellation.
BDA has to take steps.
Huh?
The last may kindly see the allotment letter, the sale deed, the site allotted in favor of the petitioner and the respondent, but what is totally different. The last may kindly.
No, but you said something else on the last date.
The alternative site has been allotted to me. Only now they contending that.
That sale deed has to.
ಹೆಂಗಾಗುತ್ತೆ ಸರ್? ನೀವು ಒಂದ್ಸತಿ ಇವ್ರು ಕನ್ವೆ ಮಾಡಿದ್ಮೇಲೆ
ನಾವು ಕನ್ವೆ ಮಾಡಲಿಲ್ಲ.
ಇನ್ಯಾರು?
BDA ನವರು ಡಬಲ್ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ನಮಗೆ ಫಸ್ಟ್ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವು ಕಂಟೆಂಟ್.
My lords, they have filed OS, my lords. Subsequently, they withdrawn that OS. Now they are claiming their rights based on upon sale deed, my lords.
Let the other side come. Yes, Mr.
No, on the last date, my lords have directed BDA to take steps to cancel the sale.
Who is Adarsh Limbika? Idara?
He is online.
He is on record.
He is on record. He is online.
Adarsh Limbika. Adarsh. The learned counsel for the respondent 1 to 4 is absent. As the last chance list on so and so to ensure compliance of the order dated 7/8/2026. Next.
Sundesh Shetty.
Sundesh Shetty.
That appear for the petition in this case.
Charati. Murugesh.
The site was allotted in favor of the petitioner's grandmother, late Puttamma, by the respondent BDA in lieu of acquisition of my property, my site, my lord. Then, my lord, a price was fixed in the allotment letter. The petitioner has paid, the petitioner's mother has paid, grandmother has paid part of the amount. Thereafter, my lord, no steps has been taken by BDA. Then he is not able to. Then, my lord, the petitioner being the granddaughter of the original allottee, she made an application before the respondent for allot of, this is in lieu of acquisition of my land. So then, my lord, Annexure D has been passed by the BDA. Resolution has been passed for allotment of the alternative site in favor of the petition. Your lords may kindly see Annexure D. ಶ್ರೀಮತಿ ಪುಟ್ಟಮ್ಮ ಅವರಿಗೆ ಬನಶಂಕರಿ 3ನೇ ಹಂತ ಸರ್ವೆ ನಂಬರ್ 62 ಕತ್ರಿಗುಪ್ಪೆಯಲ್ಲಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 374 ಸೋ ದಿನಾಂಕದಂತೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗುತ್ತದೆ. ಆದರೆ ನಿವೇಶನ ಮೌಲ್ಯ ಪಾವತಿಸಿದ ಕಾರಣ ನಿವೇಶನ ಹಂಚಿಕೆಯನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದೆ. ತದನಂತರ ಇದೊಂದು ಪ್ರಾಧಿಕಾರವು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಜಮೀನಿನ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಿರುವ ಪ್ರಕರಣವಾಗಿರುವುದರಿಂದ ಮತ್ತು ಹಂಚಿಕೆದಾರರಿಗೆ ಸೂಕ್ತ ತಿಳುವಳಿಕೆ ನೀಡದೆ ರದ್ದುಪಡಿಸಿರುವುದರಿಂದ ಅರ್ಜಿದಾರರಿಂದ ಚಾಲ್ತಿ ದರವನ್ನು ಪಾವತಿಸಿಕೊಳ್ಳುವ ಷರತ್ತಿನೊಳಪಡಿಸಿ ಹಂಚಿಕೆಯನ್ನು ಮುಂದುವರಿಸಿ ದಿನಾಂಕ 22/11/2014 ಆಯುಕ್ತರಿಗೆ ಅನುಮೋದಿಸುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಶ್ರೀ ರಾಜೇಶ್ವರಿ ಅವರು ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಯ ಮೇರೆಗೆ ಇತರೆ ವಾರಸುದಾರರು ನೀಡುವ ಹಕ್ಕು ಬಿಡುಗಡೆ ಪತ್ರದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಿವೇಶನ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಬನಶಂಕರಿ 3ನೇ ಹಂತದ ನಿವೇಶನವನ್ನು ದಿವಂಗತ ಪುಟ್ಟಮ್ಮ ಅವರ ಹೆಸರಿನಿಂದ ಆಕೆಯ ವಾರಸುದಾರ ಮೊಮ್ಮಗ ರಾಜೇಶ್ವರಿ ಅವರ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಲು ಕಾನೂನಿನ ತೊಡಕಿಲ್ಲವೆಂದು ಕಾನೂನು ಅಧಿಕಾರಿಗಳ ಅಭಿಪ್ರಾಯದ ಮೇರೆಗೆ ದಿನಾಂಕ 30/12/2014 ಮಾನ್ಯ ಆಯುಕ್ತರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸಂತೆ ದಿವಂಗತ ಪುಟ್ಟಮ್ಮ ಅವರ ಹೆಸರಿನಿಂದ ಆಕೆಯ ವಾರಸುದಾರ ಮೊಮ್ಮಗಳಾದ ರಾಜೇಶ್ವರಿ ಅವರ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿ ದಿನಾಂಕ 1/1/15 ವರ್ಗಾವಣೆ ಹಿಂಬರ ನೀಡಲಾಗಿರುತ್ತೆ. Then my lord, this is annexure E. ಇದರಲ್ಲಿ the transfer amount has also been deposited by the petitioner. ಮೇಲ್ಕಂಡ ಸೋಂಟ ನಿವೇಶನವನ್ನು ಷರತ್ತುಪಡಿಸಿ ನೀಡಲಾಗಿದೆ. Then my lord, no steps have been taken for allotment of a site. Thereafter my lord, writ petition came to be filed. Thereafter my lord, endorsement came to be issued stating that after lapse of 16 years you have approached the court and hence as per the rules you are not entitled for allotment of site. And annexure L may be kindly visited.
ಇದು ಹಿಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ. It's a incentive side given.
His land, so kindly note, this is not a case where his site was taken and his site was.
ಅದೇ ತರ ಇದು ರೆಸಲ್ಯೂಷನ್ ಅದೇ ತರ ಇದೆ ಅಲ್ವಾ?
ಯಾವ ಕಾರಣಕ್ಕಾಗಿ ನಿವೇಶನ
ಇದೊಂದು ಪ್ರಾಧಿಕಾರವು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಜಮೀನಿನ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಿರುವ ಪ್ರಕರಣವಾಗಿರುವುದರಿಂದ ಯಾವುದು ಪೇಜ್ ಹಾ
next page. There is only a proposal. I don't know whether this proposal is fructified or not. ಇದೇನೂ ಇಲ್ಲ, ಸೈನ್ ಇಲ್ಲ, ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ.
ತಿಳ್ಕೊಳ್ಳಿ ಇದು
ಫೈಲ್ ಸಿಗ್ತದೆ, ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್. This is what is slum allotment seems to be like a slum allotment. It is not allotment for.
No, not slum allotment. This is a case where the housing society site has been taken over by the BDA.
ಏನೋ ಕೊರಮ ಶೆಟ್ಟರ ಹೌಸ್
Society.
ಆ ಸೈಟ್ ಅನ್ನ ನೀವು ತಗೊಂಡಿದ್ದೀರಾ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. Grant counsel for the respondent seeks time to secure instructions list on zones.
Next week,
take whatever date, ಯಾವತ್ತು ಬೇಕು?
Next week.
10 September. Still number 45.
BK Manjunath.
Appear for the petitioner, please.
Yes.
The father of the petitioners, who was a judicial officer, was allotted a site on 2/9/1987, my lord. Site number 386 of Madhalli, further extension. And the entire payment was made. Possession certificate was issued. My lord, they have been from 1987 requesting them to execute the sale deed. Till today, they have not.
Mr. Why you not execute?
My lord, what the petitioner had done is, there is a corner site, my lord, adjacent to that, 387, my lord. They, because of forming of road widening and some underground drainage facilities, my lord, that site got reduced. In the meanwhile, there was 2 feet into 60 feet left, my lord. They encroached on that land and they constructed their site, my lord. Now what we have officer is instructed me is, they will give both, even that will be allotted to them. They should pay that rate fixed by us, my lord. With that together, they
what if you encroach into a marginal land? You're bound to pay it.
Hello, my lord, we are not denying it. What we are playing it, my lord, kindly see the earlier order passed. We were prepared to pay the margin value as on the date of allotment of the site, my lord. Now they are demanding present value. It runs to several lakhs. My lord, and it was allotted on 2/9/87. By mistake, it was constructed.
No, right. See, the marginal land is not allotted to you.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲ
ಅಲಾಟ್ ಆಗಿಲ್ಲ. ಇವಾಗ ಅಲಾಟ್ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಇವತ್ತಿನ ರೇಟ್ ತಾನೇ ತಗೋಬೇಕು.
ಅಲ್ಲ, my lord, what happened to that 2 feet 60 by 60 feet, my lord, it was actually a waste land. People used to have.
ನಿಮ್ ಸೈಟ್ ಕಿನ್ನ ಜಾಸ್ತಿ ಅದು. It is beyond your property. If it is 2 by 60 feet, it is 120 square feet. 120 square feet ಎಷ್ಟಾಗುತ್ತೆ ಇವತ್ತು? 10,000 ರೂಪಾಯಿ ಅಂದ್ರೂ ಎಷ್ಟು? 12 ಲಕ್ಷ ಆಯ್ತು.
ಅದೇ ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ ಮೇಲೆ ಕೈಂಡ್ಲಿ ಸಿ, there was a direction issued by this honorable court on an earlier writ petition. Kindly see my lord, annexure D, ink page 21. Ink page 21. Annexure D, my lord. May I read, my lord? This is the writ petition filed by the wife of the original Alati, Mr. Jairam, who was a retired officer, my lord, judicial officer. My lord, ಇದರಲ್ಲಿ kindly turn to ink page 22.
ಜಯಲಕ್ಷ್ಮಮ್ಮ ಅಂತಿದೆ.
Our wife, ಅವ್ರು ಸತ್ತೋಗ್ಬಿಟ್ರು, our original Alati judicial officer, he died, my lord. Khata was transferred into her name by consent of all the children of the original Alati. My lord, thereafter a writ petition was filed. My lord, kindly see the page 22, my lord, in page 22. These writ petitions are filed under Article 227 of Constitution of India to consider request made by the petitioner and grant convey the marginal land, that is Schedule B property, in favor of the petitioner by collecting the value of said site at the rate which was revealing existing in the year 1992, when the first request was made by the petitioner's husband for grant of said marginal land. We requested them, my lord, we are paying it. Then, my lord, this honorable court directed them, my lord, the operative portion, my lord, I will read. The counsel for the petitioner is absent, even though the matter was called on twice. When the matter was listed on 24th 2017, also he was absent. The petitioner seeks for a writ of mandamus to direct the respondent to consider the representation dated 14/12/2015 wide annexure L. The learned counsel appearing for the respondent submits that if a reasonable time is granted, the same will be considered in accordance with law. In view of the admission made,
You want to take the marginal land at present value or not? Really? Now your site becomes a corner site.
ಅದರಲ್ಲಿ without our knowledge, my lord, that of course, my lord, I concede that there is an encroachment.
ಮತ್ತೆ?
What I am requesting your lordship
And
is,
you
my
call
lord,
yourself a judicial
no, I have
officer.
been, my lord, moving the authorities. ಆವಾಗಲೇ ಅವರು ನಾನು ತಗೋಂತ
Sir, ನೀವು
ಕೊಟ್ಟಿದ್ರೆ
ಬಂದು,
ನಾನು would have-
you made a wrong request. If you had come to this court in the year 2017 and made a request that I am ready to pay the present day value, you would have got it.
ಅಲ್ಲ,
You
ಅದನ್ನೇ-
wanted the value of 1992 when the site was allotted to you. How can you make such a request? 92 ನಲ್ಲಿ it was still a corner site. Road widen ಆದ್ಮೇಲೆ ಅದು ಚಿಕ್ಕದಾಯ್ತು.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಏನಾಗಿತ್ತಂದ್ರೆ,
If you want to take it, you take it.
may make one submission, my lord. At least from my lord, from the date of this order,
No,
earlier
no.
petition order, 2017.
ಇವತ್ತಿನ ಲೆಕ್ಕ ತಗೊಳ್ಳಿ, ದುಡ್ಡು ಕೊಡಿ, ಸೈಟ್ ತಗೊಳ್ಳಿ. That is not fair.
ಅಲ್ಲ, it costs more than 10 lakhs, my
ಏನ್
lord,
ಮಾಡಕ್ಕೆ
for the thing.
Your corner site will, ನಿಮ್ದು ಮಿಕ್ಕಿದ ಸೈಟ್ಗೂ ಡಬಲ್ ಆಗೋಗುತ್ತಲ್ಲ ರೇಟು. ನಿಮ್ ಮಿಕ್ಕಿದ ಸೈಟ್ಗೂ ಡಬಲ್ ಆಗೋಗುತ್ತೆ ರೇಟು.
ಮನೆನೂ ಕಟ್ಟಿದೀವಿ ನಾವು ಅದರಲ್ಲಿ.
Because of the 6 feet by 120, it is 20 feet.
Only 2 feet.
by
width.
60 feet.
2 feet into 60 feet ಇಂದ್ರ ನಿಮ್ ಸೈಟ್ ಕಾರ್ನರ್ ಸೈಟ್ ಆಗಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಇದು ತಕೊಂಡ್ರೆ ನಿಮ್ದು ಫುಲ್ ಸೈಟ್ ಕಾರ್ನರ್ ಸೈಟ್ ಆಗುತ್ತೆ.
ಅದು ನಮಗೆ ಬೇಡ ಸ್ವಾಮಿ, ಬರೀ ಇದಕ್ಕೆ ಇವರು ನಮಗೆ ರಿಜಿಸ್ಟರ್
Will
ಮಾಡ್ಕೊಂಡು
direct him to demolish 2 by,
then it will be a problem.
2 ಅಡಿ 60 ಅಡಿ ಡಿಮಾಲಿಷ್ ಮಾಡಕ್ ಹೇಳ್ತೀವಿ. Please get it demolished.
At least my humble request is from 2017.
RT ನಗರ. RT ನಗರದಲ್ಲಿ ನೀವು.
ಅಲ್ಲ, my lord, I quite realize, but I was not sleeping. My friend, 1970,
Sir, you
kindly
made-
consider this, my lord.
You made a very
Request.
outrageous request. 92ನೇ ಇಸ್ವಿಲಿ ನಿಮ್ಗೆ ಅಲಾಟ್ ಆಗಿದ್ದ ಪ್ರೈಸ್ಗೆ ಇವತ್ತು ಕೊಡಿ ಅಂತ ನೀವು ಕೇಳಿದ್ರಿ. Marginal land was never up for sale. You wanted it. So what you should have asked, 2017 ಹೈಕೋರ್ಟ್ ಬಂದಾಗ ಇವತ್ತಿನ ರೇಟ್ ಅಲ್ಲಿ ಕೊಡಿ ಸ್ವಾಮಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕೊಡ್ತಿದ್ರು. ನಿಮಗೆ 92ನೇ ಇಸ್ವಿದ ರೇಟ್ ಬೇಕು ಅಂತ ಕೇಳಿದ್ರಿ, ಯಾರು ಕೊಡ್ತಾರೆ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ representation to consider ಅಂತ ಇತ್ತು.
No, you
At least let them from 2000.
atrocious request if you make, you will obviously get this kind of orders.
ಅಲ್ಲ, my humble submission, my lord, at least from 2017, your lordship,
No.
whatever the
No,
price that
sorry.
was subsisting in 2017.
Sorry, sir, your representation was to determine the price as it existed in 1992. That representation obviously could not have been considered.
ಅಲ್ಲ, ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಅಂತಲೇ ಅವರು ಹೇಳಿದ್ರು.
What is the rate today?
Will issue
2007.
will Saturday, by Saturday we'll issue the
You give the demand
Yes, ma'am.
for the marginal land, let us see. And ನೀವು don't be.
ಎರಡಕ್ಕೂ ಸೇರಿ ನಾವು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇವರಿಗೆ ಪೇ ಮಾಡಿ ಅದನ್ನ ನಾನು ಟುಗೆದರ್ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ ನಾವು ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಆಫೀಸರ್.
ನೀವು ಅಷ್ಟೇ, don't be,
No, my lord.
don't indulge in arbitrary action.
No, that circular
Don't
is
make arbitrary demands.
based on the circular, my lord. As already lordship I had pointed out. ಅದು ಇದರಲ್ಲಿ ಇದು just one.
ಎಷ್ಟಾಗತ್ತೆ ಅಲ್ಲಿಗೆ?
ಇದರಲ್ಲಿ 2.5 ಅಲಾಟಿ ಆದ್ರೆ ಹಂಚಿಕೆ ಮಾಡಲಾದ ನಿವೇಶನಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ಹಂಚಿನ ಜಾಗವು ಅಗಲದಲ್ಲಿ ಹಂಚಿಕೆದಾರ ನಿವೇಶನ ಅರ್ಧಕ್ಕಿಂತ ಕಡಿಮೆ ಇದ್ದಲ್ಲಿ ಮೂಲ ಹಂಚಿಕೆದಾರರಲ್ಲಿ ಪ್ರಚಲಿತ ದರದ 2.5 ಪಟ್ಟು ದರವನ್ನು ಪ್ರಾಧಿಕಾರದ ವಿಷಯ.
ಇದು ಅರ್ಧಕ್ಕಿಂತ ಕಡಿಮೆ ಇದ್ರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಇದು ಅರ್ಧಕ್ಕಿಂತ ಅಲ್ಲ, ಬರೀ 2 ಅಡಿ 2 feet by 60 feet, my lord.
We have to follow.
But then your entire site will become corner site, sir. The entire site will become corner site. That you not factored. Do you raise a demand? Let us see. Saturday. On Saturday.
46. Nagaraju MC.
MC Nagaraj.
My lord, I appear for Vachan.
57. MC Nagaraj.
My lord, I appear for Vachan.
There is no representation for the petitioner.
Kindly grant 10 days time to.
Vachan appear
file
ಆಗ್ತಾ
objection.
ಇಲ್ವಾ?
I am appearing for Vachan.
Learn counsel for the response 2 and 3 seeks time list also. 47 Lokesh.
18 September.
Ajay Kumar.
47.
Petitioner, my lord.
Directions ಬಂದಿದೆ ಇದರಲ್ಲಿ.
Learn counsel for the response 1 to 3 seeks time list also.
Third, my lord.
ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾಗಿರೋದು ಅವರು.
Since 24 ಎಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೀನಿ.
ಒಂದು ಡೇಟ್ ಕೊಡಿ ಯಾವತ್ತು?
18 September.
ಎಚ್ ಎಂ ಮುರಳೀಧರ್.
48.
ಗೌತಮ್.
Sought for a writ of mandamus
For?
to BDA to issue kata in respect of the site allotted by the first respondent and registered in my favor. The reason why they are not doing it is, number one, you have not produced possession certificate. The society has to issue possession certificate, they have not issued. Number two, though the site allotted by the society to me is there in the sanctioned plan, that is not released by BDA. That is the reason what they are assigning. This matter is covered by the judgment of this honorable court, my lords.
Yes, Gautam.
My lord, I filed my statement of objection, my lord. My lord, this is a cooperative society, my lord. They had to we had released the first part of the sites, my lord. This falls in the third part of the.
ಅದ್ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ, ರಿಲೀಸ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ
ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲ,
ಅದು ಪೇಜ್ ನಂಬರ್ 154 ಅಲ್ಲಿ ಇದೆ. ಅದಕ್ಕೆ ಮುಂಚೆ there are 3 judgments consecutively right from
150
page number 145 to 157. 3 judgments I have cited, my lords. Consistently the courts have said that as long as the site is in the sanctioned layout, release of site is inconsequential to issue kata. Now the situation is, though I have purchased the property, I am not in a position to get the sanctioned plan unless the kata is issued by the BDA. I am not in a position to.
My lord, which page?
145 in the more judgment ಇದೆ ನೋಡಿ.
My lord, this is prior to 2020, my lord. This position was prior to 2020, my lord.
What do you mean by prior to 2020?
In 2020, there was an amendment. My objection may kindly be seen, my lord.
23 ದು ಒಂದು judgment ಇದೆ ನೋಡಿ, 154.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಅಂತ, it was just a order to consider their representation, my lord. There is no order on merit after considering the point of law, my lord. My lord, in my objection statement, my lord.
What is the amendment?
Para 8, my lord.
Town and country planning.
17(2)(c), my lord. Yes, there was amendment to the Karnataka Town and Country Planning Act.
Yes.
Insertion of Act number 34 of 2020 on 22/5/2020.
17(2)(c).
Yes, my lord. 17(2)(c). May permit development of the layout in phases. If in such cases, the developer shall submit a phasing plan along with the provisional plan.
2C.
2C, yes, my lord.
No, it says planning authority, if a person so desires, may also permit the release of sites in 2 stages.
1 minute. 17(2)(c). Provided anta ide, provided that no commencement certificate or license.
That is a proviso to section 2B.
Yes, my lord. Then thereafter 2C, after that 2C, my lord. The planning authority, if the developer of the layout so desires, may also permit development in the layout in phases In such a case, the developer shall submit the phasing plan along with the provisional plan showing the development of the layout area in 3 phases, indicating the development of 40% of the layout area in first phase.
ಯಾವ್ದು ಏನೋ ಬೇರೆ ತರ ಇದೆಯಲ್ಲ ಕೊಡಿ. ಅದು ಯಾವ್ದು 21 ಅಮೆಂಡ್ಮೆಂಟ್?
Yes, my lord. 2020, my lord.
ಇದು ಸರ್ ಬೇರೆ 21 ಅಲ್ಲಿ ಏನೋ ಬೇರೆ ಅಮೆಂಡ್ ಆಗಿದೆ.
Yes, my lord.
ಕೊಡಿ ನಮ್ಮ ಬುಕ್ ಕೊಡಿ ಅವ್ರಿಗೆ.
Illide.
Whatever is read is not there in my book.
It's here, my lord. 2C.
2C.
2C, my lord.
Oh, ಓದಿ.
The planning authority, if a person so desires, may permit release of sites in 2 stages.
In phases ಅಂತ ಇದೆ ಇಲ್ಲಿ. Permit a phasing plan along with the provisional plan showing the development of the layout area in 3 phases. 3 phases ಆ book ಅಲ್ಲಿ ಇಲ್ಲ. Indicating development of 40%.
ಇದರೊಳಗೆ ಇವ್ರು ಏನ್ ಮಾಡ್ತಿದ್ದಾರೆ 21 ಅಮೆಂಡ್ಮೆಂಟ್ 2C ನಲ್ಲಿ 2E is inserted. ಅದು ನನ್ನ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ. May pass on, my lords. I have also marked. What does it say? If the kata is not issued ಅಂತ ಹೇಳ್ತಾರೆ. ಅಯ್ಯೋ
2E ನಮ್ಮ same, my lord. Even I am relying upon 2E. Any building site which has not been
What are relying upon 2C or 2D?
2E, my lord.
2E
building
E ನಲ್ಲಿ E dash E ತೋರಿಸಿ.
2C ಅಲ್ಲಿ ಅದಾದ್ಮೇಲೆ 2E ಅಂತ ಬರುತ್ತೆ. Relevant. Any building site which has not been released by the planning authority under this act shall not be issued with kata or given property index e-kata under the Karnataka Municipalities Act, the Karnataka Municipal Corporation Act and Gram Swaraj and as the case may be, my lord. Therefore, we have rejected the
No, but
that amendment is subsequent.
ಇದನ್ನ ಹೆಂಗೆ, how do you make it applicable to an earlier layout?
Earlier.
My lord, from the date of
how can you make this applicable with retrospective? Now layout is already sanctioned.
ಅಲ್ಲ ಅವಾಗ they were issuing in view of the earlier judgment they were doing it, my lord. Thereafter this amendment came about.
How can this amendment take away their right? See this particular amendment,
yes, my lord,
says that the sanction will be in 3 phases.
Yes, my lord.
And only when the sites are released, kata can be made out.
Yes, my lord.
This is not applicable to that layout. Was there such an amendment earlier?
My lord, I didn't get it.
When was the layout formed?
Layout was
When was the layout approved rather?
2000. Approved long back. November 2014.
What was the law then? ಯಾವಾಗ ಅಪ್ರೂವ್ ಆಗಿತ್ತು ಆ ಲಾ ತಾನೇ ಅಪ್ಲಿಕೇಬಲ್. ನೋ ಯು ಕೆನಾಟ್ ಸೇ ಅವಾಗ ಆಗಿದ್ ಲೇಔಟ್ ಇವಾಗ ರಿಲೀಸ್ ಮಾಡಬೇಕು ಅಂತ ಯು ಕೆನಾಟ್ ಅಪ್ಲೈ ದಟ್. ದಿಸ್ ರೂಲ್ ಕೆನಾಟ್ ಬಿ ಅಪ್ಲಿಕೇಬಲ್ ಮೇಡ್ ಅಪ್ಲಿಕೇಬಲ್ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ಲಿ.
So far as that, my lord, can I seek for one short accommodation so that I'll come prepared, my lord.
Even if you take a short or longest accommodation, rule cannot be made retrospectively.
I'll just
rule cannot be applied retrospectively. Long ana tagoli, short ana tagoli.
Little bit of
that
time.
is so. Yes, then the position as determined by this court in the earlier judgments is also applicable to him.
I'll just seek instructions and submit, my lord.
Saturday.
Judgment counsel for the respondent number 1 seeks time. New Year again.
Society made an allotment to the members.
Yes. Yavat week?
Saturday.
Sometime 1 week, 1 or 2 weeks.
Third. Yes, Mr. A. Nagarajappa.
2009-10, my lord. This layout, my lord. Layout in 2009 and 10.
What are you? How can you apply?
I'll just submit.
Mr. A. Nagarajappa.
49, A. Nagarajappa.
Yes, my lord. I am appearing for the petition. The last occasion, BDA council furnished the list of the vacant site, my lord.
So what do you want?
I am ready to take the site shown at serial number 137 or 138, my lord.
Yes, madam. Can you get instructions?
instructions on the availability, my lords. This
No,
is-
you are given a list of available sites on the last date.
Yes,
Now
my
you
lords.
picked up one site from the list.
Yes, my lords.
So just check out whether you can, BDA can convey this site to the petitioner. Alternate site,
Serial number 138, madam, my lord. Site number 130, it is 30 by 40.
130.
Site number 130, it is for, given at serial number 138, serial number 138 of the
Serial
list
number
furnished on the last.
138. 138. Saryam Vishwesvaraya layout?
Yes, my lord.
Block number 130. Yes, madam. We allot this site to him.
I can have it verified, my lords.
Huh?
I can have it verified.
You have given the list. Now you don't say I can get it verified.
ಇಲ್ಲ.
If it is there, it
Instructions
is there.
ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ವಿ. If directions may be given, then we'll proceed with it.
No, find out.
Petitioner is ready to accept this site.
Find out whether you can convey this site number 130. Barcode, the learned counsel for the petitioner, after going through the list of sites available for allotment in Saryam Vishwesvaraya layout, submits that the petitioner is willing to accept site number 130 in
Block number 7.
130 in block number 7 of Saryam Vishwesvaraya layout, measuring 30 by 40 feet as an alternate site. The learned counsel for the respondent seeks time to secure instructions. List on
Next week, my lord.
third.
Please. 50, Sundaresh HC.
HC Sundaresh.
The site was allotted in favor of the petitioner in the year 2013.
Yes, Deepthi Ayatan.
Entire amount was deposited. Till
Ready,
today,
Yen Marbeko, sale
sale
deed.
deed was not executed till
Yes,
today.
madam, when will you execute the sale deed?
My lords, in this matter, we'll have to seek instruction, my lords. We have already communicated one
Learned
short
counsel for
accommodation,
the
my lords.
Respondent seeks time.
Third time, matter has been treated before.
Huh?
Third time, matter has been listed before your
Yen
lordship.
2026, yen Maraka. Yes, next.
Next
on
same.
zones.
Both are similar.
51 same, list on zone.
Next week, my lord.
Shravan Bharadwaj.
Shravan Bharat. ಯಾವತ್ತು ಹೇಳಿ ಯಾವತ್ತು ಬೇಕು
Next week, my lord, next, let them.
ಯಾವತ್ತು ಬೇಕಾದ್ರೂ ತಗೊಳ್ಳಿ.
And next week,
Take
next week,
whatever
any
date
date
you want.
Next week, any date. Date may be.
Third. Shravan Bharadwaj.
52, Shravan Bharadwaj.
My lords, it's an auction which was.
I'm for the respondent respondent number 3, my lord, successful bidder. And I pray for 1 week time to file a detailed objection. Either subsequent circular.
Who are you?
My lords, I'm a
Second
H2, my lords.
Huh?
Second highest bidder, my lords.
Second highest bidder.
My lords, on 17/12/25.
Remember this,
Yes.
Is there any interim order?
Yes, my lords.
Learned counsel for the respondent number 3 seeks time. List on so and so interim order granted earlier.
It may be posted on third, my lords.
ಒಂದು ವಾರದಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಆಗತ್ತಾ?
ಅವರು ಒಂದು ವಾರ ಕೇಳಿದ್ರು
Next,
ಹಾಗಾಗಿ.
list on so and so is next.
September, serial 53, Chandrasekhar Vicky.
Yeah. Plan, layout plan.
It's a petition for writ of mandamus.
Change of land use ಕೇಳ್ತಾ
I
ಇದ್ದಾರೆ.
have
Change of land
done
use.
everything before the authorities.
ಯಾವಾಗ
Even they have,
My lord, this application was processed. By that time, my lord, it was found that the land is, my lord, the proposed notifier for the PRR 1 project layout, my lord. Therefore, the application was placed before the committee, my planning committee. It was pending in the planning committee. And grant 2 weeks time, my lord, by that time.
The learned counsel for the respondent number 2 to 4 seeks time to secure instructions. List on so and so.
18 September.
more matter,
54
Similar
same,
matter.
54 same, 55 same, 56 also same.
50, 54, 55, 56.
Yes,
No,
HB Raju.
HB Raju. 57,
HB Raju, there is no representation for the petitioner and the respondent. List on so and so.
18 September.
Yes, B group,
List number 2. For preliminary B group matter, serial number 1, Vishwanath HM.
For the respondent, the petitioner has not been appearing since the 2016 ಇಂದಾನೆ ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್. It's pertaining to Banchankari 6 stage, declaring that it is lapsed with respect to their property.
6th stage.
6 stage, ma'am. Banchankari 6 stage.
There is no representation for the petitioners, even the last day there was no appearance. Hence the petition is dismissed for non-prosecution.
Much.
Number 2, Arnaldi Law Associate Partners LLP. B.S. Sachin for
Pass over, my
respondent.
lord.
Pass over.
Serial number 3, Praveen Kumar GS.
GS Praveen Kumar. ಇದ್ರಲ್ಲಿ ಯಾವ್ದು ಕವರ್ ಆಗಿದೆಯಾ ಕೃಷ್ಣ ನೀವು? ಇದು ಯಾವ್ದು ಲೇಔಟ್ ರೀ ಇದು? ಬನಶಂಕರಿ
Banashankar 6, further extension Banashankari 6 stage.
ಫರ್ದರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬನಶಂಕರಿನ?
Further extension
ಫರ್ದರ್
Banashankari.
ಎಕ್ಸ್ಟೆನ್ಷನ್
ಅಲ್ಲ ಅದು ಯಾವ್ದಂತ?
ಹಾ
serial number. Further extension. 44.
ಪ್ರವೀಣ್ ಕುಮಾರ್, KM ಸೋಮಶೇಖರ್, ಶಿಲ್ಪಾ ರಾಣಿ, ಅನೂಪ್ ಹಾರ್ನಳ್ಳಿ, ಗಿರೀಶ್, ಸುಮನಾ ನಾಗಾನಂದ್.
ಸರಿ ಇದೆ. ಮೇಲೆ.
Serial number 7 minutes in may my lords make a submission in serial number 7.
Please wait. Yes.
I'm sorry.
Serial number 2.
Serial number 2, my lord. Please, office objections have been complied, my lord.
Learned counsel for the petitioner submits that office objections are complied.
Please.
Office director to check and verify. Yes. Could ಏನಿದು?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ನನಗೆ ಬಿಡಿಎದವರು
ಏನು ಇಲ್ಲ ಸ್ವಾಮಿ ಅಂದ್ರೆ ಹೋಗಿ ಏನು ಇಲ್ದ್ರೆ ಯಾಕೆ ಬರಕ್ ಹೋಗ್ತೀರಾ?
ನನಗೆ ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಟ್ರು. ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಡೋಕೆ ಹೋಗಿದ್ರೆ ರಾಂಗ್ ಮೈ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 23.
ಪೇಜ್ ನಂಬರ್
23. ಈ 23 ನಲ್ಲಿ ಬಂದಾಗ ದ ಶೆಡ್ಯೂಲ್ ಅಂತ ಬರೀತಾರೆ. ನನಗೆ ಸೈಟ್ ನಂಬರ್ 1994 ಜಾಗ ಕೊಡ್ತಾರೆ. ಅಲ್ಲಿ ಸೈಟ್ ಬೌಂಡೆಡ್ ಈಸ್ಟ್ ಬೈ ಬಿಡಿಎ ಬಿಡಿಎ ವೇಕೆಂಟ್ ಸೈಟ್ ಅಂತ ಇತ್ತು ಸರ್. ಈ ವೇಕೆಂಟ್ ಸೈಟ್ಗೆ ನಾನು 1995 ನನಗೆ ಇಟ್ ಇಸ್ ಎ ಮಾರ್ಜಿನಲ್ ಜಾಗ EWS ಸ್ಕೀಮ್ ಅಲ್ಲಿ ನನಗೆ ಕೊಡಿ ಅಂತ ನಾನು 95 ಇಂದ ಇವತ್ತಿನವರೆಗೂ ಕೇಳ್ಕೊಂಡು ಬಂದಿದ್ದೀನಿ. ನನಗೆ ಅನಕ್ಷರ್ಗೆ 6/8/2026 ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು
ಎಷ್ಟಿದೆ ಇದು ಮಾರ್ಜಿನಲ್ ಜಾಗ?
ಜಾಗ ಬಂದು ಸ್ವಾಮಿ ಪ್ಲೀಸ್
ಎಷ್ಟಿದೆ ಮಾರ್ಜಿನಲ್?
ಬಂದೆ ಬಂದು ಇಟ್ ಈಸ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 14 ಮೈ ಲಾರ್ಡ್. ಅನಕ್ಷರಿಯ ಪೇಜ್ ನಂಬರ್ 14 ಬಂದ್ಬಿಟ್ಟು 7.62 ಪ್ಲಸ್ 12.19.
ಆಯ್ತು, what is the marginal ಜಾಗ? What is the area of the marginal land?
ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್ ಬಂದ್ಬಿಟ್ಟು 12 into 8 ಬರುತ್ತೆ ಸರ್.
12 feet?
8.
12 feet by 8 feet. ಎಲ್ಲಿದೆ ಹಂಗಂತ?
ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 14 ಬನ್ನಿ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 14. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ಪುಟ್ಟಹಲ್ಗೇಗೌಡ ಆದ ತಾವು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಕುಮಾರಸ್ವಾಮಿ 2ನೇ ಹಂತ ಬಡಾವಣೆಯ 7.62 ಇಂಟು 12.19 ಇಂಟು 25.40 ಅಡಿ ಮೀಟರ್ ಅಳತೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 1994ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಂತೆ ಅಂಚಿನ ಜಾಗವನ್ನು ಮಂಜೂರು ಮಾಡುವಂತೆ ಹಾಗೂ ಸದರಿ ಜಾಗಕ್ಕೆ ಸರ್ಕಾರದ ನಡವಳಿ ಆದೇಶ 83ರಂತೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 25ರಷ್ಟು ದರವನ್ನು ವಿಧಿಸಿ ಆ ಜಾಗವನ್ನು ತನ್ನ ಹೆಸರಿಗೆ ಮಂಜೂರು ಮಾಡುವಂತೆ ಕೋರಿರುತ್ತೀರಿ. ಇದ್ರ ಪ್ರಕಾರ ನಾನು ಇವರ್ ಆನ್ ಮೈ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಅನಕ್ಷರ್ K1.
ಓದಿ ಫುಲ್ ಓದು.
ಪ್ಲೀಸ್. ಅದರಂತೆ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ದಕ್ಷಿಣಾರವರು ಕುಮಾರಸ್ವಾಮಿ 2ನೇ ಹಂತ ಬಡಾವಣೆಯ 7.62 12.19 ಇಂಟು 25.4 ಅಡಿ ಮೀಟರ್ ಅಳತೆಯ ನಿವೇಶನ ಸಂಖ್ಯೆ 1994ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ಪೂರ್ವ ಭಾಗದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಅಂಚಿನ ಜಾಗವನ್ನು ಒಟ್ಟು 54.73 ಚದರ ಮೀಟರ್ ಇದ್ದು, ಅರ್ಜಿದಾರರು ಈಗಾಗಲೇ ಪೂರ್ವ ಪಶ್ಚಿಮ 4.72 + 4.49 / 2 ಮೀಟರ್ ಉತ್ತರ ದಕ್ಷಿಣ 6.2 ಮೀಟರ್ ಒಟ್ಟು 28.78 ಅಂಚಿನ ಜಾಗದಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ಅನುಮತಿ ಇಲ್ಲದೆ ಮನೆ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಕಾರ್ ಶೆಡ್. ಒಂದ್ ಕಾರ್ ನಿಲ್ಸಕ್ಕೆ ಅಂತ ಒಂದ್ ಶೀಟ್ ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ. ಇಟ್ ಇಸ್ ನಾಟ್ ಅನ್ ಹೌಸ್.
ಎಲ್ಲಿದೆ ಫೋಟೋ? ಫೋಟೋ
ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಫೋಟೋ ತೆಗಿಯಕ್ ಬರಲ್ವಾ?
ಬರುತ್ತೆ ಸ್ವಾಮಿ, ಬರುತ್ತೆ, ಡೆಫಿನೆಟ್ಲಿ
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಮಾಡ್ತೀನಿ. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್.
ಪ್ರೊಡ್ಯೂಸ್ ಫೋಟೋ.
ಖಾಲಿ ಇರುವುದಾಗಿ ವರದಿ ಸಲ್ಲಿಸಿರ್ತಾರೆ. ಮುಂದುವರೆದು ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಸಲ್ಲಿಸಿರುವ ಅಂಚಿನ ಜಾಗದ ವಿಸ್ತೀರ್ಣ ಉಲ್ಲೇಖ 4ಕ್ಕೆ ಆರ್ಥಿಕ ವಿಭಾಗದವರು ಒಟ್ಟು 99,76,867 ದರ ನಿಗದಿಪಡಿಸಿ ಸದರಿ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಿಕೊಂಡು ಮುಂದಿನ ಕ್ರಮ ವಹಿಸಬಹುದೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಿ ಕುರಿತು ಹಂಚಿಕೆದಾರರಿಗೆ 54.73 ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣವನ್ನು ಹಂಚಿಕೆದಾರರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಲು ಹಾಗೂ ದರವನ್ನು ನಿಗದಿಪಡಿಸುವ ಬಗ್ಗೆ ಪ್ರಾಧಿಕಾರದ ಸಭೆಗೆ ವಿಷಯವನ್ನು ಮಂಡಿಸಲಾಗಿದ್ದು, ಪ್ರಾಧಿಕಾರದ ಸಭೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರ ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಲು ಅವಕಾಶ ಇಲ್ಲವೆಂದು ತೀರ್ಮಾನಿಸಲಾಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಮಾನ್ಯ ಆಯುಕ್ತರು ಉಲ್ಲೇಖ 2ರಂತೆ ಪ್ಲೀಸ್ ಇಶ್ಯೂ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ as per board resolution and close the file by issuing demand note as per norms present rate, and if no payment made may make in 30 days put it for action ಎಂದು ಆದೇಶಿಸಿದ್ದು ಉಲ್ಲೇಖ 3ರಲ್ಲಿದ್ದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಅನುಮೋದಿಸಿರುತ್ತಾರೆ. ಆದುದರಿಂದ ಉಲ್ಲೇಖ 1ರ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ತೀರ್ಮಾನದಂತೆ ಉಲ್ಲೇಖ 2ರ ಮಾನ್ಯ ಆಯುಕ್ತರ ಆದೇಶ ಹಾಗೂ ಉಲ್ಲೇಖ 3 ಮಾನ್ಯ ಆಯುಕ್ತರ ಆದೇಶದಂತೆ ಆರ್ಥಿಕ ವಿಭಾಗದವರು ವರದಿ ಅನುಸಾರ ಕುಮಾರಸ್ವಾಮಿ 2ನೇ ಬಡಾವಣೆಯ 7.62 × 12.19 × 25.40 ಮೀಟರ್ ಅಳತೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 1994ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ಅಂಚಿನ ಜಾಗದ ದರ ಮೊತ್ತ ಒಟ್ಟು 99,76,867ಗಳನ್ನು 30 ದಿನಗಳೊಳಗಾಗಿ ಪಾವತಿಸಿ ಚಲನ್ ಪ್ರತಿ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ಅಂಚಿನ ಜಾಗವನ್ನು ಮಂಜೂರು ಮಾಡುವ ಬಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಮುಂದಿನ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. ಇಲ್ಲವಾದಲ್ಲಿ ಸದರಿ ಅಂಚಿನ ಜಾಗವನ್ನು ಈ ಹರಾಜು ಮೂಲಕ ವಿಲೇ ಮಾಡಲಾಗುವುದು ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಲಾಗಿದೆ. This was made on
B.S. Karthikeyan is directed to accept notice for respondents 1 to
6, my lord.
1 to 6. Till the next date of hearing, the respondents are directed not to auction the marginal land adjacent to the property of the petitioner bearing site number
1994.
1994 in Kumar Swamy layout, second stage. List on date code.
Please.
The learned counsel for the petitioner is directed to place on record the photograph showing the construction put up in the marginal land.
Please.
Huh?
Please.
Adadmele idu ಮಾಡಿ.
My lord, kind permission, my lord. Disposed of matter, cooperative societies matter. It was disposed of in the year 2023. On last occasion, my lord, the other side filed an application and sought for some order, and my lords have already passed the order. I am filing this recalling of that order, my lords, because they have suppressed that fact and they have made the submission.
Why you did not appear before the court when
My
the
lords,
matter
we
was
did not know
listed?
that ಅಲ್ಲಿ colleague ಹೆಸರು ಬಂದಿತ್ತು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅದರಿಂದ any date, my lord. Please.
ಸರ್ ಚಂದ್ರಶೇಖರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಸರ್ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್, ನಿಮ್ದು 2.5 ತಗೋತಾರೆ
31 ಸರ್.
ಸರ್
ಸರಿ ಸರ್.
First door matter, serial number 10. First door matter, serial number 10. Rajgopal Naidu.
Lad, the
How is
petition,
this application maintainable?
I may be permitted to withdraw that.
Learn counsel for the petitioner submits, has filed a memo to withdraw.
Yes.
IA 1 of 24. In view of the memo, IA 1 of 24 is rejected. ಏನು ರಿಲೀಫ್ ಕೇಳಿದಿರಿ?
ಇದರಲ್ಲಿ writ of mandamus directing the
Murugesh,
BDA, to allot 20-30 sites seeking
100 by 80 feet ಯಾರಿಗೆ ಮಾಡಬೇಕು?
ಅದು ಲ್ಯಾಂಡ್ ಓನರ್ಗೆ, ಟು ದಿ ಲ್ಯಾಂಡ್ ಓನರ್ 100 by 80. ಅದರಲ್ಲಿ ಲ್ಯಾಂಡ್ ಓನರ್ ಶೇರ್ ಅಲ್ಲಿ 20/30 as per the resolution passed by them as per annexure C.
80 by 100 ಯಾರಿಗೆ ಅಲಾಟ್ ಮಾಡಬೇಕು?
The members of the association. Members of the association. Annexure C.
Yes, Murugesh.
Annexure C is the resolution passed by the BDA itself to allot the sites in place of, because the existing place has been taken over by the BDA to accommodate a temple, Venkateshwara temple and the park. And they have been assured to allot alternate sites. So they have identified survey number 16 and its sub numbers, and they intended to allot.
Yes, Murugesh. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
23.
ಕಾಪಿ ಅಂತ ಕೊಡಿ. Learned counsel for the petition is directed to serve a copy of the writ petition to the learned counsel for the respondent. List on so and so.
18 September. Sir, memo. Memo ಬರ್ಕೊಡಕ್ಕೆ ಹೇಳಿ. Serial number 18. ಮಂಜುನಾಥ್ ರೆಡ್ಡಿ.
There are 3 petitions, my lord.
Serial number 18.
May I request the Namatla?
First petition ಏನು ಸರ್? What is challenged? First petition ಏನು challenge ಮಾಡಿದ್ರು?
12,472.
What is challenged?
In that, my lord, what we have challenged is the disqualification order as well as the appointment of special officer.
29C na?
Yeah.
And appointment of special officer.
Yes. Some facts are required.
One ನಿಮಿಷ. Of special officer.
Yes. 68 order was passed saying that the sale of land by the developer, you should take it back. That was the 68 order. In 68 order, we filed an appeal before the competent the tribunal. There, my lord, the stay order was refused. Then we filed a writ petition. This honorable court said that you decide the matter within a certain time limit. Till then, no precipitative action to be taken. Notwithstanding that order, only based upon 68 order, they passed an order of disqualification as well as appointed special officer. Both have been now stayed. After this order came to be passed, now the appeal filed against the 68 order has now been disposed of, which is the subject matter in WP 18567.
Appeal filed against the 68 order.
18567 is the order by which, my lord, the appeal filed against 68 order has been dismissed with certain observations. On that ground, we have challenged. But some brief facts are required, my lord, before.
What is 2690?
Another part of 68 order, where it is directed to take necessary steps by filing a dispute as a key developer unable to recover the property which is in his hand. And also, further also, Karnataka proceedings also to be initiated to attach the property since we did.
Yes.
Then we not, in the event property could not be able to be restored to the society, there is a direction to the recover 2 crores and add amount as a cost of the site.
From the directors.
Yes. 45 days was allotted to us to consider the within that time we raised the issue before the very authority. And also we have filed an application for 103 and then interim model not to arrange it. Then the notice was issued on that application. Dispute that was filed within 45 days. Immediately, when that proceedings are pending, a 69 proceedings are initiated against that society. It is a premature, therefore, section 69 proceedings which are challenged in this petition, we are seeking it off verification. Because unless the matter is pending and notice has been ordered, we are complying with the decision, the order by the authority under section 68 of the Act. That was the subject matter in my petition 2690 of.
Yes. Really, sir.
Yes, Lord, the society entered into an agreement with the developer to develop, Lord, certain properties in Hajjala village. That is, in respect of that land, Lord, about 20,789 square feet of land, 20,789 square feet of land was with the developer. We requested the developer that you should hand this property also to the society for distributing among our members. But notwithstanding that, he sold the property on 25/8/2023. After coming to know about it, that is, Lord, some private persons he has sold the property. After coming to know about it, Lord, we wrote to the developer saying that you cannot sell the property, you should hand over the property back to us. We also raised a dispute against the developer saying that his action of selling the property is illegal. At page 289, Lord, is the dispute raised by us which was pending before the tribunal. In the meanwhile, Lord, a 68 order came to be passed. 68, the dispute raised by us, Lord, is at page 289. Where the persons who have purchased the properties are also made parties. In that, Lord, the developer said he is willing to hand over the site back to the society, which he filed a memo at page 373. Affidavit. That is at page 370. 375 is the application. Developer said that dispute can be allowed. He is willing to give the property back to the society.
373.
375. The developer, that is respond number 225, he said that he may be pleased to allow the dispute filed by the petitioner. On that, Lord, no order was passed. In the meanwhile, a 68 order came to be passed at page 282.
Page 270?
68 order came to be passed on 1/12/2025 at page 282. There, Lordship, kindly take page 282.
Yes.
At page 285. At page 285 from the top, ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕರು ಹಾಗೂ ಅಭಿವೃದ್ಧಿದಾರರ ವಿರುದ್ಧ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಲು ನಿರ್ದೇಶಿಸಿದೆ. ಮುಂದುವರೆದು ಸದರಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 120ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಘದ ಸದಸ್ಯರ ಹಿತದೃಷ್ಟಿಯನ್ನು ಕಾಪಾಡುವ ನಿಟ್ಟಿನಲ್ಲಿ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 103 ಅಡಿ ಸದರಿ ಆಸ್ತಿಯನ್ನು ಆದೇಶಪೂರ್ವ ಜಪ್ತಿಗೆ ಒಳಪಡಿಸಲು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ದಾವಾ ದಾಖಲಿಸಲು ನಿರ್ದೇಶಿಸಿದೆ. ಸದರಿ ಆಸ್ತಿಯನ್ನು ಸಂಘಕ್ಕೆ ಮರಳಿ ಪಡೆಯಲು ವಿಫಲವಾದಲ್ಲಿ ಪರಭಾರೆ ಮಾಡಿರುವ 11,789 ಚದರ ಅಡಿ ವಿಸ್ತೀರ್ಣದ ಜಾಗದ ಇಂದಿನ ಮಾರುಕಟ್ಟೆ ಮೌಲ್ಯವನ್ನು ಲೆಕ್ಕ ಮಾಡಿ ಮೇಲ್ಕಂಡ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯವರು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕರು ಅಭಿವೃದ್ಧಿದಾರನ ಹೊಣೆಗಾರನಾಗಿಸಿ ಸದರಿಯವರಿಂದ ನಿಯಮಾನುಸಾರ ಪರಭಾರೆ ಮಾಡಿದ ದಿನಾಂಕದಿಂದ ಬಡ್ಡಿಯೊಂದಿಗೆ ವಸೂಲಿಸಿ ಮಾಡಲು ನಿರ್ದೇಶಿಸಿದೆ. ಮುಂದುವರೆದ ಆಡಳಿತ ಮಂಡಳಿಯ ಕೃತ್ಯಕ್ಕಾಗಿ 29C ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯತ್ವದಿಂದ ಅನರ್ಹತೆಗೊಳಿಸಲು ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲು ಸಂಘದ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ನಿರ್ದೇಶಿಸಿದೆ. ಈ ವಿಚಾರಣಾಂಶ 2 ಮತ್ತು 3 they say, my lord, some allegations are made against the secretary that he has not taken note of dissenting opinion. Otherwise, there is no substance. This is the main allegation. Against this, my lord, we filed an appeal at page 395 and we sought for an interim order which came to be rejected at page 395. The registrar rejected our application for an interim order. Against that, we filed a writ petition at page 400. At page 405, para 8. Therefore, in the ends of justice, respondent number 2 is directed to complete the entire proceedings in appeal number so and so. After affording opportunity of hearing to all parties within a period of 2 months from the date of receipt of this order, it is made clear that till the completion of the entire proceedings before the respondent number 2 in the aforesaid appeal, no precipitative action shall be taken against the petitioner in terms of the impugned order dated 1st December 2025, passed by the respondent number 3 under section 68. One of the recommendation is to disqualify under section 68.
Yes.
Then, my lord, at page 363, at page 413, my lord, page 413, they passed the order of disqualification during the pendency of the appeal, notwithstanding the order on the basis of the 68 order. And at page, the separate disqualification orders are there in respect of each of the employees. And at page 534, special officer came to be appointed. Both these orders were challenged before this honorable court on the ground that they have passed this order contrary to Yes, but this both have been stayed by this honorable court on the basis of this reasoning only, because there was an interim order. Now, my lord, the appeal has been disposed of. That your lordship would get it in WP 18567.
What is the date of disposal?
1 second. That is 393. They just date of disposal order. They just page 544.
3526.
A second volume ಅಲ್ಲಿ page 544. At page 561. relevant portion.
561.
At page 561, ಪ್ರಕರಣದಲ್ಲಿ ಮೂರನೇ ಪ್ರತಿವಾದಿ ಪರ ವಕೀಲರು ಹಾಜರಾಗಿ ಕೇವಲ ತಮ್ಮ ಮೌಖಿಕ ವಾದವನ್ನು ಮಂಡಿಸುತ್ತಾ ಮೇಲ್ಮನವಿದಾರರು ತಮ್ಮ ಲಿಖಿತ ವಾದದಲ್ಲಿ ಹೇಳಿರುವ ಅಂಶಗಳನ್ನ ಪುನರಾವರ್ತಿಸುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ನಿವೇಶನ ಸಂಖ್ಯೆ 120 ಪುನಃ ಸಂಖ್ಯೆಗೆ ವಾಪಸ್ಸು ಪಡೆದುಕೊಳ್ಳುವುದಾಗಿ ತಮ್ಮ ಲಿಖಿತ ಹೇಳಿಕೆಯಲ್ಲಿ ತಿಳಿಸಿರುವುದನ್ನು ಗಮನಿಸಲಾಗಿದೆ. ಕಲಂ 103 ಅಡಿ ನಿವೇಶನವನ್ನು ಸಂಘದ ವಶಕ್ಕೆ ಪಡೆಯುವ ಬಗ್ಗೆ ಜಪ್ತಿ ಪೂರ್ವ ಆದೇಶವಾಗಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಂಘದ ನೋಂದಾಯಿತ ಸದಸ್ಯರ ಹಿತಾಸಕ್ತಿ ಕಾಪಾಡುವುದು ಅತ್ಯವಶ್ಯವಾಗಿರುವುದರಿಂದ ನಿವೇಶನಗಳನ್ನು ಭೂ ಅಭಿವೃದ್ಧಿದಾರರಿಂದ ವಾಪಸು ಪಡೆದು ಜ್ಯೇಷ್ಠತೆಯಲ್ಲಿ ಅರ್ಹತೆ ಹೊಂದಿರುವ ಸದಸ್ಯರಿಗೆ ನಿವೇಶನಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡಲು ನಿರ್ದೇಶಿಸಿದೆ. ಸಂಘದ ಆಡಳಿತಾತ್ಮಕ ಕಾರ್ಯಗಳನ್ನು ಉಪನಿಯಮಗಳ ಪ್ರಕಾರ ನಿರ್ವಹಿಸದೆ ಕರ್ತವ್ಯ ಲೋಪ ಎಸಗಿರುವ ಸಂಘದ ಪ್ರಭಾರ ಕಾರ್ಯದರ್ಶಿ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸಲು ನಿರ್ದೇಶಿಸಿದೆ. ದಿನಾಂಕ 21/4/26 ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ನೀಡಿರುವ ನಿರ್ದೇಶನ ಉಲ್ಲಂಘಿಸಿ 29C 1ನೇ ಪ್ರತಿವಾದಿಯವರು ಹೊರಡಿಸಿದ ಅನರ್ಹತೆ ಆದೇಶವು ಕಾನೂನುಬದ್ಧವಾಗಿರುವುದಿಲ್ಲ. ಕಾರಣ ಪ್ರಕರಣದಲ್ಲಿರುವ ಸಮಗ್ರ ದಾಖಲೆಗಳನ್ನು ಮರುಪರಿಶೀಲಿಸಿ ಉಭಯತರರಿಗೆ ನೋಟಿಸ್ಗಳನ್ನು ನೀಡಿ ಸಹಜ ನ್ಯಾಯ ತತ್ವದಲ್ಲಿ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿ ಕಾನೂನುಬದ್ಧ ಆದೇಶವನ್ನು 3 ತಿಂಗಳ ಒಳಗೆ ಹೊರಡಿಸುವಂತೆ 1ನೇ ಪ್ರತಿವಾದಿಗೆ ನಿರ್ದೇಶಿಸಿದೆ. ಈ ವರ್ಚುವಲ್ alert says that disqualification order is incorrect. ಬಟ್ ಆಮೇಲೆ ಏನ್ ಹೇಳ್ತಾರೆ, ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. So we are only concerned with only 2 points, my lord. One is he holds that disqualification order is bad, contrary to there is no difficulty. Then with regard to the direction that we have, you already complied with that. So therefore our contention is 68 order to that extent has already been complied with. So he virtually confirms the order passed under section 68 without noticing that we have already recovered back the property. One of the contention, my lord, raised by the other side on the last occasion was that the sale deed has been executed by the persons to whom the developer has sold. They have sold it directly to us. Now, therefore, my lord, we have filed additional affidavit of the developer as well as the other person saying that at our direction they have been sold directly, because otherwise 2 times sale deed is to be done. Double time, my lord, the stamp duty will have to be paid. So therefore, the compliance of the order is we have to recover and give it to our members. So that has been achieved. To that extent, my lord, 68(1) order, that should have been set aside. The direction should have been set aside because we have complied with it. If we have not complied, only the other issue would arise. And he also says the disqualification order could not be passed if they issue fresh notice. That's a different issue. This is all the limited ground in our.
Yes. ಇನ್ನೊಂದು ಯಾವುದು?
ಅದು ಐ ಥಿಂಕ್ ರಾಜಗೋಪಾಲ್.
18,567 ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡೋದು ಅದೇನಾ? ಈ ಅಪೀಲ್ ಆರ್ಡರ್ ಸೆಕ್ಷನ್ 68 ಆರ್ಡರ್ 18,567 ನಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ಟ್ 18.2 ನಲ್ಲಿ 18.2 ನಲ್ಲಿ the appeal order is challenged.
Correct. 18 that is 18/567 appeal order is challenged. That is only in the nature of continuity of the same proceeding.
Yes. ನಿಮ್ದು ಹೇಳಿ ಸರ್.
2690. Let me kindly go to page 29 of my report.
Page?
Page 29.
29.
2690.
Page 29. Yes, sir.
The player, if you have received a letter of relationship for clear respondent and proceeding, the conducting the proceedings will be on this file. In such a case number source, initiated so moved on section 16 and then if you have become people socially party, the notice saying that the source is circular. Circular means a notice in consequences of elected section. These 2 proceedings are called.
What is this notice regarding?
Notice regarding 69 proceedings are initiated. Calling upon to appear before the authority notice was.
Yes.
That notice recording. That the, I can take your also. Facts are 7/1/2005.
Survey number?
7/1/2005.
Ah.
There was an agreement between the developer and the society.
Ah.
There was architect and we go to page 80 to annexation B. That agreement is relevant part of the agreement is that may kindly go to Roman class 4 and page
82.
Page 83.
Hmm.
The society will purchase about 2,000 intermediate sites. Dimensions, virtually, what was the contract? Land will be procured by the developer. He must purchase either on his name or he must purchase on his own. Then he has to got converted. Then society, he has to follow your sites. How many sites? It's about 100. Now also they have been broken. It's about 156, 50 and more is there. According to the MOU, 2,000 sites. There are 2,000 intermediate sites of various dimensions in the proposed layout to be pardoned by Lakshman. Near Jagdala station in various areas. Jagdala, Panikrate, villages in an area of 150 acres. However, for the reasons beyond the control of the second party, he is not in a position to acquire the entire extent. The second party shall acquire through the layout in accordance with the terms of the consent in the agreement in the area of minimum 100 acres in the proportion site after 150 sites, the second party. All the terms, etc., then you will not be and go to page para 4 at page 84. Accordingly, this agreement witnesses to your honor. The second party assures and undertakes that he shall acquire the lands, develop the residential layout. Thereon, as per the PMRDA Corona regulation, deliver to the first party approximately 2,000 intermediate sites of area dimensions, excluding 150 sites of area dimension reserved for the benefit of the landlord. Another nominee spread over in the extent about 150 acres residentially converted, situated in Jagdala, Karnataka, Keshpuri villages, etc. This is the terms of the agreement. Then consideration was logic may go to page 86. Again, English 4. Sites to be handed over to the society for allotment to its members. Manner of allotment. The second part is the reserve. All the intermediate sites of various dimensions to be identified by the second party for the benefit of the members of the first party. As soon as the second party informs the first party of the formation of the sites for the benefit of the members of the first party, the first party shall allot the same to its members and inform the second party society. After such allotment, second party shall convey the sites to the allotee of the receipt of the same consideration at the rate, etc. In respect of 150 intermediate sites are concerned, retained by the second party as provided in the book. Second party shall be entitled to dispose it in the manner according to it. Then consideration is 225 rupees for cost of development that was fixed. In terms of this agreement, you will article kindly go to page 91 annexure C. The currency project. There are annexure C page 91. It's a model sale is executed in terms of the agreement with the FTO office now. There are several 490 agreements. This is one of them. This is the manner we follow. Then there was a layout. You will article kindly go to page 102 for annexure C. Ali, left side extreme top, one triangle shape, one property. Going to be again, I show it to this, at this. This is the location. This is the site which is the subject matter in all these complaints and others.
There is a V-shaped.
V triangle.
ಅದೇ ವಿ ಅಂತ ಬರ್ದೆ ಅದ ವಿ ಶೇಪ್ ಪ್ರಾಪರ್ಟಿ.
Here, triangle.
ಅದೇ ವಿ ಅಂತಿದೆ ಅದು.
We are close ಆಗಲ್ಲ, ಇದು close ಆಗಿದೆ. Triangle.
Yes.
But this is one of the sites covered under the layout approved by the authority.
ಇದೇನಾ ನೋಡಿ, ಇದೇನಾ?
That is site number 1.
That is 11,000 square feet.
20,000.
ಅಲ್ಲ sold is 11,000. Sold is 11,000. Sold is 11,000.
That was the site. Then the Lord, the developer made a request to the society on 24 to 2023 at connection E Miller page 10. The substance of the request is that he explained there are several sites adjacent to which there may are certain boundary disputes are also there, and there are other problems we noticed. In addition to that, let a 20,000 square foot a huge extent of property. No member could come forward to seek allotment of that site. Therefore, he suggested instead of that, keeping this and to avoid further litigation and make the speedy disposal of the sites and also to enable to farm the sites in the remaining part of the land. He made a request that this may be allotted to the landowners or for the benefit of the landowners. He made a request to the society on 24 to 2023, that is election. But at that time, take your worship to the last paragraph at page 1042. ಮೂರನೇ ಬ್ಲಾಕ್ ನಿವೇಶನ ಸಂಖ್ಯೆ 21 ನಾವು ಈಗಾಗಲೇ ನಮ್ಮ ಸಂಘಕ್ಕೆ ಹಸ್ತಾಂತರಿಸಿದ್ದೀವಿ. ಸದರಿ ನಿವೇಶನವು ಸಂಘದ ಹಂಚಿಕೆ ಮಾಡಬಾರದೆಂದು ನಿವೇಶನವನ್ನು ನಮಗೆ ಹಿಂದಿರುಗಿಸಬೇಕೆಂದು ಕೋರುತ್ತೇವೆ. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 98 ಮಾಲೀಕರಿಗೆ ಸೂಚಿಸಲು ನೋಂದಣಿ ಮಾಡಿಕೊಟ್ಟು ಬೇರೆ ನಿವೇಶನಗಳನ್ನು ಸದಸ್ಯರಿಗೆ ಕಳೆದ 10 ವರ್ಷಗಳಿಂದ ಬಗೆಹರಿಸಲಾಗದ ಸಮಸ್ಯೆಗಳನ್ನು ಬಗೆಹರಿಸುವುದಾಗಿ ಭೂ ಮಾಲೀಕರು ಸಹ ಒಪ್ಪಿ ಮಾಹಿತಿಯನ್ನು ಈ ಮೂಲಕ ತಮ್ಮ ಆಗಾಗ ಸಲ್ಲಿಸಿದ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 120 ಹಿಂದಿರುಗಿಸುವಂತೆ ದಿಸ್ ಇಸ್ ಹಿಸ್ ರಿಕ್ವೆಸ್ಟ್, ಡೆವಲಪರ್ಸ್ ರಿಕ್ವೆಸ್ಟ್. It is for the a suggestion given by him for the benefit of the society. That's all. Then, my lord, this subject was placed before the board of directors in the meeting page 105. This is the resolution. Item number 2. In which, my lord, on receipt of this request, a matter was debated, deliberated by the board of directors in their meeting. Then a subcommittee among the members of managing committee was constituted to review the pros and cons of the opinion suggestion given by him. And it was society was asked to furnish their opinion. My lord, may I kindly see paragraph 2, subject number 2. It also consisting of the complainant also, my lord. B. Balakrishna Kumar, Srimati Pankaja, M.L. Prasad Rao, so and so, so and so. This is the committee we constitute.
Complaint is Pankaja, is it?
Beg your lordship.
Complaint is Pankaja.
Pankaja and Prasad Rao.
And Prasad Rao.
Yes.
You represent, huh?
Our subcommittee.
These are the two complainants.
They are the complainants. Then, my lord, a report was placed by the subcommittee, my lord. Your lordship will get that page annexure G, my lord. Page 110 it appears. 1 minute, my lord.
110.
110. My lord, this particular subject, your lordship will get at page 114, my lord. Last paragraph. ನಿವೇಶನ ಸಂಖ್ಯೆ 120 20,800 ಚದರ ಅಡಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಭೂ ಅಭಿವೃದ್ಧಿದಾರರೊಂದಿಗೆ ಚರ್ಚಿಸಿ ಸದಸ್ಯರುಗಳಿಗೆ ನಿವೇಶನಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡಲು ಈ ನಿವೇಶನವನ್ನು ವಿಂಗಡಿಸುವ ಸಲುವಾಗಿ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದವರೊಂದಿಗೆ ಕಾನೂನಿನಲ್ಲಿ ಅವಕಾಶವಿದ್ದರೆ ವಿಂಗಡಿಸಿ ಕೊಡಬೇಕೆಂದು ಸಕಾರಾತ್ಮಕವಾಗಿ ಸ್ಪಂದಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಅಂತಿಮವಾಗಿ ಬರುವ ಮಾಹಿತಿಯನ್ನು ಆಧರಿಸಿ ವಿಷಯವನ್ನು ಚರ್ಚೆ ಸೂಕ್ತವೆಂದು ಮನಗಂಡು ಉಪಸಮಿತಿಯ ನಂತರ ವರದಿ ನೀಡಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಅಲ್ಟಿಮೇಟ್ಲಿ ಮೇಲೆ ಅವ್ರು ಏನಾರ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ಲಿ, if it is possible to farm the sites in this piece of land with the planning approval of planning authority, ಅದಾಗಕ್ಕೆ ಸಾಧ್ಯ ಇದ್ರೆ ಅದನ್ನ ಮಾಡ್ಬಿಟ್ಟು it could be amenable to members benefit ಅಂತ. This was the resolution and that was ultimately decision taken by the society based on subcommittee report. The matter stood thus. Here is a very clinching issue. Page 118 at Annexure J. When these processes are pending, shockingly and surprisingly, this Lakshman developer executed a sale deed in favor of Ramesh Babu, Kavita and others on 25/8/2023. That is in respect of site number 120, measuring 20,000 square foot.
Yes, even before the society had made any decision.
We are not consented, we are not authorized him. We are not authorized him. Then where are the... Melody, your lordships may kindly go to page 127. This is a sale deed intercept between Lakshman and the purchaser. Society's indulgence is remotely not there. Even remotely not there. Page 127 may kindly be seen. In lieu of selling of this property, Lakshman developer received the sale consideration. That particulars are provided at paragraph Roman 8 at page 127 and 128 and 129. It comes about 1 crore, 2 crore 61 lakh 62,000.
Yes.
Then your lordship may kindly look at the schedule at page 132. This may be an important aspect for your lordship's kind perusal because very scheduled property now restored to the society. And the complainants have got some objections insofar as this is concerned. That is the reason schedule may get significance because of its importance. My lord, what was it is totally measuring 1932.19 square meters or 20,789.09 square meters, bounded by so and so, so and so. This is the boundary.
Yes.
My lord, after this, on 12/3/2024, Annexure K, page 134, Prasad Rao and Pankaja have filed a written complaint to the society. An issue is, my lord, mostly related to that 120 site only, holding that we have sold the property, our indulgence are there, so many other things are alleged therein. I don't want.
What is the allegation against you?
But no allegation is, your lordship may kindly go to page 135 class B. My lord, in the monthly meeting of the administrative committee held on so and so, subject number 2 in the agenda discussed was with regard to the progress in the 3rd and 4th phase project of Hejjala. However, in the draft resolution, it is stated that builder Lakshman Properties had sought to return site number 120 of block 3 to Hejjala him to solve the problems in respect of 18 sites in survey number 92, and said request of the builder have been discussed by the committee constituted for monitoring the progress in 3rd phase at Hejjala village. In the said committee had discussed the same, detail and forwarded the same to the administrative committee for taking a decision, and administrative committee on 28/5/2023 unanimously resolved to hand over site number 120 to the builder to clear the problems of 18 sites in survey number 92. That in charge secretary and the president were authorized by the administrative committee to take further action in this regard. First of all, it is clear from meeting document 18/5/2023 was no subject of agenda with regard to the handing over of this resolution is nowhere there and it never passed at all. It is their assumption. They said it is happened. My lord, we have got the resolution book, my lord. I can place it on record at a particular date. I will show it to your lordships that that was not the resolution. Then, my lord, your lordships may kindly see. Page 139. Then, my lord, on that regard, a matter was again deliberated, a meeting of the committee, dated, my lord, 7/7/2024, annexure L at page 141. Concerned subject is, my lord, at page 143. In related to subject is ನಿರ್ದೇಶಕರಾದ ಶ್ರೀಮತಿ ಪಂಕಜ ಮತ್ತು ಪ್ರಸಾದರಾವ್ ಎಂಆರ್ ಅವರು ನೀಡಿರುವ ಪತ್ರದ ಬಗ್ಗೆ. ನಿವೇಶನದಾರರ ಶ್ರೀಮತಿ ಪಂಕಜ ಮತ್ತು ಎಂಎಲ್ ಪ್ರಸಾದ್ ನೀಡಿರುವ ಪತ್ರವನ್ನು ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಲು ಈ ಪತ್ರದ ಬಗ್ಗೆ ಅಧ್ಯಕ್ಷರು ಪತ್ರವನ್ನು ನೀಡಿರುವ ತಾವೇ ಸಭೆಯಲ್ಲಿ ಓದಿ ತಿಳಿಸಬೇಕೆಂದು ಹೇಳಿದರು. ಈ ಪತ್ರವನ್ನು ನೀಡಿರುವವರು ಒಬ್ಬರು ಎಂಎಲ್ ಪ್ರಸಾದರ ವಿವರವಾಗಿ ಓದಿದರು. ಪತ್ರದಲ್ಲಿರುವ ಅಂಶಗಳ ಬಗ್ಗೆ ಸಭೆಯು ಕೂಲಂಕುಷವಾಗಿ ಚರ್ಚಿಸಿ ನಿರ್ದೇಶಕರಾದ ಶ್ರೀಮತಿ ಪಂಕಜ ಮತ್ತು ಪ್ರಸಾದ್ ಇವರುಗಳು ಪತ್ರದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ನಡವಳಿಕೆಗಳನ್ನು ಇಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಸಭೆಯು ಪ್ರಾರಂಭದಲ್ಲಿಯೇ ವಿಷಯ ಚರ್ಚೆಯಲ್ಲಿ ಹಿಂದಿನ ನಡವಳಿಕೆಯನ್ನು ಸಭೆಯಲ್ಲಿ ಓದಿ ಅನುಮೋದನೆ ಪಡೆದು ಮುಂದಿನ ವಿಷಯ ಚರ್ಚೆಗೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಈ ವಿಷಯದಲ್ಲಿ ಪ್ರಚಾರ ಕಾರ್ಯ ಯಾವುದೇ ಕರ್ತವ್ಯ ಲೋಪವಾಗಿಲ್ಲವೆಂದು ಹೇಳಿದ್ದಾರೆ. ದೆನ್ ಸಬ್ಜೆಕ್ಟ್ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ. ನಿವೇಶನ ಸಂಖ್ಯೆ 120 ಅಭಿವೃದ್ಧಿದಾರರು ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆಂದು ತಾವು ತಿಳಿಸಿರೋ ಬಗ್ಗೆ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬಯಸುವುದೇನೆಂದರೆ 11/3/23 ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಅಭಿವೃದ್ಧಿದಾರರು ನಿವೇಶನ ಸಂಖ್ಯೆ 120 ವಾಪಸ್ ನೀಡುವಂತೆ ಕೋರಿದ ಪತ್ರದ ಬಗ್ಗೆ ಚರ್ಚಿಸಿದ್ದು, ಅಭಿವೃದ್ಧಿ ಬಡಾವಣೆ ಗಡಿ ಸಮಸ್ಯೆಗಳು ಬಾಕಿ ಇರುವ ಅಭಿವೃದ್ಧಿ ನಿರ್ದಿಷ್ಟ ಸಮಯದೊಳಗೆ ಪೂರ್ಣಗೊಳಿಸುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಿದ ನಂತರ ಈ ಬಗ್ಗೆ ತೀರ್ಮಾನಿಸಲಾಗುವುದು ಎಂದು ತಿಳಿಸಲಾಗಿತ್ತು. ದಿಸ್ ಈಸ್ ದ ಓನ್ಲಿ ಪ್ರಪೋಸಲ್. ದೆನ್ ಮೈ ಲಾರ್ಡ್, ಏನಕ್ಕೆಲ್ಲ ಆದರೆ ನಿವೇಶನವನ್ನು ವಾಪಸ್ಸು ನೀಡಿರುವವರು ಮಾರಾಟ ಮಾಡುವವರ ಬಗ್ಗೆ ಸಂಘದಿಂದ ಯಾವುದೇ ಅನುಮತಿಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ನೀವು ತಿಳಿಸಿರುವಂತೆ ಮಾರಾಟವಾಗಿದ್ದರೆ ಈ ಬಗ್ಗೆ ಅಭಿವೃದ್ಧಿದಾರರಿಗೆ ಪತ್ರ ಬರೆದು ಮಾಹಿತಿ ಪಡೆಯಲು ಸಭೆಯ ತೀರ್ಮಾನಿಸಿ ಪ್ರಧಾನ ಕಾರ್ಯ ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ದಿಸ್ ಇಸ್ ದ ದೆನ್. Then, my lord, Vinay Lakshman, a letter was addressed by the society to Vinay Lakshman on 15/7/2024 by the society. Annexure M, my lord, page 145. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸುವುದೇನೆಂದರೆ, ತಾವು ಸಂಘಕ್ಕೆ ನೀಡಿದ 3ನೇ ಬ್ಲಾಕ್ನ ನಿವೇಶನ ಸಂಖ್ಯೆ 120 ಮಾರಾಟ ಮಾಡುವ ಬಗ್ಗೆ ನಮ್ಮ ಸಂಘದ ನಿರ್ದೇಶಕ ಪಂಕಜ ಮತ್ತು ಸೋನ್ಸೋ 7/7/24 ಆಡಳಿತ ಚರ್ಚಿಸಲಾಗಿದೆ. ತಮ್ಮಲ್ಲಿ ಕೋರುವುದೇನೆಂದರೆ, ಈ ನಿವೇಶನವು ಸಂಘದ ಹಂಚಿಕೆ ನೀಡಿದ ನಿವೇಶನವಾಗಿದ್ದು, ನಿವೇಶನದ ಋಣಭಾರ ಪರಿಶೀಲಿಸಲಾಗಿ ಮಾರಾಟ ಮಾಡುವುದು ಕಂಡುಬಂದಿದೆ. ತಾವುಗಳು ಸದರಿ ನಿವೇಶನ ಮಾರಾಟ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಸಂಘದಿಂದ ಅನುಮತಿ ಪಡೆದಿರುವುದಿಲ್ಲ. ಯಾವ ಆಧಾರದ ಮೇಲೆ ಸಂಘದ ನಿವೇಶನ ಮಾರಾಟ ಮಾಡಿರುತ್ತೀರಿ ಎಂಬುದು ಬಗ್ಗೆ ಕೂಡಲೇ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಬೇಕೆಂದು ಈ ಮೂಲಕ ಕೋರಿರುತ್ತೇವೆ. ದಿಸ್ ಈಸ್ ಅವರ್ ಇಂಟಿಮೇಷನ್ ಟು ದಿ ಸೊಸೈಟಿ. ದೆನ್ Vinay, he given one more letter we addressed on 22/1/2025. It's ಬೇಕಾಗಿ. Then all these things happened. Then, my lord, they made a request for a statutory inquiry as provided under section 64 on this. There are 3 points of subject included in inquiry. One is with related site number 120. Second is, my lord, some differences, opinions have been recorded, stated in the meeting of the board. Those differences by minority members have not been recorded, and resolutions have not been properly recorded. This is the three charges made against. Pursuant to that, we have given reply after service of notice, my lord. Lakshman have given a reply to the society at Annexure N.
Yes.
Just I would like to take page 149. Last but one paragraph. ನಿವೇಶನ ಸಂಖ್ಯೆ 120ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಾವು ಕೈಗೊಂಡಿರುವ ಕ್ರಮದಿಂದ ಸಂಘದ 6 ಸದಸ್ಯರಿಗೆ 30 ಅಳತೆಯ ನಿವೇಶ ಹಂಚಿಕೆ ಮಾಡಿ ನೋಂದಾಯಿಸಲು ಅನುಕೂಲವಾಗಿದೆ ಹಾಗೂ ಸಂಘಕ್ಕೆ ಯಾವುದೇ ಆರ್ಥಿಕ ನಷ್ಟವಾಗಿರುವುದಿಲ್ಲ ಅಂಶವನ್ನು ಈ ಮೂಲಕ ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. It is his explanation. Then, my lord, Annexure P is appointment of an enquiry officer for conducting an enquiry. Charges your lordship will get at page 151. First charge is related to 120. Second charge is related to non-compliance of Rule 14 AK. Third is, my lord, Vinnavipraya Namurisde Kartavya Lopa. Descendant note have not been recorded. Then, my lord, the enquiry notice was received. Then your lordship is aware, enquiry was conducted. After the enquiry was conducted, a report was submitted. My lord, report gets some important, my lord. Your lordships may kindly see the report at page number. It is commencing from page 272, Annexure T. The report or a comment with reference subject, my lord, your lordships will get. There are statement of the complainant, statement of the society, then opinion of the enquiry officer. All those are provided and it is extracted as if it was given to them. Then, my lord, Abhipraya at page 300. Last paragraph, your lordships may kindly. This is the enquiry report.
Yes.
ಭೂ ಅಭಿವೃದ್ಧಿದಾರರು ಸಂಘದ ಗಮನಕ್ಕೆ ತಾರದೆಯೇ ಮತ್ತೊಬ್ಬ ಅಭಿವೃದ್ಧಿದಾರರೊಂದಿಗೆ ಅಧಿಕೃತ MOU ಮಾಡಿಕೊಂಡುದಲ್ಲದೆ ಸಂಘದಿಂದ ಯಾವುದೇ ನಿರಪೇಕ್ಷಣಾ ಪತ್ರವನ್ನು ಪಡೆಯದೆ 25/8/23 ನಿವೇಶನವನ್ನು ಪರಭಾರೆ ಮಾಡಿರುವುದು ಮತ್ತು ಸದರಿ ಪರಭಾರೆ ಕುರಿತಂತೆ ಯಾವುದೇ ಪೂರ್ವ ಮಾಹಿತಿ ಮತ್ತು ಘಟನೋತ್ತರ ಮಾಹಿತಿಯನ್ನು ಸ್ವಪ್ರೇರಣೆಯಿಂದ ಸಂಘಕ್ಕೆ ನೀಡದೇ ಇರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಅಲ್ಲದೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 120 ಸುಮಾರು 20,789 ಅಭಿವೃದ್ಧಿ ತಿಳಿಸಿರುವುದು ಸಂಘಕ್ಕೆ 11,789 ಚದರ ಅಡಿ ನಿವೇಶನ ನಷ್ಟ ಉಂಟಾಗುತ್ತದೆ. Then, my lord, the last but one paragraph, allade, your lordships may kindly see. What is the allegation against in the report is this. ಅಲ್ಲದೆ ಭೂ ಅಭಿವೃದ್ಧಿದಾರರು ನಿವೇಶನವನ್ನು ಮಾರಾಟ ಮಾಡಿರುವ ಬಗ್ಗೆ ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಗಳಲ್ಲಿ ಚರ್ಚೆಗಳಾಗಿ ಅರಿವಾದ ನಂತರವೂ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ವರದಿಗಳ ಉಲ್ಲೇಖವಾದ ನಂತರವೂ ಅಭಿವೃದ್ಧಿದಾರರ ವಿರುದ್ಧ ಯಾವುದೇ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳದೇ ಇರುವುದು ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರು ಸಂಘಕ್ಕೆ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟು ಮಾಡಲು ಕಾರಣಕರ್ತರಾಗಿರುತ್ತಾರೆ. ಈ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರು ಪಂಕಜ ಮತ್ತು ಸೋನ್ಸೋ ಹೊರತುಪಡಿಸಿ ಪ್ರಭಾರ ಕಾರ್ಯದರ್ಶಿ ಭೂ ಅಭಿವೃದ್ಧಿಗೆ ಜವಾಬ್ದಾರರಾಗಿರುತ್ತಾರೆ. This is the allegation. It's only a dereliction of duty, no indulgence with the transaction. Our hands are not in go with it to develop. Based on that, report was submitted. My lord, the enquiry order was passed under section 68, page 90. Our senior counsel Ashok Karnali read over that. It is the, I don't want to repeat it. Yavaduna? ಓದಿದ್ರಲ್ಲ ಅವರು
68 ಆರ್ಡರ್ ಓದ್ಲಿಲ್ಲ.
ಇದು ಓದ್ಬೇಕಾ? ಓದೋಣ ತಗೊಳ್ಳಿ. ನೀವು ಫೀಸ್ ಕೊಟ್ಟ ಮೇಲೆ ಓದ್ದೆ ಅಂತ ಏನ್ ಹೇಳಿರ? ಇದಕ್ಕೆಲ್ಲ ಸಪರೇಟ್ ಬಿಲ್ ಬರುತ್ತೆ.
ಆಯ್ತು, 68 ಆರ್ಡರ್ ಆಯ್ತು. ಆಮೇಲೆ
ಮೇಲೆ ಕಲಂ 64ರ ವಿಚಾರನ ಪೇಜ್ 317.
17
317. ಕಲಂ 64ರ ವಿಚಾರಣಾ ವರದಿಯ ಅಂಶಗಳು ಹಾಗೂ ವಿಚಾರಣಾದ ಅಭಿಪ್ರಾಯಗಳನ್ನು ಅವಲೋಕಿಸಿದಾಗ ಸಂಘವು ಹೆಜ್ಜಾಲ ಬಡ ಅಭಿವೃದ್ಧಿಪಡಿಸಿರುವ ನಿವೇಶನ ಸಂಖ್ಯೆ 120 2011-12ನೇ ಸಾಲಿನಲ್ಲಿ ಸಂಘದ ವಶಕ್ಕೆ ಅಭಿವೃದ್ಧಿ ನೀಡಿದ್ದರೂ ಸುಮಾರು 20,789 ಚದರಡಿ ವಿಸ್ತೀರ್ಣ ಜಾಗವನ್ನು ನಿಯಮ ಬಾಹಿರವಾಗಿ ಸಂಘದ ಹಾಗೂ ಸದಸ್ಯರ ಹಿತದೃಷ್ಟಿಯಿಂದ ಗಣನೆಗೆ ತೆಗೆದುಕೊಳ್ಳದೆ ಏಕಪಕ್ಷೀಯವಾಗಿ ಯಾವುದೇ ಪೂರ್ವಾನುಮತಿ ಅಥವಾ ವಾರ್ಷಿಕ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಅಭಿವೃದ್ಧಿದಾರರು ಕರಾರು ಒಪ್ಪಂದವನ್ನು ಮಾಡಿಕೊಂಡು ಮಾರಾಟ ಪರಭಾರೆ ಮಾಡಿರು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಸಂಘದ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ವರದಿಯಲ್ಲಿಯೂ ಸಹ ಉಲ್ಲೇಖಿಸಲಾಗಿದ್ದು, ಆದಾಗ್ಯೂ ಇದೆ ಅಷ್ಟೇ, ಸಂಘದ ಮಂಡಳಿಯು ಅಭಿವೃದ್ಧಿ ವಿರುದ್ಧ ಕ್ರಿಮಿನಲ್ಲು ಸಿವಿಲ್ ಕ್ರಮ ಕೈಗೊಂಡಿಲ್ಲ. 120ರ ವಿಸ್ತೀರ್ಣ ಅಡಿಗಷ್ಟು ಪೈಕಿ 9,000 ಸಂಘಕ್ಕೆ ವಶಕ್ಕೆ ನೀಡುವ ತಿಳಿಸಿರುವುದಾಗಿ 11,789 ವಿಸ್ತೀರ್ಣದ ನಿವೇಶನ ನಷ್ಟ ಉಂಟು ಮಾಡಲು ಕಾರಣರಾಗಿರುತ್ತೆ. ದೆನ್ ಡೈರೆಕ್ಷನ್. ಮೇಲ್ಕಂಡ ಕೃತ್ಯಕ್ಕೆ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯವರು, ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕರು, ಅಭಿವೃದ್ಧಿದಾರರು ನೇರವಾಗಿ ಹೊಣೆಗಾರರಾಗಿರ್ತಾರೆ. ಸಂಘದ ಹೆಸರು ಕಾಪಾಡುವಲ್ಲಿ ವಿಫಲವಾದ ಇಂತಹ ನಿಯಮಬಾಹಿರ ಕೃತ್ಯದಲ್ಲಿ ಭಾಗಿಯಾಗಿರುವ ಮತ್ತು ಸಂಘಕ್ಕೆ ನಷ್ಟ ಉಂಟು ಕಾರಣಕ್ಕಾಗಿ ಮೇಲ್ಕಂಡ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರು, ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕರು, ಅಭಿವೃದ್ಧಿದಾರರ ವಿರುದ್ಧ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಲು ನಿರ್ದೇಶಿಸಿದೆ. ಮುಂದುವರಿದು 120ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಘದ ಸದಸ್ಯ ಹಿತದೃಷ್ಟಿ ಕಾಪಾಡುವ ನಿಟ್ಟಿನಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 59/103ರಡಿ ಆಸ್ತಿಯನ್ನು ಆದೇಶಪೂರ್ವ ಜಪ್ತಿಗೆ ಒಳಪಡಿಸಲು ಸಕ್ರಮ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ದಾವಾ ದಾಖಲಿಸಲು ನಿರ್ದೇಶಿಸಿದೆ. ಸದರಿ ಆಸ್ತಿಯನ್ನು ಸಂಘಕ್ಕೆ ಮರಳಿ ಪಡೆ ವಿಫಲವಾದಲ್ಲಿ ಪರಭಾರೆ ಮಾಡಿರುವ ವಿಸ್ತೀರ್ಣದ ಜಾಗದ ಇಂದಿನ ಮಾರುಕಟ್ಟೆ ಲೆಕ್ಕ ಮಾಡಿ ಮೇಲ್ಕಂಡ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯರು ಮುಖ್ಯ ಅಭಿವೃದ್ಧಿ ಹೊಣೆಗಾರನಾಗಿಸಿ ಸದರಿಯವರಿಂದ ನಿಯಮಾನುಸಾರ ಪರಭಾರೆ ಮಾಡಿದ ದಿನಾಂಕದಿಂದ ಬಡ್ಡಿಯೊಂದಿಗೆ ವಸೂಲಿತಿ ಮಾಡಲು ದಿಸ್ ಈಸ್ ದ ಆರ್ಡರ್. Then other report related to enquiry charge number 2 and 3 is nowhere concerned to the board of directors. Then direction at 321 in terms of that.
Yes.
Then, my lord, we raised a dispute. May kindly see the date of order. My lord, dated 6/12/2016. 1/12/2016. It was served on the society on, my lords, 5/12/2025. Under later part of the order at page 321, 45 days time is granted to us.
Yes.
ಈ 45 ದಿನಗಳೊಳಗೆ ಅನುಪಾಲನಾ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುವುದು. This is the complaint. Then, my lord, we raised a dispute under section 70 before the additional registrar. That is annexure W.
Yes.
We narrated. Our prayer is that only. Then, my lord, we made an application for interim relief under section 103. That was also there. We sought for an interim order.
Yes.
ನೀವೇನು ಪೂರ್ತಿ ಪೇಪರೇ ಓದಿಸ್ತಾ ಇದ್ದೀರಿ ನನ್ನ ಹತ್ರ. Page 332 ಮೇಲೆ.
330?
332, prayer in the dispute. 332.
Yes.
Therefore, the petitioner most respectfully prays that this honorable authority be pleased to admit the dispute, issue notice to the respondents, afford an approach hearing to the petitioner, allow the dispute, directing respondent to hand over the scheduled property forthwith without there being any encumbrance charges, in order to enable the petitioner society to allot the register the same in favor of its eligible members, pass such other orders as are deemed fit in the facts and circumstances of the case. This is our prayer. Then we made an application. May kindly go to page 334.
Yes.
That for the reason stated in the accompanying affidavit, the petitioner respectfully prays honorable authority pleased to pass an ad interim order of attachment attaching the property belonging to respondent number 225, which is more fully, that is site number 120, comprised in survey number 92. This is sought to be attached.
225 ಅಂದ್ರೆ ಯಾರು ಇವರಾ?
2 to other purchasers.
Purchasers.
ರಮೇಶ್ ಬಾಬು ಅವರೆಲ್ಲ ಇದಾರಲ್ಲ ಅವರು.
Yes.
Based on that, notice was issued.
Yes.
Matters are pending. At that stage, your lordships may kindly see me. No? Mirror at annexure Y, page 362.
Yes.
16/1/2026 by the society. It is a compliance report, Mirror, we submitted to the authority, in which you have narrated with all the documents what steps we have taken in furtherance to the order of section 68. We explained all these things. Mirror, now page 379 may kindly be seen. 377.
Yes.
After all these things, very same authority now issued a notice under section 69 of the Cooperative Societies Act, initiating a surcharge proceedings against the members of the board. A notice was issued. It is also an order is charges are also referred to therein, and these two proceedings are called in question. This honorable court was pleased to grant an interim order. My lord, several proceedings culminated in multiple hearings. Ultimately, my lord, we made an effort before the authority, got impleaded the developer. He himself impleaded, and he made a request that as per the directions under section 68, property will be restored back to the society. And also we rendered an effort under order 12 rule 6 of CPC, pass an order based on admission as he come forward to restore the property to the society.
He
itself.
reported 69 report.
Regular.
What happened to the order passed in section 69?
It's pending. The stay is pending. There is no further progress. This honorable court was pleased to state that thereafter it was pending. This is the thing. Whereas my submission, several hearings have taken place, culminated before this honorable court. One fine morning, we narrated these facts and what was transpired, how the matter had to be sorted out, is suggested before your lordship. Then, my lord, on 2/7/2026, your lordship was pleased to pass an order. May kindly see the nature of the order. Text of the order for a moment. Dated 2/7/2026. The learned counsel for the petitioner submitted, developer Lakshman, and the subsequent purchasers from developer named so have all agreed to return the property back to the society. They also submitted proceedings initiated before the registrar under section 70 of the Act is sorry, not
Yes, yes.
sorry.
Yes, please.
2/7/2026. The learned counsel for the petitioner submitted, petitioner so and so and the subsequent purchaser and developer named so and so have all agreed to return the property back to the society. He also submitted the proceedings initiated before the registrar under section 70 of the Karnataka Cooperative 659 is listed orders on 10/7/2026. He submitted steps would be taken to reconvey the site number 120 situated Hedjala village, and your lordship determined the date as on before 10/9/7/2026.
Yes.
Of course, my lord, we informed the sub-registrar to log on our draft sale deed. It was not log on. Therefore, delayed. Ultimately, society got the property through a registered sale deed. After we got the registered sale deed, some objections have been filed. Whether the substance objections of the nature of this. In charge, the secretary have taken a decision and he is a party to the sale deed without an authority because it is not preceded by the resolution of the board of directors.
Yes.
Without impediment to pass such a resolution, there is a status quo order granted by this honorable court. We could not able to do anything except, my lord, continuing as a board of directors. From the date of granting interim order of status quo, we are not doing anything at all except after authorized by your lordship to complete the process of execution. This has been completed. Their objection, first part is that. Second part is, their suggestion is, no. This 120 site measuring 20,000, it was sold by Lakshman to third parties, and it is the property belongs to society. Therefore, Lakshman should purchase the property from the third party. In turn, Lakshman has to execute a sale deed in favor of the society. Yes. This was the suggestion. Mirrors a tripartite sale deed. Purchasers are also there. Confronting party, confirming party, Lakshman is also there, and society is also there. Therefore, my lord, it is binding all the three. Then, while passing an order, considering all these aspects,
Consideration.
Your lordship can pass any kind of mandate, making fit for those persons not to act in contrary to their understanding. This court having power under Article 226, issue is before your lordship only. Second point they raised in their counter is, no consideration is passed on the society. But I read the agreement. This property never vests with the society. No conveyance is in favor of the society.
Yes.
It was 2000 site layout. His site was included within the society's layout. No dispute on that. Society never taken any decision to encumber the property either to Lakshman or anybody else. Unauthorizedly, overreaching act have been done by so and so. That anyhow, these are all the matter of all these processes. Then thirdly, my lord, their contention is consideration is not passed on from the society. Lord, your lordship may kindly see, at no point of time, consideration was not received by the society in view of encumbrance taken over by Lakshman in respect of the property in question. Yes. Consideration was received by the Lakshman by the third party. He now refunded the entire amount, more than 3 crores he refunded. Yes. That was the consideration. It would not vitiate the sale deed in any manner, because a property and a sale deed consisting of a consideration of 3 crores, which you have received from the vendors. This is third manner they have contend. Fourth one is secretary is not authorized. Lord, one thing I would like to brought to your lordship's notice, while filing the writ petition, Board of Society have passed a resolution authorizing the secretary to act on behalf of the society in favor of the list is concerned.
Yes.
This is one. Secondly, under section 29G of the Cooperative Societies Act, secretary is a head of the administrative. He has to discharge the duties under the supervision control of the Board of Directors. Yes. And in addition to that, any proceedings to the judicial proceedings, it should be sued by the secretary, or it could be sued against the society on behalf of the secretary society only. This is the legal protection have been extended to the secretary. Yes. Even may not suppose if a resolution is passed, not passed because of an impediment, I refer to a lot earlier, as there is a status quo order. Post facto resolution could be passed, or your lordships can pass issue a mandate to that effect also. It is not an uncurable defect in Allah. These are all certain problems they raise in Milord India to opposing the sale deeds are concerned. My humble request to lordship is, after they filed the affidavit, we filed with the counter, we filed our affidavit jointly after developer, including 4 purchasers, 5 purchasers. They made a consistent statement. They received sale consideration. A Solomon declaration was made in the affidavit that they reconveyed the property in favor of the society.
Still,
this is.
Yes.
Let me give a back.
There are certain resolutions they referred to. Copies of those resolutions.
ಯಾವ resolution?
ಅದೇ ನೀವು ಅನುಮತಿ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಪಡ್ತಾ ಇದೆ.
Okay.
Okay. I'm just giving a synopsis of the dates and events.
The Land Council for the petitioner in WP number 2026 has filed a memo and enclosed there with resolutions passed in society. Same is taken on record.
I'm just giving a list of dates and events.
But how the genesis of this dispute arises is, Lord, there is an agreement that is entered into between the society and my lord the developer. My lord, the developer, my lord, purchases land by taking the consideration given by the society, purchases the land. Because my lords are aware under the Land Reforms Act, there is a restriction. And therefore, my lord, it could not be purchased in the name of any individual or society then. Now it has changed. So therefore, consideration was provided by the society. Purchase would be made by the individual with the understanding that he will form a layout and then he will earmark all the intermediate sites to be made available to the society. That is the understanding. He had no right. My lord, he is bound by an MOU.
It's a turnkey project.
It's a turnkey project. My lord, there are upfront we have paid the monies. Lands are purchased from our funds. When I say our funds, my lord, the society's funds. My lord, we are protecting the interest of, my lord, the society. There is nothing against the society. Now, my lord, what happens is, my lord, there's an extent of 20,000 square feet, where about easily 15 to 16 sites can be carved out. This is not allotted to any person. Surreptitiously, a plan is hatched to give this 20,000 square feet away to Lakshman and various other persons. And, my lord, this is not brought to the notice of majority of the board of directors. It surfaces, my lord, ultimately one day after, my lord, draft resolutions are circulated to be signed after 1 year after the alleged resolutions are passed. I will point out each one of it. At which point in time, my lord, objection is raised saying there was never any proposal to convey this 120 to any third party. How is it that it is coming up for the first time for discussion? It was never discussed. And then, my lord, it led to series of complaints. Primarily, my lord, saying that valuable property of the society has been done away with. It is not so much of returning it back. What was the consideration that has exchanged hands? Why was it given away? And, my lord, why the proceedings are not, my lord, maintained in the manner required by law? Not only that, my lord, they resort to forgery. I will point out each one of these. Now, before that, my lords, may straight away take, my lord, the letter given by the please, my lord, please take the statement of objections in WP number 18567. My lord, that has all the documents, my lord, along with the statement of objections.
Good.
Now, my lord, please take in this the letter, my lord, at annexure R35. Sorry.
Okay, what is the date of filing these objections? 21/4.
My lord, this was filed on 30th of June 2026.
30th June.
18567 ali.
12,000.
My lord, there are 3 petitions. Learned senior, as my lord pointed out. My lord, the latest one is, my lord, 12472 of 2026.
So, which objections do you want me to read?
No, my lord,
Objections filed in which petition?
18567.
18567. Objections.
Lord, along with it, Lord, about 47 documents are produced. Oh. ಅಲ್ಲ ಅದು ಕೊಟ್ಬಿಡಿ ನಾನು ಬೇಕಾದ್ರೆ ಇನ್ನೊಂದು ಕೊಡ್ತೀನಿ. That is my office copy.
ತಗೊಳ್ಳಿ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಫೀಸ್ ಕಾಪಿ ಅಂತ.
I can
ಇನ್ನೊಂದು ಕಾಪಿ ಇಸ್ಕೊಂಡು.
ಅದು ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ಅದಕ್ಕೆ ಬೇಡ.
Yes.
Lord, please take annexure R35, page number 248.
Yes.
Letter, my lord, written by the developer, my lord, to the registrar, Lord, this says what has happened, and I will show how this letter exposes everything. Lord, first paragraph, my Lord, talks about all the understandings, and then, my Lord, please come to now 249. Next, first para. ಆದರೆ 2022 ಸಂಘದ ಹೊಸ ಆಡಳಿತ ಮಂಡಳಿ ಅಧಿಕಾರಕ್ಕೆ ಬಂದಿದ್ದು, ಸದರಿ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಸೋಣಸೋ ಅವರು 2023ರಲ್ಲಿ ಮೆಸರ್ಸ್ ಲಕ್ಷ್ಮಣ್ ಪ್ರಾಪರ್ಟಿ ಸಂಸ್ಥೆ ಸಂಪರ್ಕಿಸಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 120 ಸಂಘವು ಸದಸ್ಯರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ಸದರಿ ನಿವೇಶನವನ್ನು ಬೇರೆ ಯಾದಗಾರಿಗೂ ಮಾರಾಟ ಮಾಡಿ ಎಂದು ತಿಳಿಸಿದರು. So therefore, my Lord, this starts in, please see, my Lord, 2023. This is a letter now written by the developer. ಅದಕ್ಕೆ ಮೆಸರ್ಸ್ ಲಕ್ಷ್ಮಣ್ ಪ್ರಾಪರ್ಟಿ ಸಂಸ್ಥೆಯವರು ಸಂಘದಿಂದ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರ ಕೊಡದ ಹೊರತು ನಾವು ಮೂರನೇ ವ್ಯಕ್ತಿಗೆ ನಿವೇಶನವನ್ನು ಮಾರಾಟ ಮಾಡಲು ಸಾಧ್ಯವಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದರು. ಅದಕ್ಕೆ ಸಂಘದ ಅಧ್ಯಕ್ಷರು, ಏನೂ ತೊಂದರೆ ಇಲ್ಲ, ನಾನು ನಿರಾಪೇಕ್ಷಣೆ ಪತ್ರವನ್ನು ಕೊಡಿಸುತ್ತೇನೆ, ನೀವು ಮಾರಾಟ ಮಾಡಿ ಎಂದು ತಿಳಿಸಿದರು. ಸೊ therefore, my Lord, this is the beginning. Now I will show how, my Lord. Then, my Lord, please see, ಮುಂದುವರೆದು ಮೆಸರ್ಸ್ ಲಕ್ಷ್ಮಣ್ ಪ್ರಾಪರ್ಟಿ ಸಂಸ್ಥೆ, ಅದು ರಮೇಶ್ ಬಾಬು ಮತ್ತು ಇತರರು, ದೇ ಆರ್ ದಿ, my Lord, alleged purchasers. ನಡುವೆ ಸಂಘದ ಅಧ್ಯಕ್ಷರೇ ಮಧ್ಯಸ್ಥಿಕೆ ವಹಿಸಿ ಮಾತುಕತೆ ನಡೆಸಿ. Now, my Lord, why I am showing all these things is, now, my Lord, they are disowning the developer. Now they are also putting some blame on the secretary, saying that we don't have anything to do with all these things. Probably the secretary has done all these things, but the genesis is here. ಅವರೇ ಮಧ್ಯ
all said and done, now that they returned the site, of course, we'll consider the manner in which they have returned.
Yes, my Lord. Now the site has come back. But, my Lord, site has come back at whose cost? When the site was given up, what was the consideration at which, my Lord, this site was given? No explanation about that. Obviously, my Lord, this is not, my Lord, land which is given for donation or endowment or, my Lord, some charity. 20,000 square feet, my Lord, was, my Lord, given up because some of the board of directors, and direct allegation in this letter is, my Lord, the president was interested. He says, please sell it. It is my responsibility to get an NOC from the board. He, my Lord, gets involved, identifies, my Lord, and does madhyastha or the transaction, so-called transaction, and this property goes out of the hands of the society. At what cost? Who is benefited, by Lord, by 20,000 square feet property getting out? My Lord, there is no accountability. My Lord, it is being made to appear before this court that site went out. Now it has come back. Now, my Lord, who received the consideration for, my Lord, this 20,000 square feet, which admittedly, my Lord, belonged to the society? Now, my Lord, it went out. The manner in which it went out is also very interesting. My Lord, 2023 this starts. Now my learned friend very conveniently says, my Lord, senior says, there is no resolution, therefore it has happened on its own. Now I will take, my Lords, to the genesis. My Lord, he says, I will give it back. The board of directors, and more particularly the chairman, my Lord, promised that he will get all these things. Now, my Lord, when this is raised, he says, don't worry, I will handle all these things and I will take it to the logical conclusion. So this is what, my Lord, the developer would give as a letter of undertaking to the society. Now, my Lord, please take the list of dates which I have given. How the proceedings are fabricated. My Lord, I will start with 16th of February 2023, where, my Lord, a meeting was called. Meeting notice is given on 16/2/2023. I will take, my Lords, to the annexures little later. I'll just narrate it so that, my Lord, we get a flow. My Lord, on that day, my Lord, the meeting is not held because of some difficulty. The meeting notice fixed the agenda. Then the very same meeting is postponed and held on 11th of March 2023. In 11th of March 2023, a letter is stated to have been produced, saying that, my Lord, that this site number 120, which is a triangular shape, will be given up, annexure R6, page 80-81. Please note, my Lord, none of this is recorded. Then, my Lord, the next meeting, my Lord, this 11/3/2023 up to 3/3/2024, meetings are not, my Lord, recorded anywhere. Only some verbal discussion takes place. For the first time, my Lord, in loose cut sheets,
The so-called proceedings are produced on 7th of July 2024 for signature. The meeting, my lord, was supposed to be on 11/3/2023. It is made available for signature on 7/7/2024 because all this is, my lord, written to suit their convenience. After, my lord, 1 year, 4 months. Now, my lord, please see I'll just take my lords to that resolution so that my lords kindly sees. All this is written in loose sheets and then ultimately, my lord, given to us on 7/7 where we object. Please turn to the statement of objections where each of these resolutions are produced. Annexure R4 series commences from page number 44 in the statement of objections.
Yes.
My lord, please turn to page number 49, where, my lord, 3 directors, my lord, sign the meeting that is stated to have been held on February, March 2023.
Now, where is that? It's in the objections filed by WP number?
WP number, my lord, 18567, which I just now gave, my lord. Another copy. In that, my lord, please take annexure R4 series commencing, my lord, from page number 44.
Yes.
Lord, please straight away come to page number 49. Where, my lord, this is made available for the first time on 7th of July 2024. My lords will notice on the left hand side, 3 directors, my lord, have signed and put the date. But rest of the directors, my lord, don't put the date and make it appear as if, my lord, it is recorded in the very next meeting. This is, my lord, a uniform thing that happens. My lord, please come to page number 55. All this is given on one day. Again, my lord, 3 directors, left hand side, my lords will kindly see 2 signatures are there. And then in the second column, last signature, again 7/7/2024.
Yes. Name signature ilva illello, no?
Left ಅಲ್ಲಿ ಇದೆ. ಅದು ಒಂದು ಪ್ರಸಾದ್ ರಾವ್ ಅಂತ ಕೆಳಗೆ ಅದರ ಕೆಳಗೆ respondent number 5. We have put the date, my lord, and signed. Same thing, my lords will get at page number, my lord, 61. My lord, the last, excluding the last signature, my lord, 3 signatures about that.
Yes.
My lord, this is where, my lord, page number 70. So therefore, my lord, all this is backdated. Page number, my lord, 78.
Yes.
All these proceedings are backdated. Now, my lord, it is very convenient for them to say that the secretary did not do it. For 1 year, 4 months, my lord, if the secretary did not do it, what is it that the other board of directors were doing? That is the first point. Second point is, why is it that they did not object that the proceedings are not drawn up? Now, my lord, please see why all this has taken, my lord, such a... Now, my lord, objections are raised. Please turn to annexure R2, page number 38. My lord, where it is brought in writing to the notice of the president as well as the secretary. My lord, all these irregularities are happening. My lord, please come to page 39. In the monthly meeting of the administrative, para 3, my lord, I am reading. In the monthly meeting of the administrative committee held on 3/3/2024, when the same question was posed to the in-charge secretary and the president, the in-charge secretary has produced draft resolutions of the monthly meetings of the administrative committee on 21/4, 28/5, 37 and 39, so and so dates, in cut sheets, loose papers. On perusal of the draft resolutions of the monthly meetings of the administrative committee, it is seen that in respect of the subjects which were not discussed, proceedings have been falsely recorded. Thereby, we hereby seriously object to the draft resolutions of the monthly meetings of the administrative committee. Then please come to, my lord, each one
Lord, please, sir, page 39. Now, my lord, please take, my lord, para 4B. In the monthly meeting of the administrative committee held on 28/5/2023, subject 2 in the agenda discussed was with regard to the progress of third and fourth
No,
phase
but
project.
correct, Abhinav.
Sorry.
See, all these documents are a run-up
Yes, my lord.
to the conveyance of site number 120.
True, my lord.
This is a process that they've taken, some
Process that they have taken.
underhand dealings, everything has happened.
Yes, my lord.
Now, since it has come back, is it not only academic that, we have to do all these things to find out? Just come back, they owned up their responsibility.
Yes, my lord.
So what is that you want furthermore? You want the proceedings for disqualification to be continued?
Application has already happened, my lord.
Yes.
29C, they have been disqualified. Charge sheet is filed because they have forged the documents. And, my lord, they are completely unfit, my lord, to be the board of directors because, my lord, this is not a clear case of underhand dealing, and not only underhand dealing, but also, my lord, forged documents. My lord, I'll just show one MOU, my lord, annexure R19, page number 135.
One point, my lord, subject to. Now the issue is based upon 68 order. Now, do we need to go beyond what the allegations are there in 68 order and examine allegation of forgery and other things?
Correct.
That would be a
Correct,
matter which come within the jurisdiction. Now, there appears to be some dissident members in the board. Now, the entire issue is culminated into a 68 order. Now, should we not confine, my lord, to the allegations made in the 68 order? Because now going into the forgery and other things, my lord, is just widening the scope subject to what you are.
29C proceedings are initiated on a charge that you have not complied the terms of the order respected. That's the only notice.
My lord, why I am taking, my lords, to all these things is, my lord, there are 3 petitions. 12472/2026, my lord, challenges the disqualification.
Yes.
My lord, that is what my lords will have to see and see whether the disqualification order is proper on the face of it, my lord. Correct.
There is no, we are not argued on merits. Our point was only that contrary to the interim order, they have passed it, which is accepted in the appeal.
I will answer that, my lord. Then, my lord, 10/4/2026, my lord, a special officer is appointed. Because of all these wrongdoings, my lord, special officer is appointed, that is challenged. Which is why, my lord, I am, my lord, taking, my lords, to all these things. Because, my lord, if this material is there and, my lord, we are able to justify the 64, 68, 69, and ultimately, my lord, which leads to 29C, then, my lord, my respectful submission would be that there is no interference called for in relation to all these orders, because everything is based on material document. It is not a site that is coming back, but the manner in which the affairs of the society has been conducted for private gain, and how most of the directors have just towed the line of the office bearers, my lord, who are managing the society. Now, my lord, 2690/2026, my lord, is for filed by the society by the in charge, my lord, secretary. How he gets the power to file, my lord, a writ petition on behalf of the society in relation to 69 proceedings, my lord, is quite surprising, because, my lord, it is filed in the name of the society. Who empowered the in charge society secretary to, my lord, do this? And, my lord, particularly when the
Special officer.
Yes, my lord. Then, my lord, the last one is again at the instance of the board of directors, my lord, who would challenge, my lord, the 68 and 69 proceedings. Now, my lord, their single contention is there is an interim order, and in contravention of that interim order, some order seems to have been passed. That is the argument of my learned senior. And, my lord, virtually the order exonerates. My lord, please see that order which they are referring to is, my lord, annexure R38, page 264.
Yes.
What is challenged, my lord, in this writ petition is the 68 order. Please turn to page number 268.
Yes.
I am answering, my lord, what my learned senior friend has argued.
My lord, the order dated 1st December 2025, my lords will get at page number 268, which was challenged. 268 ಅಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಿದೆ. ಅದರಲ್ಲಿ my lords will get the 1st December 2025 order. That is the 68 order. Then my lord, what is also challenged is the order passed, my lord, on 2nd March 2026, where my lord, the interim order is rejected in the appeal. That was what, my lord, fell for consideration. This rejection of interim order, my lord, is annexure R37 at page 259. That was what was challenged. Their contention was, if an interim order is not granted, our proceedings under the 69 and 29C would be prejudiced if you don't stay this. That was the argument that was canvassed before them. And my lord, please see the submissions which were made at page number 269, para 3. She so and so appearing for the petitioners, para 3 I am reading. Yes. For the petitioners contended that the impugned order dated 1st December is passed under section 68, wherein initiation of proceedings under section 69 of the KCS Act is given effect to. And in that view of the matter, in the event if the proceedings is initiated under section 69, the appeal filed by the petitioners would become infructuous. This was the argument that was canvassed. Then, my lord, please see, according to the learned senior counsel, arguing the impugned order dated 2nd March passed by the second respondent requires to be interfered. Per contra, Srimati so-and-so, respondent number 5, party in person, referred to the findings recorded in the order dated 4th October 2025, passed by the Deputy Registrar of Cooperative Societies, and submitted that the return of land by the developer in respect of the construction of the land has not been raised or considered in the general body meeting, and that the said finding has been recorded after consideration of the material record. Accordingly, she seeks for dismissal of the petition. She so-and-so, learned advocate appearing for response 1 and 3 submits. Respondent number 2, after considering the material and record, had arrived at a conclusion that there is no infirmity in the order passed by respondent number 3 under section 68, and rightly rejected the interim relief sought for by the petitioners. Accordingly, he sought to justify the impugned order passed by respondents number 2 and 3. Then, my lord, please come to page 271, para 7. In light of the submissions made by several counsels appearing for the parties, the filing of the appeal by the petitioners before the second respondent, appeal number so-and-so, is based on the order dated 1st December 25, passed by the respondent number 3 under section 68. In that view of the matter, in the event if such an order is implemented during the pendency of the appeal, the right to the statutory appeal preferred by the petitioners will not inure to the benefit of the petitioners. Therefore, in the ends of justice, respondent number 2 is directed to complete the entire proceedings in appeal number so-and-so, after affording an opportunity of hearing all the parties within a period of 2 months from the date of receipt of this order. It is made clear that till completion of the entire proceedings before respondent number 2 in the aforesaid appeal, no precipitative action shall be taken against the petitioner in terms of the impugned order dated so-and-so, passed by the respondent number 3 under section 68 of the KCS Act. With this observation, writ petition is disposed of. This is nothing to do with, my lord, 29C.
Yes.
Now, what they would do is, my lord, take this and then try to stall 29C proceedings. And ultimately, my lord, 29C proceedings have also culminated, my lord, resulting in their disqualification. Now, my lord, their argument is Sorry, ಯಾವ page number? Page number. ಅದೇ observation.
ಯಾವುದು?
Senior argued, my lord, I'm not able to get that annexure.
Can you please tell me what is that you're looking for?
My lord, the order where my learned friend, senior counsel, read out, saying, no, you will have to give an opportunity and do it, anta. And No. Second volume.
Page 560.
560 alva?
561.
561.
Page number
561, my lord.
of
18567. Volume 2, my lords will have to take.
1856 ಅನ್ಕೊಂಡ್ರಿ.
Yes, my lord.
Volume 2. Page number
561.
Yes. This was the order passed in the appeal.
Yes, my lord. This is the order passed in an appeal. And where 29C was not the subject matter.
Yes.
29C was not the subject matter. My lord, my learned senior, my lord, refer to, my lord, para 3. ದಿನಾಂಕ 21/4/2026 ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ನಂಬರ್ 12472/2026 ರಲ್ಲಿ ನೀಡಿರುವ ನಿರ್ದೇಶನ ಉಲ್ಲಂಘಿಸಿ ಕಲಂ 29C ರೆಡಿ 1ನೇ ಪ್ರತಿವಾದಿ ಅವರು ಹೊರಡಿಸಿದ ಅನರ್ಹತೆ ಆದೇಶವು ಕಾನೂನುಬದ್ಧವಾಗಿರುವುದಿಲ್ಲ. So what, my lord, the argument is that 29C order is passed in violation of the interim order granted, violation of the order granted in WP number 12472 of 2026.
That is right.
My lord, 29C proceedings was not the subject matter of that appeal at all. Appeal, my lord, was under.
But they have taken cognizance of that fact because the learned single judge of this court had specifically held no precipitative action shall be taken in terms of the impugned order dated 112. See, this 29C flows from 112.
My lord, please see, my lord, 21/4/2026. 21 order sheet. 12472. 12472, 21/4, my lord, is in relation to 29C proceedings and, my lord, the appointment of a special officer. Now, my lord, he puts the cart before the horse. He says, my lord, in violation of the interim order granted, 29C order is passed. It is vice versa. 29C was challenged before this court. Please see the order dated 21/4/2026.
In?
My lord, please take WP number 12472 of 2026. My lord, because this is what is referred.
12472.
In page number 561, what the registrar would say is, my lord, that 29C proceedings have been culminated by overlooking the order passed by this honorable court in WP number 12472 of 2026.
Yes.
And therefore, on the face of it, the order may not be proper. That is what, my lord, he says, and that is what my learned friend, my lord, wants to seek to rely upon. Please see, my lord, this writ petition is filed challenging, my lord, the disqualification.
Yes.
So therefore, my lord, saying that I have violated, that the registrar has violated the interim order and thereafter passed the order of disqualification, is putting the cart before the horse, because disqualification order had already been passed, which is the subject matter of 12472. Please see the order dated 21/4/2026. Heard senior counsel, I'm reading, my lord, the fourth para. Heard senior counsel appearing for the petitioner, so and so, so and so. A perusal of the material on record will indicate, though several contentions have been raised by both the parties in support of their respective claims, having regard to the fact that the appeal filed by the petitioners before the second respondent registrar of cooperative society appellate is posted on 20/4/4 pursuant to the order dated 12/3/2026, passed in WP number 8291 in the previous round of litigation between the parties, without expressing any opinion on the merits, demerits of the rival contentions, and by way of interim arrangement and without prejudice to the rights and contentions of the parties, and subject to further orders of this court, the impugned orders at annexure AJ1 to AJ10, all dated 10/4/2006. Well, that is the order of disqualification, as well as the impugned order at annexure AK dated AK dated 10/4/2026. That is the order, my lord, appointing the special officer shall remain stayed till the next date of hearing. Now, my lord, that is misread into this order.
Yes.
And my lord, the learned senior counsel would say, prima facie, he finds that this order is not correct. My lord, order is already passed.
Yes.
29.
Otherly, there is one correction. The date, Lord, instead of giving 80 to 91, instead of giving the number in WP 8291, he has given a different number.
Barತೀನಿ, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ. That is what I wanted to clarify. Because, my lord, this could not.
Clearly, you are trying to take advantage of the.
No, I am only trying to say that it will not inure to your benefit, because, my lord, this observation was only, my lord, keeping the disqualification and appointment of the special officer in abeyance. Now, quoting that order.
ಅಬಯನ್ಸ್ ಅಂತಿಲ್ಲ, ಅವ್ರು ಹೇಳೋದು ಫ್ರೆಶ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಇಲ್ಲಿ ಸಾಹೇಬರು ಹೇಳಿರೋದು ಇಂಟ್ರಿ ಮಾಡಲ್ ಹೇಳಿರೋದು. So therefore, my lord, that order is not violated, and my lord, nothing is done in this order which would, my lord, come in the way of.
What is saying is that must have been 8291.
81. I'll deal with 8291, because, my lord, that writ petition number is incorrect. So therefore, that will not inure. Now he wants to read something into it, my lord. I will deal with that also. Now, my lord, please take that order. Because, my lord, what my learned senior is saying is, on the face of it, I need not get into the merits. That may not be correct. ಅಲ್ಲ 8291 order ಅಲ್ಲಿ page number
8291 is at page 272. Of your compilation 18567.
Yes, my lord. 8291.
36. Number 257.
Lord, the direction is to dispose of the appeal.
No, but it says no precipitative action shall be taken against.
Yes, my lord. In terms, no precipitative action was there. In fact, the previous, my lord, PC8, in the ends of justice, they are directed to complete the proceedings in appeal number so and so.
Correct.
Yes, my lord. This appeal is against 68 proceedings.
Correct.
So what they said is, please conclude the appeal. No precipitative action was taken.
Yes.
What they said was, please conclude the appeal. Don't take any precipitative action. Precipitative action was not taken. But 69 order cannot be said to be a precipitative action, because the direction is, my lord, please conclude the appeal, which means pass and final order. So therefore, that observation also will not inure to my learned friend's observation. And on the contrary, my lord, please take annexure R36 at page 257. My lord, this is the writ petition in 2917/2026, page number 251, annexure R36.
Yes.
My lord, what was challenged there, my lords will kindly see page number 255. This is again, my lord, by the board of directors. 255, my lord, the first order that is challenged is 1st December 2025, that is 68 order. Page 255, my lords will kindly see 1/12/2025, that is, my lord, 68 order. Then, my lord, what is again challenged is the notices issued under 29C, initiating proceedings under 29C. Those notices were, my lord, challenged before this court. Lord, please come to 256. The petitioners have filed this petition seeking quashing of the order dated 1/12/2025, that is 68 order, passed by the additional registrar so and so, and also seek for quashing of notices. Then, my lord, learned Shri so and so, learned senior counsel for the petitioner submits the petitioners aggrieved by the order passed by respondent number 3, vide annexure V, filed an appeal before the appellate authority. He submits that the appellate authority has not passed any order on the appeal filed by the petitioners. He submits that direction be issued to the appellate authority to dispose of the appeal within a time-bound manner. That is because, my lord, interim order was not granted, which ultimately was rejected. And, my lord, came before this court where, my lord, they said,
Yes.
submit replies to the notices dated so and so at annexure ends. As the petitioners aggrieved by the order dated 1/12/2025 vide annexure V preferred an appeal before the appellate authority, and appellate authority has not passed any order on the interlocutory application to stay the execution and operation of annexure V, that is 68 order, it would be proper if a direction is issued to the appellate authority to consider the application for stay and execution of annexure V. Therefore, my lord, it is disposed of. Please see, my lord, direction to appellate authority is directed to dispose of the application for stay of execution of operation of annexure V 68 order within 15 days. Liberty is reserved to the petitioner to reply to the notices within 8 days from today, and thereafter respondent number 3 is directed to consider the reply and pass appropriate orders in accordance with law within 2 weeks from the date of receipt of the copies of the reply. So therefore, that also, my lord, this court directed, saying that you please dispose it of within 2 weeks. After, my lord, the replies are, all contentions of the parties are kept open. The appellate authority, before passing any order on the application of stay, shall hear the petitioners and respondent number 5. So therefore, my lord, nothing is violated while passing the order. And, my lord, 29C is on a completely different footing. The genesis may be same, my lord. Facts may constitute, my lord, 64. Facts may also constitute, my lord, 68, 69. No, my lord, I'll only give reply to, my lord, their dispute. In fact, before that order was passed, please turn to, my lord, page number 283. My lord, they take this and say, please don't pass orders under 29C. That is the mischief that they want to play.
283 of?
283 of the statement of objections. Annexure R41. ಅದೇ ನಾನು ಈಗ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಒಬ್ಜೆಕ್ಷನ್ಸ್ ತಮ್ಮ ತೋರಿಸ್ತಾ ಇದ್ನಲ್ಲ, where I just now read I read annexure R36. I'm requesting my lords to take annexure R41 in the very same compilation, page number 283. What they are saying is this order is passed in violation of the other order passed by his lordship. Therefore, my lord, a clarification was sought. In the, my lord, 8291 is the writ petition, my lord, disposed of by his lordship, my lord, Justice Indaresh. My lord, that they would go and, my lord, present it before 29C and say, you please stop it. In the above writ petitions, petitioners have sought for quashing of order dated so and so, that is 68 order. In writ petition number 2917, the petitioners challenge the order dated 1/12/2025, passed under section 68 of the Act, and also challenge notices under 29C of the Karnataka Cooperative Societies Act, wherein the Honorable Court on 10/2/2026 disposed of the writ petitions, reserving liberty to the petitioners to reply to the notices within 8 days from the said date, and the additional registrar of cooperative societies were directed to consider the reply and pass appropriate orders within 2 weeks thereafter. Further, in WP number 8291 of 2023, petitioners challenged the order dated 1/12/2025 passed under section 68 of the Karnataka Cooperative Societies Act, where this honorable court, after hearing the matter, disposed of the writ petition on 12/3/2026, directed respondent number 2, registrar of cooperative society, to complete the entire proceedings in appeal after affording an opportunity to all the parties in 2 months from the date of receipt of the order. In WP number 8291 of 2026, there is no challenge to section 29C proceedings. The Honorable High Court in the said writ petition directed respondent number 2, registrar of cooperative societies, to complete the proceedings within 2 months. Therefore, it is made clear respondent number 3, additional registrar of cooperative societies, shall comply with the order dated 10/2/2026 passed in WP number 2917/2026, which is just now read before my lords. In view of the above, I am of the opinion this is not a fit case to prefer an appeal. So, my lord, nothing was done. And, my lord, the direction given in WP number 2917, my lord, of his lordship Justice Kinigi, my lord, expired on 5/3/2026 if the dates are seen, my lord. That is disposed of on 10th February 2026. And he said, my lord, please dispose it off on 5/3/2026. And my lord, opinion is given thereafter because they would go and, my lord, try to interdict 29C proceedings, my lord, by showing the order passed by this court, my lord, by His Lordship Justice Indirect. That is, my lord, the cat and mouse game that they are playing. Now, my lord, they would come and say, no, there was an interim order. Despite there being an interim order is passed. My lord, what is the registrar, my lord, expected to? There is, my lord, direction saying you please receive it, conclude it. And, my lord, then they would take this order and say, no, don't pass order. My lord, in fact, he has, my lord, written to the, my lord, Office of the Advocate General, my lord, taken an opinion, thereafter proceeded, my lord. No, therefore, malafide or malice can be attributed. He has acted, my lord, under legal advice. And, my lord, he has not violated or, my lord, interdicted or, my lord, disobeyed any of the directions given by this honorable court. So, therefore, my lord, if that is the only ground that is they are pressing, my lord, then that will not come to their aid. That is all that I would say. On the merits of the matter, which is why, my lord, I was trying to show my lords, my lord, that 68 order, 64 inquiry, my lord, everything is backed by, my lord, this thing. Now, FIR is filed, my lord, charge sheet is filed, where they have been found to have, my lord, violated and tampered with documents. My lord, they backed it.
That is not the subject matter.
That is subject matter, my lord. That's subject matter.
It's also subject
Yes, my lord.
matter
Yes, my lord. Definitely.
Of these petitions?
Yes, my lord. Yes, my lord.
Yaudu? 111.
That is not the subject matter of this case.
111 is not the subject matter.
29C finding.
Criminal proceedings are registered on 111 ತಾನೆ? 111 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? That is not the subject matter.
ಅಲ್ಲ ಹೇಳಿದಾರೆ. I will just show, my lords.
ಕೊಡ್ರಿ ಇಲ್ಲಿ Act
29C ಅಲ್ಲಿ.
29C is one.
Yes, my lord.
Registering criminal proceedings is under section 111 sir.
111 embezzlement of fund and
111 ನೋಡಿ. Sanction ಅದು.
enabling provisions
of 109. That's a separate independent proceeding.
Yes, my lord. Criminal proceedings.
That is not challenged here.
That is not challenged. That is not challenged. What I am trying to say is, my lord, that there. Lord, if 18567, please take any one of the notices, my lord, and orders that are passed. I will just, my lord, request my lords to kindly take, my lord, annexure AJ, page number 413 in WP number 18567.
Page number?
Page number 413, my lord. Annexure AJ.
Yes.
Lord, where disqualification, my lord, order is passed, there, my lords, will kindly see.
Yes.
Please turn to page number, my lord. Incidentally, it is 420. ಆರೋಪ ಒಂದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಾಧಿಕಾರದ ಅಭಿಪ್ರಾಯ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Then they talk about, my lord, the MOU being fabricated. ದಿನಾಂಕ 5/4/2023 MOU ಅನ್ನು ಸಂಘಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದು ಎಂಬ ಹೇಳಿಕೆಯನ್ನು ಸುಳ್ಳು ಎಂದು ಸಾಬೀತಾಗಿರುತ್ತದೆ. My lord, what is that MOU? I will just show. Please see 5/4/2023. My lord, to substantiate their illegal, my lord, endeavors in trying to palm off this property, my lord, they produce one MOU dated 5/4/2023, which my lords will get at annexure R19 in the statement of, my lord, objections. R19, page number 135.
Section 68. This is independent.
Yes.
Lord, they produce an MOU dated 5th of April 2023.
Yes.
And, my lord, this, they say, is given to the board of directors and placed before the board as an endeavor, my lord, to somehow justify the sale of this property bearing site number 120. Lord, then we have sought for verification. There is a e-stamp online verification report, which my lords will get at page number 165, because, Lord, this is drawn on a stamp paper.
165, huh?
Yes, my lord. IG one letter ittalla elli IG one letter. 125, my lord will kindly see the stamp paper which I just now showed to my lords at page number 135. 135, my lords will kindly see there's a certificate number. And my lord, this is shown to have, my lord, given on 10th of February 2023. And they say, my lord, MOU is executed on this because, my lord, because of the meeting dates which I just now gave, my lord, they want to justify that stamp paper was purchased then and then subsequently the MOU is given. Now, my lord, please see the e-stamping verification, very same certificate number, IN, my lord, KA so and so, ending with 3303X. My lord, it is issued on 11th April 2025. Much after the date of the so-called MOU.
But how did this
fabricated, my lord, this is fabricated, which is why I am saying, my lord, there is a criminal case that is booked, now charge sheet is filed. My lord, if the board of directors were to resort to such fabrication and, my lord, justify this MOU as having been given in February itself in the board of proceedings, in the proceedings of the board, and, my lord, we have also taken, my lord, page number 219.
No, but this is not by the society. Not by the, this is done by the developer.
This is, my lord, by the developer, but my lord, their explanation is, please see, my lord, their explanation. Please take annexure R18, which, my lord, has not surfaced anywhere. They only give this explanation and then they don't give this anywhere else.
Yes.
Please see page number 128 male ಅಭಿವೃದ್ಧಿದಾರರು ವಿಚಾರಣೆ ಕಲಂ ನೀಡಿರುವ ಪತ್ರಿಕೆಗಳ ಸಂಬಂಧಿಸಿದಂತೆ ದಿಸ್ ಇಸ್ ಆಫ್ಟರ್ ಮೈ ಲಾರ್ಡ್ ನೋಟಿಸಸ್ ಆರ್ ಗಿವಿಂಗ್ ದಿನಾಂಕ 16/3/2025 ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಸೋನ್ಸೋ this MOU is given. This MOU dated is given to the board of directors on 16/3/2025.
Correct, but how are the society directors responsible?
But if this is not executed in March of 2025.
Fair enough. But this is done by the developer and the purchaser.
The developer says, my lord, it is done. And the developer, my lord, says this is on 5th of April 2023.
Correct.
And my lord, he has given it to them. And my lord, they, my lord, produce it on 16/3/2025. In the explanation, they say this is given to us, but this is not noted in any of the proceedings. Why is that, my lord?
You please tell him.
Sir, ಅವರು ಎನ್ಕ್ವೈರಿಗೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡ್ತಾರೆ on 19/5/25. They produced, it is they who produced it before the enquiry officer, stating that it was given by the builder on 16/3. When the paper itself was purchased on 11/4, how it can be given on 16/3? It is they who produced it before the enquiry officer. A month before, it can't be produced. So these people are involved in all these things. Along with their explanation,
No,
it is they who
that
produced
is what
it.
I was trying to point out, my lord. The developer ಮಾಡಿರೋದು ಅವ್ರು ಮಾಡಿಲ್ಲ ಅಂತ.
But these people have produced this before the
ಅದೇ
enquiry
developer
officer.
ತಂದು ಕೊಟ್ರು ಅವ್ರು
But it can't be. ಕೊಡಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. 11/4ಕ್ಕೆ ಪೇಪರ್ ಪರ್ಚೇಸ್ ಆಗಿದ್ರೆ ಸ್ವಾಮಿ 16/3ಕ್ಕೆ ಕೊಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಇವ್ರ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಕೊಡೋ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ನೇ 19/5ಕ್ಕೆ. 9/4ಕ್ಕೆ ಎನ್ಕ್ವೈರಿ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ, 11/4ಕ್ಕೆ ಪೇಪರ್ ಪರ್ಚೇಸ್ ಆಗುತ್ತೆ, 19/5ಕ್ಕೆ ಏನಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ತಾರೆ, ಈ ಒಂದು MOU ನ 16/3ಕ್ಕೆ ಮೀಟಿಂಗ್ ನಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ತಾರೆ. 16/3 ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಕೊಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಪೇಪರ್ ಪರ್ಚೇಸ್ ಆಗಿರೋದೇ 11/4ಕ್ಕೆ. Because of this reason, charge sheet has been filed against these people, and because of this reason, 29C has been passed against these people. 29C findings ಇದೇ ಹೇಳುತ್ತೆ ಸ್ವಾಮಿ. ಅವ್ರ ಪೇಪರ್ ಕೊಡಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ, ಹಾಗಾಗಿ these people are involved in this illegality ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
Lord, what is, my lord, done is, my lord, we are being carried away by the date of 23, but this is actually, my lord, 25. And, my lord, this is after the notice is given by the authorities as an explanation. This is given, and this is stated to have been given on 16/3/2025. Fact of the matter is, my lord, paper is purchased, my lord, subsequently.
Correct.
So therefore, my lord, it is, and this is given as explanation by the board of directors to the inquiry. It is not the other way around. So therefore, my lords, will kindly see that 29C proceedings, my lord, is based on material available. They have gone to the extent of, my lord, giving 4 fabricated agreements. My lord, the entire meeting proceedings are not recorded, subsequently tampered. And the other aspect, my lords, will kindly see is, my lord, that 16 sites, my lord, were bifurcated. 16 members, my lord, would have got 16 sites if they had conveyed back, my lord, those 16 sites back to us, or, my lord, to the developer. What they do, my lord, is further to put spokes. All the 16 sites, my lord, which had been subdivided after taking, my lord, permission from the authority, is amalgamated. If, my lord, the 16 sites had been given to the society as 16 sites, my lord, easily it could have been allotted to various persons.
Now, was it conveyed after amalgamation or before amalgamation?
Before, my lord, it was conveyed as 20,000 square feet. My lord, it was then subdivided into 16 sites. And then, my lord, it was again, my lord, the 16 sites which was subdivided could have been given back. When it was given, my lord, it was given as one site of, my lord, 20,000 square feet. There is no difficulty about it. Subsequently, my lord, before the reconveyance could take place, it was divided into 16 sites. 16 new khatas were given after taking permission from the concerned authorities. And, my lord, 16 sites could have been given back, because all along, my lord, their explanation, everywhere they say we will return back these 16 sites. That is their explanation. That is to put spoke in the, my lord, wheel. They would, my lord, amalgamate all the 16 sites, make it one site, and then, my lord, give it back. And now the secretary says, my lord, that no, we will now get it bifurcated and further allot it. Because, my lord, they want to delay the process. Because if 16 sites comes back to the society, my lord, very next minute, my lord, it can be allotted in a manner known to law and given to the members. They don't want that, because they want us to now undertake.
That we can follow it up.
That can be done.
That can be done.
That can be done. No difficulty about it, my lord, but the manner in which all these things are happening, then, my lords, will kindly see. Of course, irregularity is one thing, my lord. It is like stealing, my lord, article, gold article, and saying gold article is, my lord, given back. So therefore, absolve me of the act of theft. Act of theft cannot be absolved, my lord, just because the article comes back or the immovable property has come back. Then the second aspect is, my lord, please see, my lord, they are repeatedly pointing before this court about the dispute. The dispute can be filed against the members.
Yes.
Admittedly, purchasers and the developer are not members of the society.
Yes.
They have instituted dispute in such a way just to show that no, we are pursuing it. They are not members, my lord. The purchasers are not members, and they want, my lord, please see the manner in which the dispute is filed. The property itself is not described in the dispute. ಅದೇ dispute ಅವರು ತೋರಿಸಿದ್ರು ತಮಗೆ ಇದರಲ್ಲಿ
section
70 dispute. ಅದರಲ್ಲಿ ಮೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಶೆಡ್ಯೂಲೇ ತೋರಿಸೋದಿಲ್ಲ ಅವರು. And, my lord, it is not against the members. Lord, page number 322 in WP 2690. Annexure, my lord, N, I think.
Yes.
My lord, please see, it is filed against, my lord, the developer and the purchasers. Nowhere, my lord, as far as I remember, subject to correction, do they say that these are members of the society and therefore a dispute is maintainable. Now, my lord, please come to the prayer at 332. No schedule is there. And the dispute would show at page number 331. it is submitted that as stated supra, respondent number 1, without bringing it to the knowledge of the 331, 2690 of 2026, if the dispute petition averments, my lord, contradict the explanation which they have given in.
Page number?
My lord, page number 322, annexure N. What they would say in the my lord, this is instituted against Lakshman.
Yes.
And my lord, the purchasers, none of whom are, my lord, to my knowledge, my lord, members. They don't say in the dispute petition that they are members. Section dispute 70, my lord, is maintainable against members.
Yes.
And my lord, what story they would want to weave here is contrary to the explanation which I just now showed about the MOU, as well as the explanations which they are giving. Please see, my lord, page number 328, para 12. It is submitted that such being the case, respondent number 1, without bringing to the knowledge of the petitioner society, has sold and conveyed all that piece and parcel. So their case here is, my lord, it was not brought to our notice. But the explanation is, the developer gives us a MOU. That MOU we are placing before you as an explanation. Why is it that the MOU is not brought here, my lord, before in the dispute procedure? Because, my lord, the answer is evident. All this is, my lord, backdated. And now, my lord, please see, at the end of the dispute, my lord, no schedule is mentioned. Please turn to para 17. Where they say site number 120 carved out of survey number 91 and 92. We are doing this to comply with 64 and 68. So 64, 68, my lord, they cannot, my lord, now say it is bad, because they say we are trying to comply with that, and no schedule is produced to the dispute. But dispute itself is not maintainable because, my lord, it is not against, my lord, the members. It would be one without jurisdiction. Now, secondly, my lord, insofar as the sale deed is concerned, that sale deed is produced, my lord, along with, my lord, an affidavit.
Yes.
Filed by the in-charge secretary in 2690/2026 proceedings. They have filed an affidavit.
Yes.
On 5th of August 2026. No, please.
When was this? When was this filed?
Lord, this was filed on, my lord, August, in pursuance of the orders passed by this honorable court, my lord, where they undertook that they will file.
August ondiದೆ.
12th August. Affidavit, my lord, is dated 5th August. Affidavit at page number 8, my lords will kindly see, is dated 5th August. It is filed before this court on 12th. Trying to give an explanation.
Yes.
Lord, please come to, my lord, internal page 6. I submit that perusal of the aforementioned sale deed, it is crystal clear that conveyance of property 120 was made in favor of the petitioner society, and the sale consideration of rupees 3 crores 10 lakhs. My lord, I don't know how this amount is arrived at. Obviously, my lord, if this was sold to them, at what price was it sold? Where did the consideration go? Was paid by the confirming party, that is developer, who received the sale consideration from Hari Prasad and others under the sale deed dated 25/8/2023. Details of the payments are shown below. Then, my lord, please come to 19. It is relevant to mention here that the aforesaid payments were made by the developer in favor of Hari Prasad and others, pursuant to the issuance of notice by the petitioner society, asking him to restore the property back to the petitioner society. Lord, this is my lord, page 7, para 19. Now, my lord, please take the sale deed. If my lord takes the sale deed, which my lords will get at page number 75. My lords will kindly see the consideration amount.
That you have pointed it on the last edit.
Yes, my lord. My lord, the reason for them seeking for, my lord, the conveyance of this property in favor of the society is at page 81, where they would say there is an order passed, we discussed, and therefore we have called upon the developer to do it. Now, if my lord were to kindly see the payments at page 83, my lord, first payment is 7/10/2024, 50 lakhs. Nothing to do with, my lord, any of these things. So some transaction, my lord, is sought to be, my lord, brought within that. Now, my lord, the other thing that would be, my lord, is, my lord, will they also, my lord, say that they will undertake for the capital gains? No, my lord, the society has got this property. Now it becomes an asset.
Yes.
Now, my lord, without consideration, they would sought to support, my lord, a void sale deed, if I may say so, by filing affidavits. The Supreme Court has said if a document is void, any amount of your supplanting subsequently will not make the document valid. It doesn't take much time for them to say, my lord, that no consideration has passed. There are tax implications, my lord, which will come if the society has to give it to the member. Then, my lord, there's a capital gains tax. All those will come, and it is unnecessarily, my lord, creating problems for the society just to make sure that even this property comes back, my lord, it will not be able to be allotted. Now, the letters which they would, my lord, say so, page number 24, if my lords were to kindly see. They say the society asked the property back, and which is why we have given it back. Society's letters are produced. No request is made. So, my lord, all these things, my lord, would show that even if the property has come back to the name of the society for namesake, my lord, nothing, the society will not be able to do anything with this. My lord, no bank will give the loan. And, my lord, it has to be bifurcated. Of course, that can be pursued. But then if the parent document, my lord, itself is such, my lord, those are practical aspects. So therefore, my lord, coming back to, my lord, 68 order, initiation of criminal proceedings, initiation of 29C, and initiation of disciplinary proceedings are all, my lord, part of 68 order. And, my lord, that is not complied. No disciplinary action is initiated. Therefore, my respectful submission, my lord, is that all the three writ petitions will have to be, my lord, dismissed.
Yes.
And, my lord, even when, my lord, there is a special officer appointed, status quo, my lord, directed to be maintained. My lord, this sale deed is executed, whereby I don't know, my lord, how they have organized the stamp duty. So therefore, my lord, 29C, they are clearly disqualified. Question of them permitting to continue, my lord, in the board will not arise. The special officer is there, my lord, he will have to take further action in accordance with law.
Non-members cannot be added as party to the district. They look at section 117, section 11.
Yes.
It is on the caption of procedure for settlement of disputes. Powers of the registrar or administrator. Decision under section 7. It's a reference under section 1 regarding 70 and 70.
107, huh?
117, 117. That's subsection 3A. And first one is procedure of settlement. If the registrar, 3A may kindly be seen. If the registrar or any other person to whom the dispute is referred satisfied that a person, whether be a member of the cooperative society or not, has acquired any interest in the property of a person who is a party to a dispute, he may order that person who has acquired the interest in the property may join as a party to the dispute, or any decision that may be passed on the reference by the registrar or the nominee or any other person shall be binding on the party to join in the same manner as if the original party to the dispute. Lord, your Lordship may kindly recollect, Land Acquisition Act number ability. Award was not conferred with the status of the decree.
Yes.
Our land acquisition of the order, award as person with the benefit award, he has to file a suit for recovery of the award. That was amended and
ಇದು
listed as a decree.
70 subclause 2E ಓದಿ ಅನ್ಸುತ್ತೆ. 70 subclause 2E. And of course, read with section 117.
Yes.
117, my lord, operates differently. My lord, there, if there is a dispute, my lord, which is involving the society of its or its members, and my lord, non-member, my lord, acquires a right in it. The day on which the dispute was filed, my lord, it was not the society's property. It was a property of 4 individuals. They don't file any dispute against the members of the society. It is not their case that during the pendency of the dispute, my lord, a non-member has acquired a right. My lord, 17(3)(a) will apply when a...
No. If you look at section 72E.
Yes, my lord.
Have a look at section 72E.
A crime by a cooperative society for any member, received officer, forced grant, agent, consent, forced settlement.
So a dispute is maintainable by a society for any deficiency caused in the assets of a cooperative society.
Yes, my lord.
Now, if you look at section 117,
My lord, by a member, past member, it is
correct. So if there's any deficiency caused to a cooperative society property, proceeding under section 70 is maintainable. Suppose if the property is alienated.
Lord, it should have been, my lord, if I follow what my lords are saying. If the society had filed it against all the board of directors and then made an allegation, look here, the developer acting at the instance of the board of directors has done it, then my lord, it is a different scenario. That is not the dispute is what I'm trying to say.
Yeah, I understood.
Yes, my lord, yes. Such a scenario, my lord, I have no difficulty. In fact, my lord.
170 is very clear. A person acquires an interest in a property purchased or acquired by a person, and in such a person who acquires the title through the member, he can also be added. Correct. To render the judgment and award passed under the act would be binding on him also.
Yes, no difficulty.
It is a convenient for the purpose of its enforcement. Otherwise, we cannot enforce the award.
Yes.
Developer is a member.
Developer is a member, huh? Developer is a member.
Developer is a member. Ultimately, later I wanted to say, Karnataka andaje ಹೇಳ್ತಾರೆ. History ಇರೋ ಹೆಂಡತಿನ ಗಂಡ ಒಳ್ಳದ ಗಂಡ ಮೊಸರಲ್ಲಿ ಕಲ್ಕಂಡ. That we prepared a very good menu. It was excellent.
Yeah,
ಆಮೇಲೆ he wanted to search a stone.
No, it's a case of robbery going wrong. That is all.
Direction under section 68. Applications.
Yes, my lord, against whom it should have, respondent should have been the board of directors. Board of directors, in-charge secretary, my lord, who is, my lord, the person who is behind all these things, he becomes, my lord, suddenly the disputant. My lord, in fact, the first respondent should have been the in-charge secretary, and board of directors should have been the respondent. In fact, my lord, it should have been done by the special officer.
One thing is certain, in our experience, in such an easy manner, defect and deficiency were not never made right at any point of time, any problem, except this.
That is because, my lord,
In my experience, I am telling you. Very ultimately, they must be happy, everyone must be happy, because it's a judicial employees house building society.
And yet all these things
Model
happen.
for the others.
No,
You say this is a model?
No, definitely not, my lord. This should not be a model.
But that is justified.
No, don't even advocate that this should be a model.
What I am saying is, in such an easy manner, they may not consider things. They will fight it till the Supreme Court. Thereafter, they will abide by it. You are not advised anything. Immediately, they said, record it, record. Some mischief period in a governance, It may happen. It is not only in a cooperative society, country it is happening. It doesn't mean that every thing is amenable for things.
Don't draw a parallel between the country and a cooperative society.
Learn one or 2 points by way of reply. The 68 order itself recommends that 29C proceedings will have to be initiated. Now, on that basis, 29C proceedings are initiated where the allegation is based upon 68 report only. So when the court says don't precipitate action, they cannot initiate 29C proceedings based upon 68 report. That was the basis. But that our point has been accepted. I don't know where is the question of going into it. The registrar, while considering the appeal, has accepted that we will have to initiate first proceeding.
Yeah.
As and when they initiate first proceedings, it has to be seen. Ultimately, now all of them are members of the board. They wanted the site to come back. Now it has come back. Now they are raising objection even with regard to the mode and manner in which it has come back. They wanted sites to be formed. Now, since the compliance, ultimately 68 report is a case where compliance report has to be given. Now compliance is done. The question of forgery and other things, in fact, the MOU which he is referring to, he himself, the developer himself, has given a letter and has forwarded it on 15/4. That document also is produced in the other case, where he says that I had entered into an MOU after selling the property. He says, I have an MOU, I have not sold the property. It is in this background the allegation is made against the developer. That makes so, the question of now dismissing our appeal does not arise, is our point.
Yes.
The other issues, may not arise in this case. The contours of the dispute have to be seen before.
Yes. Huh?
Anyhow, we made out a very good.
That's near for the score. He is satisfied. Yes.
Obliged, we are very grateful. It is your lordship's call after me. Anyhow, we are happy.
Allah, we have made out a good case that the court should not say, all right, I'll teach you.
Preempting the court.
It is statutory compulsion. General body to be completed before September.
Yes. Status quo cannot be removed.
Now that the special officer is appointed,
Special officer is appointed on the basis of the disqualification order.
No,
Now
it's
he
all right.
disqualifies
Now
all the directors because none of them are present. I appoint the special officer.
fair
Both
enough.
Mullard has
Let
been
the
stated.
special officer go ahead with the special general, whatever annual general body.
Now special officer has not taken charge. That has been stated.
ಅದಕ್ಕೆ ಅದನ್ನ ತಾವು ವೇಕೇಟ್ ಮಾಡಿ ಅಂತಾನೆ ನಾನು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. Anyhow, my lords may, my lords
Let the special officer proceed with the AGM.
Yes.
Let him go ahead. For at
Special
least till
officer
the
is
case
not
is.
required, my lord. There is still time. 1 month is there. Your lordship may decide the matter one way.
Yes.
Yes.
Special officer.
Grateful, my lord, for a detailed hearing.
ಈ ಮಂತ್ ಎಲ್ಲ ಆಗುತ್ತೆ. ತಾರೀಕು ಕೊಟ್ರಿ 10th.
I want to expect
10 September. For dictating orders on 10 September. Interim order is extended till the next day. I got a meeting idea. Kari ನೋಡೋಣ ಏನಾಗುತ್ತೆ. ದೊರೆರಾಜ್.
Serial number 20. Serial number 20, passport number Doreraj BH.
For the petitioner, my lord. Subsequently, the notices were issued by BDA to all the
allottees. And a BDA had passed an order for demolition, whoever is occupied illegally. And photos have also been taken. After that, yesterday, my lord, a letter is also given to us, calling us, inviting us for registration. Because the matter is pending here, they have not registered. This is the development so far.
My lord,
Who appears on the other side, Pawan Chandra Shetty.
So, my lord, what happened is in the previous occasion, my lord, lordship had directed us with regard to the sites, my lord. This is an auction site, my lord. Beside that is Pawan Chandra Shetty's client, my lord. They had all moved one site ಅವರು ಸ್ವಲ್ಪ ಮುಂದೆ ಬಂದ್ಬಿಟ್ಟು ನಮ್ಮ ಆಕ್ಷನ್ ಸೈಟ್ ನ ರೆಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು. ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ ಇವ್ರಿಗೆಲ್ಲರಿಗೂ ನೋಟಿಸ್ ಕೊಟ್ಟು ಸರ್ವೆ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರವ್ರ ಪ್ಲೇಸ್ ನ ಇದ್ ಮಾಡಿ ಅಂತ ನಾವು ಈಗ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಅಂಡ್ ಆ ಬೌಂಡ್ರೀಸ್ ಕಲ್ಲು ಎಲ್ಲ ಕೂರಿಸಿದೀವಿ. ಆಮೇಲೆ ನಮ್ಮ ಆಕ್ಷನ್ ಸೈಟ್ ಅಲ್ಲಿ ಯಾರು ಇದು ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ರು ಅದನ್ನು ಡೆಮಾಲಿಷ್ ಮಾಡಿ ಫೆನ್ಸ್ ಮಾಡಿದೀವಿ. If lordship permits, my lord, we'll register that auction site also in favor of the auction purchaser, my lord.
Yes, you are opposing.
Your lordship, let me mention, there are 3 other matters connected to the same issue, your lordship. They were heard by your lordship. They are listed for 15. And there are 3 other matters which are.
When is it listed?
15/9, further it is listed, your lordship. 22920 up to
15/9. 15 September.
Yes, your lordship. All the 3 numbers are there, your lordship.
New Year.
One of those actually, one of the affected parties of the.
No, but your site is also identified now.
Yes.
Everyone has been identified, my lord. ಅವರೆಲ್ಲರೂ push ಮಾಡಿ ನಮ್ಗೆ ಸೇಲು ಮಾಡಂಗಿಲ್ಲ.
Pawan Chandra Shetty client compound ಹಾಕಿದ್ರಾ?
Yes, my lord.
ಇದ್ರ ಮೇಲೆ ಕಾಂಪೌಂಡ್ ರಿಮೋಟ್ ನೋ.
Yes, my lord, it is removed. Memo may be taken.
Don't jump, mister. We are trying to sort out. So all the allottees have been satisfied.
ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್ ಮೇನ್ ನಮ್ಗೆ ಇಶ್ಯೂ.
Auction purchaser ಆಯ್ತು. People have moved.
Yes, my lord.
You must have identified all their sites because it is you who has
Yes, my
allotted.
lord, we
the
have
sites.
identified, my lord.
So if all of them are satisfied with the measurement of their sites, I think all these petitions can be disposed of together.
ಹೌದು. ಅವರು let them say what they have to say, my lord. Pawan's client, we don't know. Till now they have not submitted anything to.
Yeah, Pawan Chandra ಅವ್ರದನ್ನು ಅವ್ರ client ಅದನ್ನು identify ಮಾಡಿದೀರಾ?
ಎಲ್ಲರೂ we have identified and we have issued the ಈ ಕಲ್ಲು ಹಾಕಿ ಕೂರಿಸಿ ನೀವು ಇಲ್ಲಿರ್ಬೇಕು ಅಂತ ನಾನು ಅದನ್ನ.
No, we'll list these matters on 3rd.
Yes, ma'am.
Let the other matters also come on 3rd.
Yes, ma'am.
15th ಯಾವ್ದು ಇದೆಯಲ್ಲ?
3 matters are there, your lordship.
My lord, when these matters were the other matters that my lord friend is mentioning, we appeared and made a submissions to be connected. 2 days back also one matter was listed. Your lordship said my submissions should stop. Let that matter be connected. It was posted to today. Unfortunately, the dates are gone.
I have to give the numbers. We'll list it on Thursday.
My lord, tomorrow.
I have 3 numbers. I have all the 3 numbers.
Kindly, my lord, tomorrow.
Numbers ಕೊಡಿ.
Because they are ready
My lord,
to.
ಈಗ ಏನಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಇವರು ಒಬ್ಬೊಬ್ರೆ ಬಂದು ಹೇಳಿ ಈ ಆಕ್ಷನ್ ಪರ್ಚೇಸ್ ನ ಸ್ಟಾಪ್ ಮಾಡ್ಬೇಕು ಅಂತ.
Therefore, we'll hear all the cases together and dispose it off.
Yes, my lord.
ಕೊಡಿ numbers ಎಲ್ಲ ಕೊಡಿ. List on 3rd.
So for the development.
Numbers ಕೊಡಿ. 15th ಇದೆಯಂತೆ. ಅದು 3rd ಗೆ ತರಸಕ್ಕೆ.
So for the development, what has happened and the notices which are issued can be taken on record.
For what purpose? Not necessary. The media makes a statement that they have identified the property which is sold to you and the properties which are allotted to the other allottees. And that's the end of the problem.
The record, if I may make submission, my lord, what has been going on from the outset, we observe there has been a force which acts here that allotment ಹೇಗ್ ಮಾಡಿಸ್ಕೊಂತಾರೆ ಅಂದ್ರೆ ಒಂದು ಕಾರ್ನರ್ ಸೈಟ್ ಇಲ್ಲಿದೆ ಅಂದ್ರೆ ಅದ್ರ ಹಿಂದೆಗಡೆ ಅಲಾಟ್ಮೆಂಟ್ಗಳು ಆಗೋದು. ಈ ಕಾರ್ನರ್ ಸೈಟ್ ಇವೆಂಚುಯಲಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಬಿಟ್ಟು ಆ ಕಾರ್ನರ್ ಸೈಟ್ ಯಾರಿಗೂ ಅಲಾಟ್ ಆಗಬಾರ್ದು. ದೇರ್ ಆರ್ 5 matters in which similar sequences has been done and allotment ಮಾಡಿಸ್ಕೊಂಡು ಆ ಕೋರ್ಟ್ ಬಂದ್ಬಿಟ್ಟು ಸೈಟ್ ನ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳೋದು. In the same matter, Pawan Chandra Shetty's client has come before this court. Before this matter was being taken up, ಅವ್ರಿಗೂ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೇಸ್ ಹಾಕೋದು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳೋದು, ಕೇಸ್ ಹಾಕೋದು, ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡೋದು. However, only for the auctioneer, the entire team, gangs up, ರಿಜಿಸ್ಟರ್ ಮಾತ್ರ ಮಾಡಬಾರ್ದು.
Your client is here.
I am sorry to.
I thought
that
your client is here.
Yes,
I just asked you. Good.
Obliged.
My lord, in the meanwhile, we may be permitted to place on record our order ಆದ್ಮೇಲೆ ನಾವು ಏನ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದೀವಿ ಅಂತ ಅಲ್ಲಿ ಪ್ಲೇಸ್ ಆನ್ ರೆಕಾರ್ಡ್ ಬಿಫೋರ್.
Third September.
Yes,
So all other cases, some other day.
yes.
Lord, I mean, pass on memo to club all the matters.
Yeah?
Memo if required, because submission
No, he has
ಮಾಡಿದ್ಮೇಲೆ
given all the
ಕೊಟ್ಟಿಲ್ಲ.
numbers. We'll list it on 3rd.
Obliged.
That's one small submission. One small submission. Serial number 23, my lords. There's one more connected matter to the same fact.
So give the number to.
Please.
Number 23 also pass ಆಗಿದೆ. So ಇವಾಗ ಕೊಡಿ ಇವ್ರೆ ಎಲ್ಲ ನಂಬರ್ ಕೊಡಿ. ಲಿಸ್ಟ್ ಎಲ್ಲ ಹೋಯ್ತು. ಥರ್ಡ್ ಇದಾ ಫಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್ ಹಾಕಿ. ಇಲ್ಲೇ KDB ಇದು. ಹಾ. ಇದು ನಂಬರ್ 23. ಅಷ್ಟೇ ಲಿಸ್ಟ್ ಎಲ್ಲ ಹೋಯ್ತು ಫಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್. ಅದೇ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಹಾ. ಫಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್. ಇಲ್ಲೇ ನೋಡ್ಕೊಂಡು ಹೋಗ್ಬಿಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 48.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಯಾವಾಗ ಅರ್ಜನ್ ಆಗಿದೆ?
ಇದು ಮೇಡಮ್ ಇದು ಬಿಡದಿ ಇಲ್ಲ ಮೇಡಮ್ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಪೂಜೆ ಇದೆ, ನೋಡ್ತೀನಿ. ಡೌಟು ತಗೊಳ್ಳಿ. ಈಗ ಇಟ್ಕೊಂಡು ಮೇಡಮ್ ನೀವ್ ಇಟ್ಕೊಂಡ್ರೆ ನಮ್ಗೆ ಅಲ್ಲಿರುತ್ತೆ ಅಂತ. ನಮ್ಗೆ ಮೆಮೊರಿ ಪವರ್ ಆದಷ್ಟು ಕಡಿಮೆ ಆಗ್ತದೆ.